tomorrow. Thursday. Special court matter ಯಾವುದು Thursday ಕೊಡಿ. Yes sir. No, that's all right. What do you want now? Oh, it's all right. Give it. All right. Give it. Give the memo, sir. Give the memo. Today afternoon not possible. Tomorrow we'll post it. Correct. So what? Yes. Kodi. Yes. 27th. Fresh or pending, sir? Fresh or pending? Give it. No dates on pending matters. Give it. You are the respondent. There's an interim order in your favor. And then what do you want, sir? Oh, other 2:30 ಗೆ ಹಾಕಿ madam. We'll close it. B report format close ಮಾಡಿ 2:30 ಗೆ. ಪರವಾಗಿಲ್ಲ ಸರ್, ಸೀನಿಯಾರಿಟಿ ಮೇಲೆ ಹೋಗೋದು ಕೊಡಿ ಸರ್. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಏನ್ ಬ್ಯಾಂಕ್ ಅಫಿಷಿಯಲ್ಸಾ? ಏನ್ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಬಾರೋವರ್ಸ್ಗೆ ಎಷ್ಟು ಕಾಟ ಕೊಡ್ತೀರಾ? ಹಾ, ಬಾರೋವರ್ಸ್ಗೆ ಅಷ್ಟೊಂದು ಕಾಟ ಕೊಡ್ತೀರಾ? ಸ್ವಲ್ಪ ಇರ್ಲಿ ಬಿಡಿ. ಯಾಕೆ ವೈಟ್ ಲೈಟ್ ಫುಲ್ ಹಾಕಿಲ್ವಾ? Who's that? ಹಾ, ಕೊಡಿ. ಮೆಮೊ ಕೊಡೋದು ಕೊಡಿ. ಕೊಡಿ. ಹಾ, ಇದು ಎರಡು ಸೇರಿ 2ನೇ ತಾರೀಕು ಲಿಸ್ಟ್ ಮಾಡೋಣ. ಕೊಡಿ. ಮತ್ತೆ ಸುಮ್ಮನೆ ಏನ್ ಮೆಮೊ ಈಗ? ಏನ್ ಪರವಾಗಿಲ್ಲ, ಅವತ್ತು ಕೊಡಿ. ಎಸ್, ಅವತ್ತು ಕೊಡಿ. ಎಸ್. ಎಸ್, ವಾಟ್ ಯು ವಾಂಟ್? ಕೊಡಿ 2:30. 2:30. ಹಾ, 2:30. ಎಸ್. Who commits suicide? Why? ಯಾವ್ದರದ್ದು ಇದು? ಇವತ್ತಿದೆ. (108) of BNS. We'll take it along with those matters. ಕೊಡಿ. ಕೊಟ್ಟಿರಿ 2:30 ಅಂತ ಹಾಕೊಂಡ್ರಿ. ಯಾಕೆ ಶ್ರೀನಿವಾಸ್? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿರ್ಲಿಲ್ವಾ? ಆಯ್ತು ಕೊಡಿ. ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ನಾಳೆ, tomorrow. Wait, I'll come back. Wait, Nazir. 2022 na I'll move ಮಾಡಿ ಮೇಡಮ್. ಸೊ ಅದು ಇಲ್ಲಿ ಬರ್ಬೇಕು ಅಂತಿಲ್ಲ. 22 ನನಗಿಲ್ಲ. 22 ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ಅಲ್ಲಿಂದ ಬರ್ಲಿ ಬೇಕಾರೆ ಮೇಡಮ್. 2022 ನನಗಿಲ್ಲ ಮೇಡಮ್. ನೀವು ಆ ಕೋರ್ಟ್ ಮೂವ್ ಮಾಡಿ ಇಲ್ಲಿ ಬಂದ್ರೆ ಓಕೆ. If it is 22, it will go there. Yes, ಕೊಡಿ. 2:30. Yes, ಮೇಡಮ್. ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಯಾವ ವಿಡ್ರಾ ಮಾಡಿರಿ? ಒನ್ ಮಿನಿಟ್. ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಯಾವ್ದು ವಿಡ್ರಾ ಆಗಿರುತ್ತೆ 2:30 ಹಾಕಿ. ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ತಗೊಳ್ಳಿ, 2:30 ಹಾಕಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಬಂದಿಲ್ವಾ ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ 2:30 ಹಾಕಿ ಅದು ಕೊಡಿ ವಿಡ್ರಾವಲ್ ಅಂತ ಹಾಕಿ ಮೇಡಮ್ ಸರಿ ಏನ್ ಬೇಕು ಆಗಿದೆಯಾ ಹೌದು ಸರಿ ನಾಳೆಗೆ ಹಾಕಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಸ್ ಶಂಕರ್ ನಾಳೆ ಹಾಕ್ತೀನಿ ತಾಳಿ ನಾಳೆ ಒಂದ್ ನಿಮಿಷ ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರೆ ನಾನು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಮ್ಯಾಮ್ ಎಸ್ ಕೊಡಿ ಎಸ್
because of this party is giving the suggestions to the other
ಪ್ರವೀಣ್ ಗೌಡ್ರ ನಾಳೆ ಬರ್ಲಿ ಅದು ನಾಳೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್ ವೈ ಆಯ್ತು 2:30 ಎಷ್ಟಾಯ್ತು ಮೇಡಮ್ 2:30 8 ಟ್ರಯಲ್ ಸ್ಟಾರ್ಟ್ ಆದ್ರ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಎಸ್ ಕೊಡಿ ಎಸ್ ಕೊಡಿ ಸರ್ ಗಿವ್ ದ ಮೆಮೋ ಎಸ್ ಸೊ ವೈ 2:30 ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಕೊಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಬರ್ಕೊಡಿ 2:30 ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಬರ್ಕೊಡಿ ಕೀಪ್ ದ ಪಾರ್ಟೀಸ್ ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲಿ ಬರಲ್ಲ ಸರ್ 107 ಎಸ್ ನಾಟ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಪಿಟಿಷನ್ ಇಸ್ ನಾಟ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಮನಿ ಹಸ್ ಬಿನ್ ಸೀಸ್ ಆಲ್ ರೈಟ್ ಗಿವ್ ಇಟ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಈಗಲೇ ಮಾಡ್ಬೇಡ ಹಾ ಗಿವ್ ಇಟ್ ಎಸ್ maybe sir for what purpose sir no for what purpose it is coming before the magistrate what were you doing till now when did you file the petition somewhere 2-3 months ago charge frame agiradi post agiradi yavaga so for last 2-3 years what were you doing agle charge frame agta idea kodi why you can't understand English? Am I not taking everybody's memo? Where's the hurry? Yes, give that 2:30. Yes. Sorry. It will come next Monday. Yes. A special court matter Thursday. Huh? So what? All right, give it. Yes. Those are all not head-going things. Give it, yes. Sir, if it is transfer petition, it won't come here. There's another designated court for it. Please move it there. Yes. Why? What mentioned? Have you mentioned it in the prayer? In prayer litta adu? Kodi ನೋಡಿ beings pakad ನಾಳೆ 2:30. Yes. Give it. No, give it, yes. Yes, next. What is that? Parvaila. No date, sir. Give it, yes. Pending matter, no date, sir. It will come, yes. Can't you keep quiet? Am I not coming back? What is fresh matter? Charge sheet, charge sheet sign ಮಾಡಿದಿರ ವಿಡ್ರಾ ಮಾಡ್ಬೇಕಾ 2:30 ಗೆ ಏನಾಗ್ಬೇಕೀಗ ಫ್ರೆಶ್ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಕೊಡಿ ಗಿವ್ ಇಟ್ ಸಾಕು ಫ್ರೆಶ್ We'll see, give it, yes. Give it, sir. Fresh pending, sir. Give it. Fresh matter ಕೊಡಿ. ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬರುತ್ತೆ ಕೊಡಿ. ನೀವು 10 ಸರಿ ಮೆಮೊ ಮಾಡಿದ್ರೆ ಏನಾಗಲ್ಲ ಸರ್, ಏನ್ ಹೇಳಿ ವಿಷಯ ಹೇಳಿ. ಬರುತ್ತೆ ಕೊಡಿ. ಟುಮಾರೋ ವೈ ಏನು ಅಫೆನ್ಸ್ ಏನು ಕೊಡಿ. ಎಸ್, ಟ್ರಯಲ್ ಎಸ್ಕೇಪ್ ಆಗಿರೋರಿಗೆ ಇಂಟೆಲಿಜೆನ್ಸ್ ಜಾಸ್ತಿ. ಅದನ್ನ ಪೋಸ್ಟ್ ಇನ್ January 2025. ಯು ಹ್ಯಾವ್ ಎಸ್ಕೇಪ್ ಟ್ರಯಲ್ ಸರ್, ದಟ್ಸ್ ವೈ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಚಾರ್ಜ್ ಆಗಿರೋದು. ಡೋಂಟ್, ಬಿಕಾಸ್ ಐ ಆಮ್ ಲಿಬರಲ್ ಇನ್ ದಟ್, ಡೋಂಟ್ ಥಿಂಕ್ ದಟ್ ಬಂದಿಲ್ಲ, ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ಅವೆಲ್ಲ ಇಲ್ಲ. ಇಫ್ ಐ ಸ್ಟಾರ್ಟ್ ಪಾಸಿಂಗ್ ಆರ್ಡರ್ ಸೇಯಿಂಗ್ ಫೇಸ್ ಟ್ರಯಲ್, ನಥಿಂಗ್ ಇಸ್ ದೇರ್, ಅದಕ್ಕೂ ಇದೆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಮತ್ತೆ ಕೊಡಿ, ಅದು ಪೋಸ್ಟ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ, ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ. ಎಸ್. ವಿಚ್ ಇಯರ್? ವಿಚ್ ಇಯರ್? ಗಿವ್ ಇಟ್. ಎಸ್. ಯಾವ್ದದು ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ ಸರ್? ಯಾವ್ದು ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್? 376. You have given the memo? No problem. Have you given the memo now? Give it, yes. It will come, yes. Settlement ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ಯಾವಾಗ ಬೇಕು? Tomorrow, yes, settlement. Give it off, yes. Give it, fresh matter ಕೊಡಿ. ಪೆಂಡಿಂಗ್ matter, ಪೆಂಡಿಂಗು ಫ್ರೆಶ್ ಎರಡು ಕೊಡಿ. ಅಂದ್ರೆ ಪೆಂಡಿಂಗ್ ಅದು ಕೊಡಿ, ಅದು ಪೆಂಡಿಂಗ್ಗೆ ಕೊಡಿ. ಕೊಡಿ ಸರ್, ಪರವಾಗಿಲ್ಲ. ಡೇಟ್ ಇಲ್ಲ ಸರ್, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್. ಐ ವೋಂಟ್ ಗಿವ್, even if you ask, I won't give. Please give. Yes. ನಿಮ್ದೆಲ್ಲ 2:30 ಏನ್ ಸಮಾಚಾರ? ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಈಗ ಯಾರೋ ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ, that should go in for different to a different court. You have the respondent. ಯಾವಾಗ ಆಗಿದ್ದು ಆರ್ಡರ್? ಆಯ್ತು ಕೊಡಿ. ಎಸ್, ಎಸ್, ಕಾಲ್ ದಿ ಕೇಸಸ್ ಮಾಡಿ. ತಗೊಳ್ಳಿ. So NBW should not be issued against a senior citizen. Immunity, is it? Wait, sir. Yes.
Fresh matter, still number 1.
Eli Prasanna Kumar. All 6 matters, same order. Pass over. Odd pass over. Same orders, pass matter kodi. ಏನ್ ಮಾಡಕ್ಕ, ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಇದರಲ್ಲಿ ಸೇಮ್ ಅಕ್ಯೂಸ್ಡ್. Is a public servant, is it? What's the fine imposed? ಯಾಕೆ? ನೋ ಪಾಸ್ ಓವರ್ಸ್. ಎಸ್, ಸೇಮ್ ಆರ್ಡರ್. ಫೈನ್ ವಿಷಯವಾಗಿ ಕಾವ್ಯ ಬೇರೆದ್ರೆಲ್ಲ ಮಾಡಿದೆ. ಯಾರಿದ್ರು ಅವತ್ತು ಕೇಳ್ಕೊಳ್ಳಿ. This is not adjournment. Cases are called. Wait till the matter is called. What sort of thing is this? All fresh matters. All fresh matters. I'm adjourning all fresh matters. Seriously? Yes. Yes, madam. No pass over. Yes. Same order with regard to fine 25%. This is ಇದೆಲ್ಲ all 6 are public servants. Same petitioner. Yes, sir. ಅದು A1. It's all right. I'm talking of fine. Criminal appeal admission and grant sentence suspending is a matter of right. It is only with regard to the fine that have imposed in other cases. 40 ಕೋಟಿ ಎಲ್ಲಿಂದ ತರ್ತಾರೆ ಮೇಡಮ್? ಅಲ್ಲ 40 crores. That is why court should have ordered correctly. What is the fine to whom and what? You can't impose sweeping fine on everybody. Yes. There's ಸ್ವಲ್ಪ ಆದ್ರೂ ಫೈನ್ ಬೇಕು. ನಾಮಿನಲ್ ಅಂದ್ರೆ 25 ಲಕ್ಷ. Yes. Bribe is 2,500. With impose 5 lakhs. Yes.
Each case like this.
ಆರು ಕೇಸ್ ಇದಲ್ವಾ? Each case then ಇಲ್ಲ ಬೇಡ. Each case 10 lakhs in all 6 cases put together. Tag all these. Same order that I have passed in other cases ಕೊಡಿ ಅದು. With 10 lakhs fine. Deposit of 10 lakhs fine. Yes. Same order. An office objection? Accepting submission, office objections overruled. Amala. Next.
7.
78-4. Permission ilva? Heard the counsel for the petitioner is before this court calling in question registration of proceedings in CC so and so registered for offence punishable under section 78-4 of the nodi 78 bracket ಅಲ್ಲಿ 4 of the Karnataka Police Act. The primary contention of the learned heard so and so. The primary contention of the learned counsel appearing for the petitioner is that on an uncognizable offence, the permission of the learned magistrate is taken after the commencement of investigation. Therefore, would submit that the entire procedure, therefore would submit that the registration of the crime and its aftermath are all illegal. The issue in the list need not detain this court for long or delve deep into the matter. As the coordinate bench in the case of Vagepa so and so, ILR 2020 Karnataka page 630 has held as follows. The learned HCGP on verification of the records would admit the fact that the crime is registered after the permission from the magistrate is sought after the registration of the crime and commencement of the investigation. Therefore, the petition deserves to succeed. So and so allowed cost. Next.
8.
Indira Nagar chit is granted in other cases. Tag swords. Next. It will be.
9.
ಈಗ ಹೇಳಿ ಮೇಡಮ್. Yes. Defreezement. Let me see, let the HCGP secure instructions. Learned HCGP is directed to secure instructions with regard to the subsistence of the crime after permitting defreezement of the account by the investigating officer himself. The learned counsel for the petitioner submits nothing survives in the petition as the offence are not made out even. Therefore, list the matter on Friday in the fresh matters list. Yes, next.
10.
The evidence has commenced, your lordship, evidence stage it is.
the petitioner number one, the petitioners, 4 in number, are 1 to 4. Alla? Petitioners accused number 1 to 4 are knocking at the doors of this court, calling in question proceedings in so and so. Insofar as the petition number 1 and 2 are concerned, they are the lessee and the room boy of the lodge in which the alleged acts of prostitution were taking place, and therefore have become an offense under the provisions of the Immoral Traffic Prevention Act, so and so. Insofar as the petitioners 3 and 4, accused 3 and 4 are concerned, accused number 3 is the customer against whom the proceedings cannot be permitted to continue in the light of plethora of judgments rendered by this court and the coordinate benches of this court. And the petitioner number 4 is the owner of the property who has leased it out to the lessee and is not aware of what is happening in the lodge. Therefore, the proceedings against accused number 3 and 4, if permitted to continue, would become, ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಿ 1 and 2 withdraw ಮಾಡಿದ್ರೆ ಅವೆರಡು ಕಾಸ್ಟ್ ಮಾಡ್ತೀವಿ. Cannot be permitted to continue. At this juncture, the learned counsel for the petitioner submits that he would withdraw the petition insofar as petitioners 1 and 2 are concerned. Therefore, petitioners 1 and 2 shall face trial and come out clean in a full-blown trial. Insofar as petitioners 3 and 4, as observed here in above, 1 is a customer against whom the proceedings cannot be permitted to continue in the light of customer. And the accused number 4 is the owner of the property against whom proceedings cannot be permitted to be continued in the light of the other owner of the property. So, in that light, the criminal petition stands in the light of the aforesaid reasons, the following order. Criminal petition insofar as petitioners 1 and 2, accused 1 and 2 stands dismissed. The criminal petition insofar as petitioners 3 and 4, accused 3 and 4 is allowed. The proceedings accused number 3 and 4 stands quashed.
7.
Dismissed or dismissed as withdrawn. Sorry. Dismissed as withdrawn. Sir. In the meantime, yes. Partner not involved in day-to-day affairs. ಆಯ್ತು ಕೊಟ್ಟಾಯ್ತು.
12.
Discharge rejected in 2022, sir. ಇವಾಗ ಏನ್ ಮಾಡ್ತೀವಿ? ಏನಾಗಿದೆ ಈಗ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿ 2 ವರ್ಷ ಆಗಿರುತ್ತೆ. ಮತ್ತೆ get the stage. Learned HCGP is directed to secure the stage of the proceedings before the concerned court by the next date of hearing, next Tuesday. Fresh matters.
13.
Petitioners are advocate and notary.
Chief, de facto complainant is not made a party here.
Make him a party. Where is the complainant? Complainant yaro? I'll dismiss it right away. It is not even maintainable without the complainant being made a party. Dismissed? ಅದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? ಮಾಡಿ ಈಗಲೇ. List tomorrow in the fresh matters list. Make the complainant a party. Amend it. ಅಯ್ಯೋ ಅದೆಲ್ಲ ಯಾಕೆ ಮೇಡಮ್? ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿ, ವಿಡ್ರಾ ಮಾಡಿ, ಮತ್ತೆ ಯಾಕೆ? ವಾಟ್ ಇಸ್ ದಿಸ್? ಎಸ್, ಈಗಲೇ ಮಾಡಿ. The learned counsel for the petitioner seeks leave of this court to implead the complainant as a party respondent to these proceedings. Permission granted. ಇಲ್ಲೇ ಬರೀರಿ. ಅದಕ್ಕೆ ವಿಡ್ರಾ ಮಾಡಕ್ಕೆ ಯಾಕೆ? Next. Tomorrow, fresh matters.
14.
Stage. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿರ್ಬೇಕು ನೋಡಿ. ನೋಡಿಲ್ವಾ? Where is Jagdish?
Anytime he'll be here.
Not there?
He's on his way.
All right. 380 crime stage ಅಲ್ಲಿ ಇದೆ ಇನ್ನು. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ, ಚೆಕ್ ಮಾಡಿ. No representation, we have the petitioner. List after 2 weeks, 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks. Next.
15.
Lordship, in this matter, A1 and A34 were discharged. That order is challenged.
Petitioner calls in question an order of discharge that is passed on 11, order rejecting discharge that is passed on 11/7/2018. The petition itself is preferred on 27th May 2023, 5 years after the said order. The learned HCGP on instruction should submit that the proceedings are at an advanced stage before the concerned court. In that light, I find no warrant. Idyavud, madam?
Your lordship, serial number.
Oh, sorry,
15.
madam, Mitoli. The petitioner is the state. It calls in question an order dated 11/7/2018 by which the accused have been discharged of the offences. The order of discharge is passed on 11/7/2018 and the state prefers the subject petition on 27/5/2023, close to 5 years after the order of discharge. Merely because it is the state, the delay in filing the petition cannot be condoned, as the order of discharge is order of discharge doesn't warrant, would not warrant any interference, as it is passed on reasons which are cogent and facts which are considered coherent. Therefore, the petition,
The absence of the accused.
ಯಾವ absence 5 ವರ್ಷ ಆದ್ಮೇಲೆ, in the light of the petition being preferred by the state after 5 years and the reasons rendered here and above, the petition deserves to be rejected and is accordingly rejected. Next.
16,
498.
Settlement ಆಗಿದೆಯಾ? In the learned counsel appearing for the petitioner submits that the husband and the wife have settled the dispute amongst themselves, but the wife is not cooperating with the closure of these proceedings. He has appended the petitioner has appended the settlement also to the petition, which is rendered in MC 5445 of 2022. In that light, there shall be an interim order of stay where the petitioner still the disposal of the petition. 1 HCGP 2 emergent notice. Post the matter for in its usual course for admission.
17,
Appeal back actually. Yes. No representation list after 4 weeks. Yes, next.
18,
Oh, yes, sir. What did the bank do, sir?
Fake documents given with.
Fake documents ಕೊಟ್ಟು ಲೋನ್ ತಗೊಂಡಿದ್ದೀರಾ? ಅಲ್ಲ, ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇವ್ರು ಕೊಟ್ಟು ಲೋನ್ ತಗೊಂಡ್ರೆ ಬ್ಯಾಂಕ್ನವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
Owner is
ಫೇಕ್ ಅಂತ
the,
ಗೊತ್ತಿದ್ಯಾ? ಫೇಕ್ ಅಂತ ಗೊತ್ತಿತ್ತಾ? ಡ್ಯೂಯೆಟ್ ಹಾಡ್ಬೇಡಿ, ಒಬ್ರು ಹೇಳಿ. ಹಾ. The petitioner is before this court calling in question registration of the crime against the petitioners for the following for offenses so and so. The complainant is the bank. The bank alleges that the documents submitted for securing a loan were forged.
vendor's documents.
Vendor's documents were forged. The bank appears to have conducted complete due diligence before the release of the loan, as it is the statutory necessity before the release of loan. If the bank officials are not hauled up for conniving with these petitioners, the petitioners cannot be held to be producing forged document for securing a loan in a manner known to law. Therefore, there shall be an interim order of stay of further proceedings. Square these petitioners till the next date of hearing. Next.
19,
In the meantime.
20,
Stayed. ಯಾವ್ದು ಇನ್ನೊಂದು petition ಇದೆಯಲ್ಲ ಕೊಡಿ, ಟ್ಯಾಗ್ along with sounds ಕೊಡಿ. ಇದು wait sir, one matter wait ಮಾಡೋದು ಕಷ್ಟ. You are the accused. When do you pay, sir? 2,70,000. Where? Where do I get that? When did you deposit? After the 421 proceedings? The learned counsel for the petitioner submits that during the pendency of the proceedings instituted by the complainant under section 421 of the CRPC, the entire amount has been deposited. If in recording the said statement, there shall be an interim order of stay as spread for emergent notice to the respondent. Amount of 2,70,000. Yes. All right.
21,
Same tag with 19, same order.
22,
20B 341,
Yaar is 21? Manuswami Gowda.
22. Withdrawal.
Withdrawal. 22 withdrawal. Yes, in terms of.
23,
Petitioner calls in question summons issued on 11/9/2019 by filing a petition on 26/10/2023. The learned HCGP is directed to accept notice, secure the instructions with regard to the stage of the proceedings list. Next, Wednesday in the fresh matters list. Yes, next. 5 ವರ್ಷ ಆದ್ಮೇಲೆ summons challenge ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ? Yes.
24,
Evidence comments ಆಗಿದೆ sir. You are the husband. Correct. ನಿಮ್ನ 494 ಅಲ್ಲಿ ಟ್ರೈ ಮಾಡಬಾರ್ದು ಅಂದ್ರೆ ಇನ್ಯಾರನ್ನ ಮಾಡ್ಬೇಕು ಹೇಳಿ? If husband should not be tried for bigamy, can a stranger be tried? No, that's a matter of trials. No problems. ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. There is an allegation of bigamy. There are several proceedings between all of you. That is there, sir. I am not going to interfere with this. Arey, sir, that is a matter of evidence. How can I look into all that here? No, no, sir. That is a matter of ಈಗ evidence start ಆಗಿದೆ ತಾನೆ. Which one? This one? That's a matter of trials. Immaterial. I will not look into it here. No, sir. That's a matter of evidence, sir. No, sir. If husband cannot be called for bigamy, who else? Nothing else. No, that's alli, sir. Evidence illalla. There. Discharge reject ಆಗಿದೆಯಾ? ಹಾಕಿ. Yes. File discharge. No, sir. File discharge. Anyway, ಮತ್ತೆ ಬರುತ್ತೆ ನೋಡೋಣ ಅವಾಗ. Produce all the discharge. Yes. Next.
25,
In the meantime, next.
26,
ನಿಮ್ ಸ್ಟೇ ಆಯ್ತು ಸರ್. ಅಲೋ ಮಾಡ್ಬೇಕಾ? ನಿಮ್ದು ಅಲೋ ಮಾಡೋದಿಲ್ಲ ತಾನೇ ಈಗಲೇ?
Evidence dates are given.
Summons issued on 21/6/2019, close to 6 years ago. What's the stage?
Evidence on 5/2/25.
Huh?
Evidence on 5/2/25.
Charge ಯಾವತ್ತು ಫ್ರೇಮ್ ಆಗಿದೆ? Maybe, madam. What to do? ಅರೆ ಸರಿ, 5 ವರ್ಷ why were you quiet? You can't sit quiet for 5 years and then come here. 1 HCGP, 2 emergent notice. The returnable by 18th of December. 5/2 is the next date. Don't. Next.
27,
Notice. Page 59, sir. That is not, there's not license for all this, sir. Assault to 354. Civil dispute idre you can do anything.
complaint hearing is the elder son, elder daughter of the
ಸಿ ನೀವು ಹೇಳೋದೆಲ್ಲ 406, 420, 465 ಇದಕ್ಕೆ ಅಪ್ಲಿಕಬಲ್ ಆಗುತ್ತೆ. 354, 324 ಅಲ್ಲ. ಸೊ 1 HCGP, 2 emergent notice. No sir, nothing.
28,
Just after 4 weeks, no representation, not the list, yes.
29,
2 and 3, 498A, yes, next. 2621 Kavya, yes, next.
30,
Who's that? Yes. The petitioners are before this court calling in question registration of a crime in crime number 87 of 2022 and the aftermath, i.e. CC 23694 of 2023. A perusal at the complaint would indicate that the incidents that have taken place between 2017 to 2021 are complained of on 26/5/2022. And the private complaint itself itself runs foul of the judgment of the apex court in the case of Babu Venkatesh versus State of Karnataka, 2022 SCC online SC page 200, in as much as it does not append to itself an affidavit nor evidence with regard to compliance with subsection 1 and 3 of section 154 of the CRPC. Therefore, there shall be an interim order of stay. 1 HCGP, 2 emergent notice.
31,
In the meantime, bank loan. Filed. Even otherwise matter to be stayed. Be report format will close madada. Will give you liberty to approach the court in case of need. Deep freeze madidara. Yes, comment.
Have to seek instruction from freezing you will have to file an application.
451 application, I have direct the court to consider. Where is it? When was it rejected? After the B report, before the B report? Before the B report, obviously it will be rejected. Learned HCGP is directed to accept notice for the first respondent. Copy ಕೊಟ್ಬಿಡಿ. Copy ಇದೆಯಾ?
ಇಲ್ಲ ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ವಾ? Copy ಕೊಡಿ, ನಾಳೆ ತಗೋತೀನಿ. ನಾಳೆ will dispose it. List tomorrow in the fresh matters list. Yes.
32,
Civil dispute license ಅಲ್ಲ ಸರ್ ಎಲ್ಲದಕ್ಕೂ. Page 36 ನೋಡಿ. ಎಲ್ಲದಕ್ಕೂ civil dispute ಅಂದ್ರೆ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಅದಕ್ಕೆ ಹೊಡೆದಾಡ್ಬೇಕು ಅಂತಿಲ್ಲ. See, one HCGP, 2 emergent notice, returnable by 18th December. ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಷ್ಟ್ರಲ್ಲಿ ಏನಾಗಲ್ಲ ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನು? 10/12. 10/12, returnable by 10/12. Yes, next.
33,
Serve, madam. Serve on the counsel who represents the respondent. What stay, madam? Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service in the next 2 days. List the matter on Wednesday. Next date yavat madam ali? Dismiss alla. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ? ನೋಟಿಸ್ ಆಗಿತ್ತಾ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್? ಮತ್ ಸ್ಟೇ ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Madam, you are the complainant. Complaint is rejected. What stay are you seeking now? All right. No, that's all right, but what stay are you seeking now? ನೋಟಿಸ್ ಆಗ್ಬೇಕಷ್ಟೇ ಮಾಡಿ. ಅದಕ್ಕೆ serve on the counsel who represented the respondent in the trial proceedings, list the matter on next Wednesday in the fresh matters list.
24,
2, 3 and 4. The petitioners are 2, 3 and 4. One illa. One kodalla. Yes. The petitioners are accused 1, 2, respondents 1, 2 and 1, 2, 3 and 4 before the court, in which the before the court, the proceedings are the one initiated by the wife, the respondent, invoking section 12 of the Domestic Violence Act, so and so 2005, finding no ingredient of such violence, such domestic violence. Respondents 2, 3 and 4, the proceedings against the said respondent shall remain stayed before the concerned court. Next.
35,
Learned HCGP is directed to accept notice for the first respondent, for the respondents in the meantime. Yes. Drugs and cosmetics. They're all covered, sir. List the matter on 17 December. We'll close it.
36,
Eighteen 11/22 letter ಎಲ್ಲಿದೆ? Everything is settled. Yes, madam. The complainant communicates to the police regard to withdrawal of the complaint so registered on account of a settlement between the parties. The communication reads as follows. Page 85. In that light, there shall be an interim order of stay. Yes, next.
37,
Same Vishwas, ಕೊಡಿ order, tag, same order.
38,
settlement.
Husband, settle ಆಗಿದೆಯಾ? Settled, is it?
Yes, yes,
All the matters. Parties are present?
yes, yes.
Where is the settlement?
Settlement memo is.
Oh, joint memo. Mediation ಎಲ್ಲಿದೆ? Like mediation agreement. EU. Huh? E, page. ಇಲ್ಲೇ ಇದೆ. Page 82. One minute. Flag ಹಾಕಿದ್ದೀನಿ. ಈ paragraphs ಮಾತ್ರ ಸಾಕು. Yes. Next.
order sheet signatures. 39,
Is okay for petitioner by law.
In the main, 427, 447. ಅದಿದ್ದೇ ಇರುತ್ತೆ ಬಿಡಿ. In the meantime, next.
40,
Dates, sir.
40,
354, sir. ಎಲ್ಲಿದೆ? Kindly come to page 20. ಆಮೇಲೆ 164 statement ಕೊಡ. ಏನು ಆಗೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿ? 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಎಲ್ಲಿದೆ? ಪೇಜ್. ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ? ನೀವ್ಯಾರು? ಶೋಧನ್ನ.
A2, your.
A2 ಮೇಲೆ ಏನಿದೆ ಮೇಡಮ್?
Either your lordship, page 20, I am reading. your
ಅಲ್ಲ
lordship.
20 ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ಟೇಟ್ಮೆಂಟ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್
64 ಅಲ್ಲಿ ಇಲ್ಲ, but based on his instigation only.
ಇನ್ಸ್ಟಿಗೇಷನ್ ಇಸ್ ಆಲ್ ರೈಟ್. ಬಿದ್ದಿರುತ್ತೇನೆ ನನ್ನ ಬಾಯಲ್ಲಿ ಇದ್ದ ಬಟ್ಟೆಯನ್ನು ತೆಗೆದು ಜೋರಾಗಿ ಕಿರುಚಿನ ಸೌಂಡ್ಸ್. ಇವ್ರ ಮೇಲೆ ಏನಿಲ್ವಲ್ಲ ಮೇಡಮ್. ದಿ ಪೆಟಿಷನರ್ ಇಸ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2. A perusal at the summary of the charge sheet would depict allegations against accused number 1 in its entirety. Even the 164 statement which is appended to the petition points at the allegations against accused number 1 and none against the accused number 2, the present petitioner. In that light, there shall be an interim order of stay.
Forty-one.
In the meantime, yes, next.
42.
341 ಮಾತ್ರ ಸ್ಟೇ ಮಾಡ್ತೀವಿ. ಇಲ್ಲದೆ ನೋಟಿಸ್ ಮಾಡಿ. ನೋಟಿಸ್ ಮಾಡಿ. ಇನ್ನು ಉಳಿದಿರೋದು 504, 506, 323 ಅದು ಇರಲಿ. ಆಲ್ ರೈಟ್ ಸರ್. ಅದಕ್ಕೆ 341 ಸ್ಟೇ ಮಾಡ್ತೀವಿ. The perusal at the summary of the charge sheet would not indicate the necessary ingredients as obtaining under section 339 of the IPC to be met for an offence under section 341. Therefore, there shall be an interim order of stay of further proceedings before the concerned court qua offence under section 341 of the IPC. Insofar as the remainder of the offences, the same would be remainder of the offences interdicting them would be considered after the appearance of the respondent. 1 HCGP 2 emergent notice. Next.
43.
A22 A7 498A. Yes, next.
44.
A1 illala, husband ilva. Husband illa. Insofar as the husband is concerned, the proceeding shall continue. Yes, next. Page 37, sir. 307, sir. Yes. Note 1 HCGP 2 emergent notice. Next to A2, A3, A4, 498A. Idharallu husband idara? Either no husband, only 2621. Yes, next.
46.
Page 22. Page 22. You are accused number? Yes, sir. ಆಮೇಲೆ ಪರವಾಗಿಲ್ಲ. Anything else? Get the complaint. 1 HCGP 2 emergent notice. Yes. Why? Charge sheet ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ವಾ? ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ ಪಾರ್ಟಿ? He has been transposed as complainant. What are you talking, sir? Srinivas Murthy yaru? Who is the de facto complainant?
ಪ್ರಾಣಾಧಿಕಾರಿ.
Huh?
ಶ್ರೀನಿವಾಸ್ ಮೂರ್ತಿ ಅವರಿಗೆ.
De facto complainant. A6 ಅಂತ ಎಲ್ಲಿದೆ? Where is it? I am there only. A3 to A6 are absconding. Is on anticipatory bail. Accused number 2 is dead. A3 to A6 are absconding. That may be a mistake. Anyway, 1 HCGP 2 emergent notice. Yes. No, not a case for stay. You have filed discharge. File discharge. ಅಷ್ಟೇ. No problem, notice, yes. No problem, notice, yes.
47.
A1 is the husband, your lord.
ಒಂದೇ ಕಾಮನ್ ಆರ್ಡರ್ ಅಷ್ಟೇ, ಬೇರೆ ಬೇರೆ. ಆರು ಕನೆಕ್ಟ್ ಮಾಡಿ ಒಂದೇ ಆರ್ಡರ್. ಬಿಕಾಸ್ ಒಂದೇ ಪೆಟಿಷನರ್, ಸೇಮ್ ಕಾಮನ್ ಪೆಟಿಷನ್. ಸ್ಟೇಜ್ ಏನು ಮೇಡಮ್? 2015 CC. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿ ಎವಿಡೆನ್ಸ್ ಯಾವಾಗ ಕಮೆಂಟ್ಸ್ ಆಗುತ್ತೆ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ತಾನೆ. ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ? ಕೊಡಿ ಹಾಗಾದ್ರೆ. The counsel for the petitioner submits that the husband and the wife have settled the dispute before the family court in MC so and so. In that light, there shall be an interim order of stay. All right. In that light, there shall be an interim order of stay of further proceedings before the concerned court. 1 HCGP, 2 emergent notice. Next.
48.
Husband gilla, all others. All others stay. No husband. Not made husband, huh? Very good. Smart. Yes. Number put. Tag this petition along with so and so. There shall be an interim order of stay of further proceedings with these petitioners till the next date of hearing. Emergent notice to the respondent. Next. This is 78(4) KP Act.
Please. Covered by your lordships.
Today, page. Page.
Page 26.
Page 26.
Document number.
Covered ಯಾವ್ದು ಸರ್? ಯಾವ್ದು ಒಂದು ಕೊಡಿ. 3 and 2. Page number ಹೇಳಿ ಸರ್.
Page 26. Page 26 document.
ನಿಮ್ದ್ರಲ್ಲಿ ಇಲ್ಲಿ ತಪ್ಪಿರುತ್ತೆ ಮೇಡಮ್, ಅದೇ ಪ್ರಾಬ್ಲಮ್.
Lordships.
ಇವ್ರು ನಿಮ್ಮ ಕಾಪಿ ಕೊಟ್ಮೇಲೆ ಕಂಪ್ಲೈ ಮಾಡ್ತಾರಲ್ಲ, ಆಮೇಲೆ ಕಾಪಿ ಕೊಡಲ್ಲ.
Criminal petition number 282 of 22, your lord.
ಮಿಸ್ಸಿಂಗ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? Yes, page 49. NVJ, page 49 covered. Yes. Next.
50.
ಎಲ್ಲೋ ವೆಂಕಟೇಶ್ ದಳ್ವ ಮೂವ್ ಮಾಡಿದ್ರು. 306 ತಗೊಂಡಿದಾರಂತೆ, ಹಾಕಿದಾರ. Which investigation? Why? After what incident? Suicide ಆದ್ಮೇಲೆ ಅಕ್ಯೂಸ್ ಹೆಂಗ್ ಫೋನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಬೇರೆ accused ತಾರೆ.
No,
Well,
she continues to be
Your
IO.
Lordship may take criminal petition 8640 of 23.
No, ಈಗ 8640 ಯಾರ್ದು ಸರ್?
The deceased.
The deceased.
Your Lordship may take that.
Now the allegation is of torture
Allegation of.
during investigation.
Yes, my lord. Two things, my lord. She is a lawyer. And being a lawyer, she's been tortured. That is why Advocates Association also filed an IA asking, impleading this in this case.
Association ಹಾಕಿದಾರ?
Yes, my lord.
Application ಬಂದಂಗಿಲ್ಲ. All the applications.
230, get that up. I'll take all the cases at 230.
Yes.
230 I'll take this. ಅಷ್ಟೊಂದು ಲಿಸ್ಟ್ ಮುಗ್ದಿರುತ್ತೆ. Yes.
ಆಯ್ತು.
T1.
Partition between the family members.
So what?
After the resist partition, the second
The-
respondent complaint issued a legal notice.
Second respondent,
And
the petitioner, one of the petitioners are before this court so and so. one of the petitioners registers a crime against the second respondent in crime number 15 of 2024. And later, the complainant appears to have registered the crime in crime number 17 of 2024. All for the reason that the civil disputes are pending between the parties. Therefore, there shall be an interim order of stay of further proceedings where the petitioner to the next date of hearing. 17 of 24 as a counter blast is next.
52,
Settlement ಆಗಿದೆಯಲ್ಲ last time ಇದ್ರು ಅವ್ರು actually. Page 76 ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಡ ಅಲ್ಲ ನಾವು ಇಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಡ. Yes, madam. Last time she was present.
Please, ma'am.
Para
There are 4, 5 and 6, page number 7.
ಬರ್ಕೊಂಡ್ರೆ ಮೇಡಮ್ 4, 5 and 6 ಆಯ್ತು ಕ್ಲೋಸ್ಡ್. ನೆಕ್ಸ್ಟ್
53,
ನೋಟಿಸ್ page 27 notice.
54,
1 HCGP 2 emergent notice. 7980 KP Act. Madam,
Yes, ma'am.
54 permission ಇದೆಯಾ?
Please.
ಕೋವಿಡ್ ರೂಲ್ಸ್ ಅದು ಗೊತ್ತು ಬಟ್ ಪರ್ಮಿಷನ್ ಇಲ್ಲಿಯಾ?
Stage for plea ಗಿದೆ. Stage plea ಗಿದೆ. I'll try.
ಪೇಜು
Plea ಇದೆ.
FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ ಮುಂಚೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ರಾ ಇಲ್ವಾ? Offences are non-cognizable.
No.
Vagapa covered. Yes. Next.
Fifty-five,
7A. Day after tomorrow. Yes. Oh, the same notice. The fifth, yes.
56,
2013 sees crime ಅಲ್ಲಿ 2021 ಅಲ್ಲಿ ಯಾಕೆ ಚಾರ್ಜ್ ಶೀಟ್ 8 years ಆದ್ಮೇಲೆ 420. But why 8 years you have taken? 1 HCGP 2 emergent notice returnable by the 13th of December. The HCGP shall secure instructions as to why in a crime for offense punishable under section 420 of the IPC, the investigating officer has taken 8 years to file the charge sheet. Transferred, so and so. Then beda, so and so. In the meantime, ad ಮಾಡಿ ಅಲ್ಲ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು in the meantime there's a perusal. ಮೇಡಮ್ ಹರಡ್ ಅಭಿನಯಕ್ಕೆ ಅಂತ ಮಾಡಿ HCGP 1 ಅದೆಲ್ಲ ಇದೇನ್ ಬೇಡ in the meantime ಅಂತ ನೆಕ್ಸ್ಟ್
57,
78(3) KP Act ಕೊಡಿ ಅದು ಸೇಮ್ ಆರ್ಡರ್.
58,
498A 2 and 3 ಗೊತ್ತು accused number 2 and 3. Yes. 2, 3 and 4. All right. 2621.
59,
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ ಗೊತ್ತಿಲ್ವಾ ಯಾಕೆ ನೋ ಸ್ಟೇ tag this petition along with so and so, list them both on Friday. Fresh matters list. Next. And on the bench 29th. Monday, next Monday. Sidramanya, next Monday. Yes.
second,
60. Split,
number 60,
split. Kodi.
So when the total comes.
Like, pass over. ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ.
61,
In the meantime,
62,
States, sir.
60 totally evidence comments ಆಗಿದೆ my lordship.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಯಾವತ್ತು ಸರ್? ಯಾವತ್ತಾಗಿದೆ? After filing the petition. The petitioners are before this court calling in question proceedings in so and so registered for offence punishable under section 447 of the IPC. The counsel for the petitioner takes this court through the documents to demonstrate that the petitioners are in possession of the property and therefore the offence under section 440.
I instructed for R2, my lord.
Works property na?
No, 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 it is a private property.
Ah,
The 136, 136 also is there, my lord, offense.
maybe, yes. So,
No.
so there, Leonard, we got the mail, but
And charge
Counsel-
framed and evidence is on progress. CW1 was,
when was it framed?
on
After
21st.
filing the petition or before filing the petition?
After filing of petition, there is no say, my lord, evidence was commenced.
Maybe.
CW1
Maybe.
recorded the evidence.
You file your objections, we'll consider it.
Have it on this date, next week, my lord.
Yes, so.
Any date may be granted.
Counsel MH Hanif accepts notice for the complainant, registered to print the name of so and so is appearing for the complainant. Mikid ಹೇಳಿದ್ನ ಆಮೇಲೆ ಮಾಡಿ. There cannot be criminal trespass into his own property is the submission. In that light, there shall be interim order of stay of further proceedings where the petitioner still the next date of hearing list the matter on 12th December in the fresh matters list.
Please.
63,
11 and 12 and 306, lethal combination.
ಏನು ಇಲ್ಲ material page number 56 even the complaint is taken at serious value there is no ಒಂದೇ ಶಬ್ದ third by come judgment is go and die except that there is nothing 56 page number ನಲ್ಲಿ ಇದೆ 56 page number only 3 messages are collected in entire investigation. When charge sheet is filed, I have got the copy.
Okay.
Everything is even if slightest material, even complaint is here. Any legal material which can be translated into evidence. I have provided. Any material which can be translated into evidence. That is not
Yes.
legal material.
List tomorrow in the fresh matters list, yes.
But
64,
Representation list after 4 weeks. ಇಟ್ಕೊಂಡಿರಿ ಅಕಸ್ಮಾತ್ ಬಂದ್ರೆ ಮಧ್ಯಾಹ್ನ. Yes, next.
65,
DV Act 2 and 3.
petitions are okay.
2 and 3, yes. Then the petitioners are before this court, so and so they are accused 2 and they are respondents 2 and 3 before the concerned court. Finding no allegations, 2 and 3 state. Next.
66,
Why all of you are there? Different petitioners, huh? No, no problem. Let them be there. It's all right, yes. ಇರ್ಲಿ ಯಾಕೆ? ಅವ್ರು ಇದಾರೆ ಅಂತ ಸ್ಟೇ ಮಾಡಲ್ಲ, ನೋಟಿಸ್ ಅಷ್ಟೇ. ಹಾ.
Prior to that, 7th of March, the complainant and the husband have acknowledged that they are returning the shop. And they have made a payment of 15 lakhs.
Where is that?
And
Page.
the annexure G. Page number
I serve on the complaint, the petitioner to serve on the complainant. ಅದು ಬೇಡ. Imagine notice to the complainant returnable by the 17th of December. HCGP accepts notice for the first respondent. Learned counsel for the petitioner taking this court through the documents appended to the petition would submit that the complainant and her husband who have received the money have themselves said that they would return the shop. In that light, there shall be an interim order of stay of further proceedings where the petitioner till the next date of hearing. ನಾನು ಅದು ಕೊಡ್ಸಕ್ಕೆ ಅಂತಾನೆ ಬರೀ ನೋಟಿಸ್ ಮಾಡೋಣ ಅಂತ. ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ yes.
67,
ಯಾವಾಗ ಪೇ ಮಾಡ್ತೀರಾ? ರೆಡಿ ಇದೆಯಾ? Learned, the petitioner is before this court calling in question the imposition of 20% for suspension of sentence by the appellate court against a convict, the petitioner, and for offence punishable under section 138 of the Negotiable Instruments Act. The learned counsel for the petitioner submits if 2 weeks' time is granted, the deposit would be made. Based on, recording the said submission, list the matter after, list the matter on 12th December. There shall be an interim order of stay of the said order till the next date. DD ಇಲ್ಲ ಅಂದ್ರೆ ವಜಾ ಮಾಡ್ತೀವಿ. ಹಾ?
68,
ಆಯ್ತು ಸರಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
68,
Theft, madam.
Stolen. Received, madam.
Your ಮೇಲೆ
Stolen
ಏನಿದೆ?
property received.
Yes.
A4, my lord.
No, only one, no, one HCGP, 2 emergent notice. Madam, it is theft, madam. ಬರ್ಲಿ, dismiss ಮಾಡಿಲ್ವಲ್ಲ? Yes. One HCGP, 2 emergent notice returnable by 17th, yes. ಅವತ್ no, we'll see that day, list on 17th. 17th in the fresh matters list. A3 ಯಾವ ಸ್ಟೇಕ್ ಕೊಡಿ, ಅದ್ ನೋಡಿ ಮೇಡಮ್, ಎಲ್ಲ ಸೈನ್ ಮಾಡಿದ್ದೀನಿ. I tag along with sounds, ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ರೆ ಏನ್ ಮಾಡಕ್? Yes. Same order ಮಾಡಿ. List them both on 17th.
69,
Page 25, sir. All offences found against all the accused. One HCGP, 2 emergent notice.
Even NBW.
ಅಷ್ಟೇ notice. Yes, next. No, sir. Yes, next. Returnable by 18th December. In the meantime, next.
Petitioners, your. Grant the police has filed with FIR. Span of 1 year, your. Date of.
States, sir. Stay,
71,
71. Na. A2 and A3. 400, yes.
72,
One HCGP, 2 emergent notice in the meantime, next. Granted. ಕೊಟ್ಟಾಯ್ತು sir. Yes, next.
73,
Case and counter case. 80 and 81. ಹಾ, ಗೊತ್ತು, ಅವ್ರು 81. ಏನ್ ತಪ್ಪು? The incident has happened according to. So what, sir? Civil suit pending ಇದ್ರೆ assault ಮಾಡಬಹುದು. One HCGP, 2 emergent notice. Next. We'll see, yes. You also alleged against women only. Yes, list on returnable by 11th December. ಅವತ್ತು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡು. Yes.
74,
On the date of the alleged incident, the petition for restitution of conjugal rights was going on. And prior to that, she had filed a petition for resolution of marriage. She herself. accused
Evidence
that
started.
the
Evidence
husband had convinced her because of it. Therefore, my lord, there was no occasion for him to assault her. The injuries are self-inflicted.
Grievous injuries.
Only for the purpose of filing a petition for.
No, see page 38, sir. Page 38. And evidence has commenced, you will not interfere.
I request my lord. to
You are the
file a
husband.
case.
No, sir. Not a case for stay.
Page 21, she says that husband convinced her to withdraw the petition for dissolution. Subsequently, during the pendency of a petition for restitution of conjugal rights.
Injuries
she alleges
also
this
previous.
incident And later files a petition for dissolution of marriage. Only to.
ಈಗ ಎವಿಡೆನ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ, ಯು ಆರ್ ದಿ ಹಸ್ಬೆಂಡ್. Lethal combination. Impossible to interfere.
Circumstances
No,
indicate that only for the purpose of creating grounds for dissolution of marriage, it was filed subsequently. The allegations have been made.
I will not interfere because evidence has commenced. Otherwise, you want me to give a finding, we'll give a finding. There is clear case of assault.
26 of the evidence,
Very good. Yes,
May 26. That was paid in July.
no problem. Meenakshi Bala. You urge all the contentions there. Next, disposed.
75,
In the meantime, 324. Yes, next.
76,
Petitioner is accused number 5. A perusal at the summary of the charge sheet as obtaining in column number 17 would indicate no ingredient of any of the offences alleged to be committed by the petitioner. Accused number 5, finding no case against accused number 5 to permit further proceedings, there shall be an interim order of stay of further proceedings. ನೀವಿದ್ದೀರಾ ಹರ್ಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಹಾಕಿ. ಎಸ್ ನೋಡ್ಲಿಲ್ಲ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
77,
Both 77, 78. 77 in the meantime, list in the first week of January 2025. Next. One HCGP, ಕೊಟ್ಟಾಯ್ತು sir. One HCGP, 2 emergent notice ಅದರಲ್ಲಿ. Next to DV Act, notice. State ಇಲ್ಲ, sorry, the emergent notice. Next to DV Act, emergent notice to the respondent. Yes, next. ಅದೇ next day.
Aged persons, my lord.
ಅದಕ್ಕಷ್ಟೇ. ಸರ್, DV Act ನೀವು ವೈಫ್ ತಾನೆ?
No, wife filed against the mother-in-law and
Correct. Notice, yes.
Yes.
Emergent notice to the respondents. Next.
79,
Hearing for the petitioners, your lordships, offences are under section 434 and 447 of IPC. The said
What is 434?
mischief, your lordships.
Mischief. 427 is mischief.
Uh, Mischief by destroying or moving, etc.
Moving
landmarks.
a
Ah.
publicly determined area.
Public official has to install the said landmark.
Correct.
your
Boundary
lordships.
problem.
In the PCR, your lordships, he alleges that it was on the date of 13/2/2017. He comes to file the PCR in the month
The
of 10th.
petitioners are before this court calling in question, so and so the offences punishable are, the offences alleged are the ones punishable under section 447 and 434 of the IPC. A perusal at the order of cognizance or the complaint so registered against these petitioners would indicate that the issue that is seemingly civil in nature is sought to be projected as a crime. Therefore, there shall be an interim order of stay. Next.
Much obliged.
Yes.
80,
Serve ಮಾಡಿದ್ದೀರಾ?
Serve ಮಾಡಿದ್ದೀವಿ.
ಇಲ್ಲ ಇಲ್ವಲ್ಲ. Let's tomorrow in the fresh matters list. Yes, next.
81,
Same, ಕೊಡಿ. Tag. ಆರಾಮ.
ಐದು
Right.
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಯಾವತ್ತು
ವಿಡ್ರಾ
ಹಾಕೋದಿಲ್ಲ?
ಮಾಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ.
ಹಾ?
ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ.
ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ
ಅಷ್ಟೇ
ಈಗ.
ಹೌದು. Yes.
82,
For petition in this case. Opposition section 420, 460, 471. Whereas the complaint is lodged by one private person, Putswami, who is a.
Forward.
Allah, prior to that, 1/12/2023 at page number,
Sir, giving false credentials, you have taken the benefit.
I am the contract, your lordship. And at page number, page number 74, annexure P.
When the documents were sent for verification by KPTCL, they come to know.
It has been sent to 1/12/2023, I have sent the documents, your lordship.
One HCGP, 2 emergent notice. Yes.
No, till today, I am in the continuation of the contract, your 38, annexure
All
P,
right.
your
Yes,
lordship.
yes. Next.
83,
I appeal to the.
Not a signature.
38.
In the meantime, next. The learned counsel for the petitioner taking this court to the documents appended to the petition would demonstrate that the petitioner is neither the signatory to the check nor is involved in the day-to-day affairs of the company. Therefore, there shall be an interim order stay. 84, Andar Bahar. Andar Bahar.
Yes, 7980.
Yes, next. Kudid. Disposed.
Eighty-five.
I appeal for respondent number 2 to 6, your lordship. I undertake to take notice.
85, complainant.
Seeking short adjournment, my lord.
Learned Counsel Abhinaya K accepts notice for the respondent
2 to 6,
2 to 6. Ellaruna?
LR.
2 to 6. Registry to print the name of Abhinaya K as appearing for respondents 2 to 6. The learned counsel for the petitioner seeks adjournment. Urgency unta.
Yeah, your worship, this is the 2010 matter pertaining to Bhadravati MLA in which senior had argued, where Mr. Shyam Sundar was, had filed an.
Oh, that matter is it.
In that matter, it's not the same application which is challenged now.
Hmm.
An earlier application prior to that was dismissed in 21 March of this year,
Hmm.
where the prosecution had filed an application to treat 35, 36, 37 CWs as court witnesses, which was dismissed.
Anyway, he's seeking time.
Yes, your lord.
Pendency of this petition will not come in the way of further proceedings before the concerned court.
But
That's the
there-
matter.
There's another thing, your lordship. They have filed another petition before the coordinate bench, GMRES file ಮಾಡಿ, special PP appoint ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು on 22/11 they have taken an order for 2 weeks, defer ಮಾಡಿ ಅಂತ ಹೇಳಿ. It had to be posted before this court, designated court for special court matters,
Special court matter, alva?
special court.
Then how
matter.
did it go there? The learned counsel for the respondent, learned counsel Abhinaya K submits that the petitioners have preferred another petition, which is before the coordinate bench, which ought to have been placed before this court in the light of it being, this being this designated special court for MP and MLAs.
That is already disposed, your lordship.
Disposed of.
2 weeks ಅಂತ ಹೇಳಿ time ಕೊಟ್ಟು dispose ಮಾಡ್ತೀನಿ.
Senior counsel
Very
engage
good.
ಮಾಡಿದ್ದಾರೆ.
Let's the matter on 5th December,
4th may I request.
4th December, all right, yes.
Matter.
ಬೇರೆ ಏನು ಬರಿಬೇಡಿ. Abhinaya K accepts notice 4th December. Next.
86.
For the petitioner, my lord. My lord, the offense complaint is section 306 read with 149, my lord. None of the ingredients of the offense have been made out in the charge sheet. my
Used
lord.
1 to 12.
Indeed, my lord.
Hmm.
There is no specific allegation against any of the accused, my lord. My lordship may find the charge sheet summary at page 46, my lord.
Let's see. Day after tomorrow in the fresh matters. Yes.
Right.
Madam, look into it and come. Day after tomorrow.
Please, my lord.
Yes.
87.
Petitioner, the dispute with regard to the return of deposit amount, security deposit amount between the landowner and the tenant, my lord. Monies have been already paid to tenants, mother, there's a second
But
responsibility.
ಏನ್ assault ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆಯಾ?
A1. But otherly, your lordship may kindly see, for the allegation incident at 12 o'clock, FIR 7 and wound certificate at 11:20 PM.
Notice.
And as against 2 and 3, my lord, there's absolutely nothing.
You are accused number-
ಬೈದ್ರು ಅಂತ ಇದೆ. Your summary, your lordship, page number 36.
A perusal at the summary of the charge sheet as obtaining in column number 17 would indicate all offences of assault against accused number 1 and none against the accused number 2 and 3. In that light, there shall be an interim order of stay only against accused number 2 and 3. Proceedings against accused number 1 shall continue. 1 HCGP 2 emergent notice.
88.
Lord, I appear with the petitioner. My lord, allotment of checks, my lord, was done by the BBMP officials, my lord, allotment of checks. So we had nothing to do with the allotment of checks.
Notice only.
My lord,
One-
since 2011, my lord, allotment is pending. 2018 is charged.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಇನ್ನು HBC ಇದೆ. 2019 ಅಲ್ಲಿ CID charge.
10 ವರ್ಷ ಆದ್ಮೇಲೆ ಹೊರಡಿಟ್ಟು ಹಾಕೊಂಡು ಏನ್ ಸರ್ ನೀವು? Will direct the court to conclude the proceedings fast ಅಷ್ಟೇ. Learned HCGP is directed to accept notice for the respondent secure instructions with regard to the stage of the proceedings. List next Monday in the fresh matters. Next. 2014 CC, madam.
Same.
Please.
Look into it. Same, 89 is same.
90.
I'm partying person in this case. Based on the complaint of respondent number 2,
respondent police have issued a malicious prosecution.
ಏನ್ ಮಾಡಿದ್ರಿ?
Station ಅಲ್ಲಿ
ಸ್ಟೇಷನ್ ಗಲಾಟೆನಾ?
No, Lordship. The entire submitted the charge sheet based on the fake incident, Lordship.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ.
Submitted the charge sheet based on the fake incident. No such incident as that. But
You have assaulted the policeman.
No, Lord. 41 is CRPC notices and documents.
ಯಾಕೆ ಮಾಡಕ್ ಹೋದ್ರಿ? ಯಂಗ್ ಅಡ್ವೊಕೇಟ್ ಸ್ಟಿಲ್.
No such incident has happened. We went to the police station to give complaint, Lordship. But
Why did you go to the station?
Because of in my village, some of the persons who try to outrage the modesty of my mother. Because of that incident, we went to the police station to give complaint, Lordship.
They did not
But the
take.
Respondent police considered that fact, but didn't register the FIR against the persons who outraged the modesty of the woman. They totally considered that fact, and due to the political influence, they instituted a malicious prosecution against me in this case, Lordship. Because of this,
Against you.
against me and my mother, Lordship.
Mother is also an accused here.
Yes, Lordship. I is number 2 in that case, Lordship. But they considered this fact and but didn't register the FIR against that person's, Lordship.
ಇದು 90 and 92 tag HCGP 1 emergent notice 2.
Stay application.
The perusal at the allegations or the findings in the summary of the charge sheet, particularly for offense punishable under section 353 of the IPC, it would not meet the ingredients as held by the apex court in the case of H. Dhananjay versus cabinet secretary so and so. In that light, there shall be an interim order of stay away the petitioner till the next date of hearing.
Memo with the documents I am filing.
Registry file ಮಾಡಿ. Next. 1992 ಎರಡು. 91 in the meantime, next.
The sister has filed complaint against.
So sir, 1973. Stay high.
Great.
Next.
93,
188 COVID violation.
Appearing for petitioners, madam.
Where is judgment 188? Covered judgment ಎಲ್ಲಿ?
Produce the judgment, madam.
List next Monday in the fresh matters. No, sir. Get it? Next ಮಾಡ್ಬೇಕು. 188 20 judgment ಇದೆ. ಸುಮ್ನೆ you can't walk in without homework.
Continuously NBW.
As on date is 1,36,000. Therefore, there shall be an interim order of stay, subject to the condition that the petitioner would deposit
50%.
50%. Yes.
That's 1,30,000.
50% of 1,36,000 in the next 4 weeks. List the matter on 18th December in the fresh matters list. Next. Emergent notice to the respondents.
95,
Let's say appear for the petitioner merits. Petitioner merits is read as accused number 3. There was a civil suit which was filed. Civil suit is compromised merits at page 94.
90?
94. The sale deed which was executed in my favor now has been declared as null and void in the compromise. That is at page 94. Then subsequently, my lords, the complainant has sold the property also. That sale deed. my
That's
lords,
all right. 13 1D.
Please.
27th, madam.
my lords,
Day after tomorrow, barley, in the fresh matters list. Yes.
I'll take out notice on
Baby Patil serve ಮಾಡಿ.
Please.
Counsel to Baby Patil is directed to accept notice for the respondents. You're A4, right?
I'm A3.
A3 now, right? Yes. Yes.
96,
I pay for the petition.
10 ಲಕ್ಷ ವಾಪಸ್ ಕೊಡಿ.
Civil matters.
ಪರವಾಗಿಲ್ಲ 10 ಲಕ್ಷ ವಾಪಸ್ ಕೊಡಿ.
ಅದರಲ್ಲಿ ಇದು ಯಾವುದು
ಕಂಪನಿಗೆ ಕೊಟ್ಟಿರೋದು.
ಪರವಾಗಿಲ್ಲ
ಕಂಪನಿನ ಪಾರ್ಟಿ ಮಾಡದೆ ಬೇರೆಯವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ದೇನೆ
10 lakhs ವಾಪಸ್ 10 lakhs ತಾನೇ
9.5 lakhs.
10 ಲಕ್ಷ ತಗೊಂಡ್ರದು
ಅಲ್ಲ 9.5
ಎಷ್ಟು
9.5.
ಕೊಡಿ ವಾಪಸ್ ಕೊಡಿ
ಕಂಪನಿ
ಮನೆ ಕೊಡ್ತೀವಿ ಅಂತಾನೆ ತಗೊಂಡ್ರದು ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ ಕಂಪನಿನೇ ಇಲ್ಲ ಇವಾಗ ಹಂಗಾಗಿದೆ.
ಪರವಾಗಿಲ್ಲ
ನನ್ನ ಒಬ್ಬನ್ನೇ ಮಾಡಿದಾರೆ ಅವ್ರು.
ನೋ ಪರವಾಗಿಲ್ಲ ಪಾಪ ಸಮ್ ಪೂರ್ ಮ್ಯಾನ್ ಹೋಮ್ ಬಯರ್ಗೆ 10 ಲಕ್ಷ ಬಿಗ್ ಮನಿ
ಸೈಟ್ ತಗೋತೀನಿ ಅಂತ ಅದೆಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗುತ್ತೆ. ಡಿಸ್ಪ್ಯೂಟ್
ಯಾಕೆ
ಆಗುತ್ತೆ.
ತಗೊಂಡ್ರಿ
ನಾವಲ್ಲ ಅವ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ಸ್ ಗಳು ನಾವು ಮಾಡಕ್
No, no,
ಡಿಸ್ಪ್ಯೂಟ್ ಆಯ್ತು.
nothing.
There was so many.
Who has received the money will return back the money.
It
Civil
is
and railway
company has received the money, madam. Company has received the money. Not the personal ಏನ ತಗೊಂಡಿಲ್ಲ ನಾವು.
ಪರವಾಗಿಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ.
Company has received the money.
Yes sir. Anything else?
ಅದೊಂದ್ ಸ್ವಲ್ಪ
ವಾಪಸ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂದ್ರೆ ನಾವು ಹಾಕ್ತೀವಿ.
I will
List the matter on 17th December in the fresh matters list.
17th.
ಬೇಡವಾ?
ಬೇಡ 16th.
16th, all right, yes.
97,
In the meantime, yes, next.
98,
Huh?
97. 98. 97.
97 ಬೇಕಾ 98 ಬೇಕಾ 97 ಸ್ಟೇ ಆಯ್ತು.
98.
Yes.
98. The section offense and section 408.
Huh?
408, 420 offense.
Correct sir, misappropriation.
Breach of trust by servant and cheating.
Yes sir, correct. One HCGP, 2 emergent notice.
Kindly intimate kindly.
Yes, next.
99,
Why not 4, 506 sir? Heard the learned senior counsel in the meantime, next. Please. It's published.
Lord,
Page
case,
116 covered,
please, Lord, this
page 116.
And case and counter results.
Page 116 covered.
please, Lord.
Charge framed on 5/7/2023.
Page 116 covered ಇದ್ರೆ ನೋಡಿ. Charge frame ಆಗಿ covered ಇದ್ರೆ ತೊಂದ್ರೆ ಇಲ್ಲ. ನಾಳೆ ಎಸ್ ನೋಡ್ಕೊಂಬನ್ನಿ ರಂಗಸ್ವಾಮಿ ನಾಳೆ. ಎಸ್
Rest matters, please.
101,
fresh matters list.
And
Wildlife.
He is agriculturist of survey number
HCGP is directed to accept notice for the respondent. State. Your accused number 5.
Well, he is the main accused, my lord.
Learned
He-
HCGP to secure instructions, go through the papers and make a submissions Tuesday in the next Tuesday, fresh matters.
obliged.
Next. Legal grounds ಇದೆ ನೋಡ್ಕೊಂಬನ್ನಿ.
102, I appear for the petitioner, my lord.
2,
The complainant, my lord,
Are you the purchaser?
I am, my lord, the subsequent purchase.
The petitioner is accused number 14 is said to be the subsequent purchaser of the property that has now become the bone of contention. The learned counsel for the petitioner submits that he is a subsequent purchaser and a bona fide purchaser and purchases the property long after the initial purchase by someone else and did not know the
My lord, it was just an understanding and an advance was paid to the company A1. A1 has returned that
Yes.
consideration.
learned counsel submits that the role of the petitioner is only advance payment.
Complainant had paid advance to A1 company. They returned it back saying you are not
That
eligible.
A1 will tell, don't worry about
Please.
it. Yes, so and so. Since the petitioner is a bona fide purchaser and no allegations are leveled against him that could become the ingredients of the crime, I deem it appropriate to stay further proceedings, square the petitioner till the next date.
Great.
In the meantime, 103, yes.
103.
Tender work. Tender. In the meantime, next.
104,
Allegation is of fabrication of.
11B sketch.
No, no, it's a assessment certificate issued by the panchayat
ಮತ್ತೆ?
for irregular.
Why did you fabricate that?
Okay, I fabricate.
In the meantime, yes.
105,
Sir, bigamy case is initiated by the husband against the wife.
Who else can initiate against whom, sir? Husband ಮೇಲೆ wife ಮಾಡ್ಬೇಕು ಬೈಗಮಿ.
But taken the contention of under section 200 CRPC without filing the affidavit, violating the principle laid down in the Priyanka Srivastava versus UP case. Not filed an affidavit, not approached the police station, also not stepped into the court, sir. Even complaint is absent, and the absence of the complaint, section 200 CRPC application was received and referred for the investigation, sir.
The petitioner is the husband against whom an offense under section 494 of the IPC is alleged. The offense is for bigamy. The respondent complainant is the wife. Alleges that the petitioner has married twice over. Does not approach the jurisdictional police. Approaches the concerned court invoking section 200 of the CRPC without filing an affidavit as is necessary in law. In terms of the judgment of the apex court in the case of Babu Venkatesh versus State of Karnataka, 2022 SCC Online SC page 200. In that light, there shall be an interim order of stay till the appearance of the complainant. Next.
106.
Petitioner in this case, my lords. My apologies to come over VC, my lords. I'm not keeping too well.
That's even the case is not well, sir. Page 40, sir.
My junior counsel is also there, my lords. He's also there, the petitioner himself, rather. My lords, they're already been divorced, my lords. There is no that just because there couldn't be.
All right.
Just because there couldn't be a 498A case, such cases.
One HCGP, 2 emergent notice in the meantime. Your case is it?
My lords?
You are the petitioner.
Yes, my lord.
Yes, my
In the
lords.
meantime, yes.
107.
States.
Obliged.
Stay badwa.
Stay big.
What type? Yes.
Obliged. Very.
107. Renault.
498 aim lots. All the
2 to 7.
all the petitioners are in-laws in laws. There is a, we have approached the All India Human Rights Association at page number 124. And there was a agreement made between to resolve the
108
dispute.
In the meantime. ನಿಮ್ ಸ್ಟೇ ಆಗಿ ಬಾಳ ಹೊತ್ತಾಯ್ತು.
Please, my lords.
498A.
Please.
ಫಸ್ಟ್ ಟೈಮ್ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ?
Not 9.
CC 2018, what stage? 108 stayed in the meantime, yes.
Accused number 2, my lord. Alleged
Stage,
offense-
stage CC 2018.
Charge sheet has been filed, my lord.
Charge frame ಆಗಿಲ್ವಾ?
No, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ನೇ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊ ಬಂದಿವಿ. Charge frame
frame ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ.
Because 2018 CC. Yes, in the meantime, next.
110.
Page 34, same order. Tag. Yes.
111.
Split,
No, my lord.
ಮತ್ತೆ 399, 402, A6.
A6, my lord, implicated only
Hello.
based on the confession and statements. And
Continuously NBW, my lord.
NBW for A2, not against me, my lord. NBW for A2. My lord, there is no material in support of the
Lord.
petition.
One HCG.
My lord,
Complainant ಯಾರು? No, sir.
complaint is, my lord, PSI.
HCGP accepts notice for the respondents.
My lord,
List the matter on 10th December.
my lord,
Next.
there is no material, my lord, to
No,
support
sir.
their case. My lord, nothing is available in the charge
We'll
sheet.
see, yes.
My lord, any date,
10th.
grateful.
112.
Item number 12, my lords, I take it to the respondent number 2. My lords, 2021 charge sheet. For 1 year, my lords, they would keep, my lords, prolonging the trial, my lords.
ಇನ್ನು
seeking
ನೀವು
for hearing.
ಎಂಟ್ರಿನೇ ಕೊಟ್ಟಿಲ್ಲ. Wait. Yes. Even otherwise ಬರೀ notice case ಅದಷ್ಟೇ. Learned counsel Ajay Kadkol accepts notice for the second respondent. Registry to print the name of so and so is appearing for the second respondent. When do you want?
So next week, my lords, subject to my lords
Yes,
convenience.
list on
For matter
Wednesday in the fresh matter.
For a matter listed for a. framing
Maybe,
of
sir.
charge.
So what? Yes.
Very good.
Next. The interim order ಕೊಡೋ ಕೇಸ್ ಅಲ್ಲ. Next.
Already
113.
ನಾವೇ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿದ್ರೆ. Page number 156 ಅಷ್ಟೇ ಆಗಿದೆ.
Connect ಮಾಡಿ stay ಆಗಿದೆ.
No, no, my lord, that is a different transaction. This is a different transaction.
Complainant and accused same sum. Page number
Page?
156.
Page
156. sir.
My lords, parties are the
Petition
same.
number 890424.
156, sir.
Also. Same transaction.
Complaint same.
How some complaint same, accused same, Baguru Nagarajappa.
May I make the submission, my lords? My lords, transactions are different.
Solid.
Parties
Then
are the
day af-
same.
day after-
They're
Day after tomorrow in the fresh matters.
very well. I'm very grateful.
Tag this petition along with page 156. Yes.
Yes, I'm very grateful.
113,
354, 355 finite formula.
Wound certificate.
No, in a crime.
113 alva.
Yes,
ಅದೇ wound certificate ಇದೆಯಾ?
wound certificate is not yet produced. And similar, very same offense, there is already.
ಆಯ್ತು ಬನ್ನಿ. wound certificate
is
ಇದೆಯಾ?
not-
Charge sheet ಗಳಂತೂ ಹಾಕಿಲ್ಲ wound certificate. It is not even listed as a document. In the meantime, yes, next.
then 14,
Accused number 3, my lord. Negation against him that he held the accused number 1 to get married. This matter stays already granted on the way of settlement and even on the merits, my lord. The
It will
date of marriage,
tag with page 30-31.
my lord,
That
marriage was.
In the light of the interim order grant subsisting qua the other accused, there shall be an interim order of stay in the case at hand, qua this present petitioner as well, lest the matter on 12th December.
then 15,
I appear for the petition number
188.
188. There's a judgment of a
Ah,
court.
okay. Work ಮಾಡಿರೋದು. Yes. Covered. Next.
116,
I'm grateful.
No representation, 4 weeks. Next.
117,
I am for the petitioner.
Under system. Under system, I filed vocal for respond number 2, your lord.
117, madam?
6 and 7, no involvement at all.
Yes.
Malapura.
116, please, Lordship.
116. 17 ಅಲ್ವಾ ಕರೆದಿದ್ದು?
That is
16
17.
ಇರ್ಲಿಲ್ವಲ್ಲ ನೀವು?
ಇಲ್ಲ, ಇದೆ.
4 ವಾರ ಅಡ್ಜನ್ ಮಾಡಿದೆ.
ಇಲ್ಲ,
No, no
I am-
representation.
I am-
ಎಲ್ಲಿದ್ರಿ?
Husband
ಕೇಸ್ ಅಂದ ತಕ್ಷಣ ಅಪಿಯರ್
ಅಲ್ಲ, my humble submission, there is a legal notice was given.
ಅದು ಆ ಗ್ರೌಂಡ್ ನನ್ನ ಹತ್ರ ಇಲ್ವೇ?
ಅಲ್ಲ,
ಲೀಗಲ್ ನೋಟಿಸ್ ಕೊಟ್ಟ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ರು ನಥಿಂಗ್.
ಅಲ್ಲಲ್ಲ, the allegation in 22 is.
ನೋ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲಲ್ಲ, my humble.
One HCGP to emergent notice.
ಅಲ್ಲಲ್ಲ, my humble
Respondent number
submission,
2.
Lordship. In 20.
Respond number 2, I filed in vocal, your lordship.
Oh, you ಅದ್ರಲ್ಲ counsel so and so accepts notice for second.
In our complaint itself, she said that
Yes, is coming.
15/6/22.
List the matter on Vishnumurthy ಅವರೇ.
Vishnumurthy.
116 ತಾನೆ?
How's on?
116. List the matter on 10th December. Yes. Husband, husband, sir.
Allah, husband, Lordship, there is a allegation in 22 is the last, she is residing in the June 20.
No, no, next, yes. ಬರ್ಲಿ.
then 17,
I am A6 and A7.
The heard the learned senior counsel C.V. Nagesh appearing for the petitioner. A perusal at the complaint. Charge sheet ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ, charge sheet ಆಗಿದೆ.
And summary of the charge sheet would not indicate any involvement of accused number 6 and 7 in the alleged episode of crime while allegations galore against all other accused. Finding no overt act or any ingredient of the allegations permitting further proceedings where these petitioners would become an abuse of the process of the law, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings where the petitioner to the next date of hearing. 1 HCGP to emergent notice. Next,
18,
7A,
Please,
5ನೇ ತಾರೀಕು.
exonerated.
ಡಿ ಎಕ್ಸಾನರೇಷನ್
Yes.
ಅದು ಯಾವತ್ತು ಹಾಕಿದೀವಿ ಮೇಡಮ್?
Please,
Friday. 29th, we'll close it on that day. Serve on baby party. Heard the learned senior counsel Kiran Javli appearing for the petitioner to serve on baby party. Requisite set of papers. ಅದೆಲ್ಲ on Friday. 2-3 ಹಾಕೊಂಡಿದ್ದೀನಿ ಅವತ್ತು.
please.
119,
Lord, PCR, my lord.
The private complaint was filed in the year 2015 and a reference is made in the year 2015. Investigation gets complete and a charge sheet is filed in the year 2024 after 9 long years. The respondent the HCGP to secure instructions as to why it has taken 9 long years to file the charge sheet for an offense under
B
section.
report, my lord, B report.
B report
B
ಹಾಕಿದ್ದೀರಾ?
report, please.
20 ವರ್ಷ ಆದ್ಮೇಲೆ.
Allah, first PCR, second PCR, my lord, this is. Second PCR, first PCR filed on
2010, my lord.
ಅದ್ರಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಆಯ್ತಾ?
B report. Second, file same set of facts. That
Same
is
2015.
Please, my lord. I put the
ಹಿಂಗ್ ಮಾಡಿ. The learned counsel appearing for the petitioner submits that the first private complaint was registered in which the police after investigation file a B report. The second complaint is
23/7/2015 filed, that is also filed. B.
the second complaint is registered during the same time in which the charge sheet is filed by the police.
B report, my lord. Charge sheet alla, B report.
9 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನ್ ಮತ
B report file ಮಾಡಿದಾರೆ sir. They have filed B report.
ಫಸ್ಟ್ ಬಿ ರಿಪೋರ್ಟ್.
Second B report.
ಮತ್ ಸಿಸಿ ಇವ್ರು ಚಾರ್ಜ್ ತಗೊಂಡ್ರದ ಈಗ.
Charge sheet ಹಾಕಿಲ್ಲ sir. B report.
And yet again, a B report is filed after the investigation by the police. The concerned court now rejects the B report and takes cognizance of the offence. Since the B report is filed twice over and the issue relates to several sale deeds and the matter being purely civil in nature, I deem it appropriate to stall further proceedings where the petitioner still before the concerned court till the next date of hearing. Next.
120, 14%.
7 charge.
You are back?
Yes.
Yes. BB Patil serve ಮಾಡಿ. ಮುಂಚೆ ಯಾರಿದ್ ಲತೀಫ್ ಅಲ್ವಾ? Latif was somewhere here. Counsel Latif is directed, B Latif is directed to accept notice for the respondent. Serve on him. List on 5th December.
121,
Hearing for the petition.
File an appeal under section 29.
91 of CRPC applied application to summons the documents, my lord.
What documents? DV Act.
DV Act, employer,
Emergent notice to the respondent. Yes, next.
tomorrow there is a matter for argument. Matter is posted. for
Argue the
argument.
matters. Yes.
Have to put
Return
the doc-
You serve on, petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. List on 6th December. Next.
122,
Let's counsel for the
Charge
petition.
sheet ಆಗಿದೆಯಾ?
My lords, counsel for the petition.
Charge sheet is filed
My lords, no, charge
Not
sheet
yet.
is not filed, my lords.
Not yet.
in the meantime. Yes, next.
My lords, interim prayer.
23.
Oblige.
The offense, the petitioner is before this court calling in question proceedings in, calling in question registration of a crime for offense punishable under section 427, 447 of the IPC. A perusal at the complaint would indicate the absence of ingredients of both the offenses. Therefore, there shall be an intermodal of stay of further proceedings. Next. Learned HCGP is directed to accept notice for the respondent. List the matter next Wednesday. Learned HCGP is directed to secure instructions, go through the papers and make a submission. MMDR.
Please, my lord, he is only an executed a rent agreement. He is the owner of the land. And there is a
Yes,
condition to take license and other.
ನೋಡ್ತೀರಾ?
He's the owner of.
Practicing it.
List on next Wednesday, fresh matters. Next, yes.
25,
For the petition, this case, your lordship, the TV Act, your lordship. Your lordship already she was leaved only for the 7 days in his petition itself. He was.
Emergent notice to the respondent. In the meantime, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. Deepak, data theft, your employees.
126,
Please, no, my lord will see, I'm A4, A5.
Uh,
Allegations are made against the company. I'm only a director. Company is not made as an accused. The short background to this, my lord, is the complainant company wants to purchase the company in which 4 and 5 are directors. The transaction falls through. In fact,
Friend, heard the learned counsel appearing for the petitioner. The second respondent complainant is said to be wanting to purchase, which company is that?
the complaint, company known as Learnovate Skills Private Limited.
Where do you get that? First paragraph, array of
Yes.
parties sold. The transaction appears to have gone wrong. The petitioner accused number 4 and 5 are said to be directors of the company. The transaction is with the company and the company is not made an accused in the proceedings, but the investigation is concluded and charge sheet is filed.
Charge sheet is not.
Hakilwa? Not, company is not made an accused and the investigation is on. In the light of the said, in the light of the aforesaid lacunae, there shall be an interim order of stay of further investigation where the petitioners till the next date of hearing.
So
Next.
great.
127,
Lords, the respondent is the purchaser of the property, my lords.
I priorly given a police complaint to the commissioner stating that I was threatened by the respondent number 2 because I haven't handed over the possession of the apartment. Indenture of sale happens in 2016. It is agreed that the possession of the apartment couldn't be handed over due to various reasons between the.
Uncognizable offenses, sir.
354.
Huh?
354 B.
354 ಇದೆಯಾ?
B this kindly. Gist of the case.
352 of BNS.
Case number 73.
BNS, sir.
352 of
IPC.
BNS.
Yes, 76.
350.
BNS 76, sorry.
352
76.
BNS.
76, sorry, madam.
My lord,
76 of BNS.
I was the one who was assaulted, my lords. I produced the wound certificate, I mean, MLC report as well, my lords.
That's one.
Kindly, case
One
number
CGP, 2 emergent notice returnable by the 11th of December. Yes, next.
Yes, ma'am. Respond number 2.
Ilva, 120? ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಬರೀ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. ರಾಕೇಶ್ ಭಟ್ ಬಂದ್ರೆ ಕೇಳಿ. Next.
And 28.
Respond number 2, Gram Panchayat, Secretary of Gram Panchayat files a complaint before the police station.
Notice ಅಷ್ಟೇ.
No.
One
Him stay, ma'am.
CGP, 2 no.
They have annexure in, my lord. They are asking for the brain mapping of the petition number 2, my lord.
No, no, sir. Yes.
For petitioner 1 is she is also a member of the same Gram Panchayat, my lord.
Well,
And there is a
yes.
political rivalry between
List on,
secretary on
list on so and so. Yes.
a series of notices issued against the petitioner 1 and 2, my lord. Both are husband and wife, my lord.
So what? Yes.
And there is no
List on
name of the
11th
complaint
December,
or in the
yes.
FIR, my lord.
11th December.
129.
Would want to see the investigation papers.
Please, sir.
Registered the learned HCGP to secure the investigation papers conducted till date and place it before the court on the next date. List on Thursday in the fresh matters.
Great.
Yes.
130.
Commissioner,
Husband,
no, my lord.
were you in love?
Yes, my lord.
Ah.
And the allegation is that by suppressing the first marriage, my lord, sir, I have moved with the deceased. The photographs,
Charge sheet material ಎಲ್ಲಿದೆ ಪೂರ್ತಿ ಹಾಕಿದ್ದೀರಾ?
lords, page 28, 29 is a photographs part of charge sheet, which shows that the deceased was with the wife and children along with the petitioner. So there is no question of suppression of the first marriage and moving with her. Maybe, my lord, sir.
306.
Please,
Tomorrow. Right, tomorrow. Let's tomorrow in the fresh matters. ನೋಡ್ಕೊಂಬನ್ನಿ. Yes.
131.
Petitioner in this case, 354B, 323, 504, 506.
354.
Counter the matter earlier complaint, they have larger rejection. Civil suit also pending.
ಎಲ್ಲ ಒಂದೇ ಸರಿ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ? Heard the learned counsel H.S. Shankar appearing for the petitioner. The second petitioner, accused number 2, registers a private complaint against the complainant in PCR 7842 of 2023, which is referred for investigation. The moment the complaint is referred for investigation, springs the impugned complaint against the petitioner, alleging offense under section 354B as well. The finding no ingredients and finding no ingredients of the said offense apart from the fact that the crime itself is registered as a counter blast, albeit prima facie, there shall be an interim order of stay of further proceedings. So on. Next.
132.
Petitioner.
The offense is 420, 504, 506. Absolutely, there is no allegations against me.
You are appearing for whom, madam?
Respondent 1,
One.
Wait,
respondent number 2.
State.
Respondent number
Respond number 2. Complainant.
complaint. I'm actually a respondent here.
Correct.
State complainant party ಮಾಡಿ.
First in ಇದೆಯಲ್ಲ Ravi Kumar.
Ravi Kumar.
Which serial number is yours, madam? I think.
Okay, 140. It was a mistake.
142 earlier.
Yes.
Absolutely, there is no allegations against me.
A perusal at the summary of the charge sheet would indicate all the offenses against accused number 1 and 2. The petitioner is accused number 3, and no allegations that would touch upon the ingredients are alleged against this petitioner, finding therefore permitting further proceedings would become an abuse of the process of the law, albeit prima facie. There shall be an interim order. Next. Your A3 thane.
ಹೌದು.
Yes, next.
ಮತ್ತೆ
133.
Heard the learned senior counsel KG Raghavan appearing for the petitioner. A perusal at the crime so registered against the petitioners would indicate that the criminal law is sought to be set into motion purely on a breach of a joint development agreement between the parties. Permitting further proceedings against the petitioners would run foul of the judgment of the apex court in the case of Vijay Kumar Ghai versus State of West Bengal, reported in 2022, 7 SEC page 124. Therefore, there shall be an interim order of stay of further proceedings where the petitioners till the next date of hearing.
I
One
just want to point out one fact, my lord.
JDL.
My lord, no, my lord, there is in earlier, the same charge sheet, because I will not be able to go out to this court, my lord, with a light conscience, therefore I want to.
Dismiss
point-
ಆಗಿದೆಯಾ?
No, my lord, I want to point out, I'll tell you lordship what. My lord, there is an earlier criminal petition that had been filed, challenging the same charge sheet and taking cognizance. The court, my lord, said, I will quash the cognizance, and my lord, your lordship may kindly see the direction given.
Fresh orders after
Yes, have been
application.
passed. And fresh order has been passed, taking cognizance, my lord. Therefore, if the charge sheet is stayed, all further proceedings will also get stayed.
That's what I have.
That, no, I wanted to
All
point
further
it out to your lordship, my lord.
ಇಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಒಂದ್ ಪ್ಯಾರ ಬರ್ಕೊಳ್ಳಿ ವಿಜಯ್ ಕುಮಾರ್ ಗಾಯ
I will not be able to go out to this court with
The
a right
senior
conscience, my lord,
counsel at
that's all.
this juncture would submit that this very petitioner had knocked at the doors of this court in writ petition 1572 of 2024. A coordinate bench, in terms of its order dated 2nd April 2024, had quashed the order of cognizance and remitted the matter back to the hands of the concerned court to apply its mind and then take cognizance in the issue if warranted. The resultant action is what has brought the petitioner back to this court. In the light of what is aforesaid, and the fact that the further proceeding would run foul of the judgment of the apex court in the case of Vijay Kumar Ghai, the interim order is granted.
Yes.
34.
The due process of law, I obtained the injunction on 19/9/2022. Yeah, even after complying with notice also, the police also know that the injunction is granted.
Go to page 39, last two lines, accused number 5 and 6, I will not grant. See,
So,
page 39 gogi sir. Last 4 lines. Accused 1 to 4, no problem. Accused 5 and 6, I will not grant.
all are not family members.
No, no.
Hey, they with due process of law,
The
they have
petitioners
taken-
are before this court calling in question so and so. A perusal at the summary of the charge sheet would indicate independent overt acts alleged against accused number 5 and 6. Therefore, there is no question of grant of interim order qua accused 5 and 6. Insofar as accused number 1 to 4 are concerned, they are only alleged of instigation. Therefore, there shall be interim order of stay further proceedings qua accused number 4. 1 HCGP, 2 emergent notice.
they have obtained the injunction order to the
ಹಂಗಂತ
place.
5 and 6 ಆ ತರ ಮಾಡ್ಬೇಕು ಅಂತ ದಟ್ಸ್ ನಾಟ್ ಅ ಲೈಸೆನ್ಸ್. ಎಸ್ ನೆಕ್ಸ್ಟ್
135.
2 to 5 ಹಸ್ಬೆಂಡ್ ಇಲ್ಲ ಯಾರಿಲ್ವಾ
490.
4 weeks ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
136.
May be taken up tomorrow, your lordship.
ಕವರ್ಡ್
Petitioner. ಇದು ಕೋಕಾ
LSPP was attending this matter. There is.
ಆಯ್ತು ಯಾವಾಗ ಬೇಕು
ಸ್ಟಾಟ್ಯೂಟರಿ
Saturday? ಏನ್ ಸ್ಯಾಟರ್ಡೆ
ಅಲ್ಲ ಸ್ಟಾಟ್ಯೂಟರಿ ಬೇಲ್ ಇದೆ 190 days extend
ಅದಾ tomorrow list tomorrow in the fresh matters list. Yes, he is come. Next
37.
petitioners are A4 and A5, 498A in the meantime. Next
Grateful.
ಅಷ್ಟೇ ಅಲ್ವಾ
What's in the charge sheet, no, just A2 and A3.
A2 and A3
Grateful.
138.
My lord, I am a 14% petitioner. My lord, I am
ಮಾಡಿಲ್ಲ
ಅಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ
placed the documents, my lord, to show that no incident has happened. We given endorsement. And we filed a miscellaneous petition before the magistrate court. There also inquiry was held. If he's aggrieved, my lord, he can go and file a 200.
Private complaint haki.
My lord, can I make a submission, my lord?
File a private complaint, sir.
My lord, I will like to make a submission, my lord.
Ah.
My lord, in the BNSS, they have only allowed a preliminary inquiry. As per Lalita Kumari judgment, it clearly states a preliminary inquiry should be only be restricted to whether there is a cognizable offense or not. However, the police have come to the. My lord, can I
File
can
a
I make
private complaint in 223, sir.
No,
They
my
will
lord.
call.
No, my lord. There is a procedural error by the police as well as the
Learned,
magistrate.
Additional SPP is directed to accept notice, secure instructions, and make his submissions. Next, yes.
My lord, a date may be given, my lord.
A list on 20th December. Next.
My lord, a shorter date, my lord.
Parayala, avat bani. Next.
Yes, my.
139.
Respond number.
Student stay ಮಾಡೋಣ.
ಅಲ್ಲ ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. In fact, my lords.
ಅಲ್ಲ ಬೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ.
I don't know, bail is okay.
Yes.
But I'm only saying.
Heard
so-
the learned senior counsel K. N. Panindra appearing for the petitioner. Pending consideration of the issue on its merit, there shall be an interim order of stay qua accused number 12, owing to the age and no
ಅಲ್ಲ ಈಗ ಅದು ಸ್ಟೇ
direct allegation
ಸ್ಟೇ
against the
ಕೊಟ್ರೆ
petitioner.
ಎಂಟೈರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ ಸರ್.
It is made clear.
My property is registered in his name.
It is made clear investigation against other accused is not stayed. Yes.
ಅಲ್ಲ ಇವ್ರ ಮೇಲೇನು ಸ್ಟೇ ಕೊಟ್ರೆ ಈಸ್ ದಿ ಮೇನ್ ಅಕ್ಯೂಸ್ಡ್.
Yes.
Kindly see the entire charges, my lord. The serious investigation is going on.
This the matter on 12th December. ಅವತ್ ಮಾಡು.
ಅಲ್ಲ ಈ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಆಯ್ತು ಅಂತಂದ್ರೆ ಎಂಟೈರ್
ಬೇರೆಯವ್ರದ್ದು ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ ಈಗ ಸ್ಟೇ
Only
ಕೊಟ್ಟಿದೆ
accused
ಇದು
number
ಬೇಲ್
12.
ಆಗಿದೆ ಸರ್, ಬೇಲ್ ಆಗಿದೆ ಅವ್ರು.
Accused number 12. Yes, next.
140.
For the accused number 2, my lord.
A2 498A. Yes, next.
141.
Pene Vijay Kumar 5th. BB Patil serve ಮಾಡಿ.
No, there is no charge sheet is filed. my lord.
Same. Charge sheet ಹಾಕಿಲ್ಲ. Great. Next.
142.
For the.
ಏನಿದೆಲ್ಲ?
In this case, not. But the allegation is that, my lords, during
Viral,
the year
yeah.
2017-18, my lords, there were some documents.
You're ready?
Yeah.
I will pass it over. List ಮುಗಿಸ್ಬಿಟ್ಟು ತಗೊಂತೆ.
Please.
Yes. Pass over.
43.
Wife is the.
Settlement ಆಗಿದೆಯಾ?
Ali, California court, the child custody is going on. She brings the child here. So for the purpose of filing habeas corpus, I appoint a private detective. His statement also is
Private detective.
for the purpose of identifying where the child is.
Ah.
She files 354D for abatement of stalking.
1 HCGP, 2 emergent notice. The petitioner is the husband. The second respondent, his wife, the complainant. Plethora of proceedings are instituted against each other, not only in this country, but beyond the shores of this nation as well. A habeas corpus petition is instituted by the wife, in which the petitioner is said to have engaged the services of detective.
Private detective.
Private detective.
Is A2.
Huh?
A2 is.
Private detective, the accused number 2. Therefore, the petitioner is now alleged of stalking the second respondent complainant. The learned counsel for the petitioner submits that the person was engaged to get to know where the child was and not to stalk the complainant. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
Correct. Apply.
144.
Complainant wants to withdraw the complaint? Where? You are the complainant.
Please,
Yes.
I am the complainant, my lord. in
The
that,
petitioner is the complainant. Theft was the allegation.
Theft was the allegation.
The
my lord.
allegation, again, the complaint is registered for the offense punishable under section 37 BNS, BNS, section 309 of the BNS 2023, which is 379 of the earlier regime, the IPC. after the registration of the crime, it transpires that the articles were found
Found
and therefore wants to withdraw the complaint and withdraw the complaint. That in the light of the aforesaid circumstance, the complaint against the complaint so filed so and so is
Accused are
Quashed
not named,
forward.
my lord,
Huh?
please. Please,
in that light, the accused are not made parties anyway.
please.
In
Not
that light, the
named also.
complaint is quashed.
Please.
Yes.
Grateful.
Next.
45.
For the respondent, my lords, need to take
The
instructions from the department.
What instruction, sir? Predicate offense ಏನಾಗಿದೆ?
ಸ್ವಾಮಿ
Predicate offense ಏನಾಗಿದೆ?
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೋಟಿಸ್ಗೆ ನಾನು ಏನ್ ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕಾ ರಿಪ್ಲೈ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ವಿತ್
ಹ್ಮ್.
ಡಾಕ್ಯುಮೆಂಟ್. CGST ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರು. CGST ನ ಸೇಮ್ ಕೋರ್ಟು ಆಲ್ರೆಡಿ ಅದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೆ. ಅದಕ್ಕೇನಿದೆ ಅದು 13 lakhs ನಾನು ಪೇಮೆಂಟ್
Take instructions day after tomorrow in the fresh matters list. Yes, next.
146.
Essential commodities. No representation for weeks.
47.
The petitioners are before this court calling in question proceedings in so and so. The alleged offense is the one punishable under section 341 of the IPC inter-alia. A perusal at the summary of the charge sheet would not indicate the ingredients of section 339 to be met for it to become an offense under section 341 of the IPC. Therefore, there shall be an interim order of stay of further proceedings. Next. Civil suit number,
Civil suit number OS in
you are in possession.
3-2 of the.
You are in possession.
I sought a possession, my lord, but the complainant has sold the property, my lord.
ಅದೇ ಬೋರ್ಡ್ ಹಾಕಿದಕ್ಕೆ ತಾನೇ ಇದು.
We have not done anything. Well, similar, other person also gave a complaint. Lordship has stated that, my lord.
Different crime, same crime.
Say different crime, my lord. Some other person has gave the same complaint, my lord. Lordship has stated it.
ನೀವು ಇದನ್ನು ರೆಫರ್ ಮಾಡಬೇಡಿ. In the meantime, yes,
Please.
next.
Complaint.
149.
Different complaint.
Complaint, second respondent.
But I am for the petitioner.
Hmm.
First, my lord, the Kodiyalli police will register a case for robbery. Thereafter, my lord, when he is in custody, another complaint is registered. In the complaint, he
Yes,
states,
robbery ಅಂದ್ರೆ mobile theft.
mobile theft. Then another complaint is registered. ಬೇರೆ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸ್ಬಿಟ್ಟು 9 ಕೋಟಿ ಅಲ್ಪಾ ಎಂಟರ್ಪ್ರೈಸಸ್ ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ. ಐ ಹ್ಯಾವ್ ನೋ ಕನೆಕ್ಷನ್ ವಿತ್ ಅಲ್ಪಾ ಎಂಟರ್ಪ್ರೈಸ್.
ನೀವು ಬರೀ ಮೊಬೈಲ್ ಕದಿಯೋದು ಅಷ್ಟೇನಾ?
ಅಲ್ಲ, ದೇ ಆರ್ ಬಿಸ್ನೆಸ್ ಪಾರ್ಟ್ನರ್ಸ್. ಅವರೇ ಹೇಳ್ತಾರೆ 92ರಿಂದ ಗೊತ್ತು ನನಗೆ, ನಾನು ಇಬ್ರು ವ್ಯವಹಾರ ಮಾಡಿದ್ದೆ.
There are other 2 criminal petitions on this honorable court.
My lord, he himself is indulged
Number
in
ಕೊಡಿ.
several.
8 criminal petition 4649 of 2024.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಕೊಡಿ, ಅದ್ ನೀವು ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
ಎಲ್ಲ ಅದು ಹಾಕಿಲ್ಲ.
ನೋಡಿ ಯಾವ್ದು.
ಈಗ ಅಗೇನೆಸ್ಟ್ ಕಂಪ್ಲೇನೆಂಟ್ ದೇರ್ ಆರ್ ಮಲ್ಟಿಪಲ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ. ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಫ್ರಾಡ್ದೇ ಇದೆ, ಇದರಲ್ಲೇ ಇದೆ, ಪೇಜ್ 40.
ನಂಬರ್ಸ್ ಕೊಡಿ.
Yes.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಆಗ್ಬೋದು.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Lordship, kindly give me 2 weeks time.
28, yes.
Much.
Next.
150.
ಫೈಲ್ ಬಿಟ್ಬಿಟ್ಟಿಲ್ಲ. ಇರ್ಲಿಲ್ಲ. ಇದು ನಾಳೆ ತಗೊಂತೀನಿ. ಫೈಲ್ ಬಿಡ್ಬಿಟ್ಟು. Please tomorrow, fresh matters.
151.
ಸಮನ್ಸ್ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಕೊಟ್ಟಿಲ್ವಾ? ಸಮನ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ, summons ಕೊಟ್ಟಿಲ್ಲ.
Proclamation without summons.
It requires at this place satisfaction that served, he is not appeared. All I would request, my lord, dismiss, set aside, and the direction will be given to him. He will
To
appear.
execute
He will appear.
proclamation.
He will appear and take back. That's the only point.
The next date.
February ಹೋಗಿದೆ. No affidavit, nothing.
ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ಅಷ್ಟೇ.
Day after tomorrow.
Very well.
We'll dispose it.
Fresh matters.
Fresh matters ಇಲ್ಲ.
152.
The council can day after tomorrow.
Next Monday, fresh matter. ಮೇಡಮ್ ಇದರಲ್ಲಿ CBIಗೆ ಅಥವಾ ಬೇರೆ ಏಜೆನ್ಸಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಯಾಕೆ ಅಂತ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. Why, what is the fault in the investigation? Is a complaint
498A.
498. Yes. List next Monday in fresh matters list.
153.
Petitioners are husband and mother-in-law and father-in-law who are before this court calling in question the proceedings in before the concerned court instituted by the wife invoking provisions of the Domestic Violence Act, finding no ingredients of those offences against petitioners 2 and 3, there shall be an interim order of stay of further proceedings qua those petitioners, not against the first petitioner, the husband.
Shivram may be taken because he's appearing. in other
No, no,
court.
husband I will not give.
At least your lordship may refer the matter to the mediation so that.
Adu barli, let the wife come, we'll refer it. Emergent notice to the respondent returnable by petitioner is at liberty. Emergent, apart from taking out steps, the petitioner is at liberty to serve on the counsel who represents the wife before the concerned court. Next.
154.
The petition of this one.
Where are the dry fruits? 60 lakhs.
Also,
Yes.
all has been
Illa
repaid.
dry fruits kodi, illa 60 lakhs kodi.
No, the emails may kindly be seen that all the amount has been paid back.
Paid
repaid.
back.
Yes, it has been repaid. He has directly received it from Amazon. He has not paid me any amount. He has paid it to Amazon and Amazon has paid it back to him. My lords may kindly see, I am only a person who can introduce him to Amazon platform for sale. No amount is paid to me directly. All the amounts he has paid directly to Amazon, and kindly see page number where he himself accepts that he has received the amount. The acceptance is there in all the email thread which is produced.
Get the complaint then.
Please, my lords.
Get the complaint. 1 HCGP 2 emergent notice. Petitioner shall also serve the complainant by way of hand summons just on 5th December. Hand summons barala idralli, criminal case anyway. Take out steps, we'll see. Yes. Next.
155.
What prayers are these? File an appeal.
No, my lords, only the prayer is application is kept pending, my lord, since more than a year. 15 hearing dates. No order is passed, that's all, my lords. 15 hearing dates, my lords. Your lords may kindly synopsis, my lords. It was posted for orders on 9/2/2024, synopsis page number 2. Your lords may kindly, my lord, direct the, my lord, concerned registrar, my lord.
Heard the learned petitioner is before this court seeking the following. Ishton prayer is there?
As only a speedy disposal. Main is to pass orders on the application which is pending, my lords. 15 hearing dates are there.
Seeking the following prayer. The learned senior counsel, the petitioner is the husband and the respondent wife. The wife files application invoking section 12 of the Domestic Violence Act 2005 on 22/4/2019. The proceedings have gone on since then, and all the applications appear to have been kept pending, and 15 adjournments are granted without any rhyme or reason. The learned senior counsel would submit that these proceedings should conclude as expeditiously as possible is what this court has held time and again. In that light, I deem it appropriate to direct the concerned court to dispose the applications pending in the case at hand after in accordance with law, at any rate within 3 months from the date of receipt of the copy of this order.
That's the main petition. My lord, the petition itself is posted for orders, 15 hearing dates are given. 9/2/2020, posted for orders, my lords.
The learned counsel,
Nine.
learned senior counsel again would
On 25/2, application under
take
section
this court
25/2.
to the order sheet to demonstrate that the matter is posted for orders on 15 occasions and no orders are passed. Therefore, orders shall be passed as it is being posted for orders within 2 weeks from the date of receipt of the copy of this order. Munchina order beda.
Please. On section 25/2, my lords. Order.
Whatever, on the applications pending, yes.
Please. Grateful.
Next, ordered according.
156.
Forest Act.
Please, my lords.
Learned additional SPP is directed to accept notice for the respondent. Friday?
My lords, here interim order has already been granted on Friday. Last Friday it was listed. Interim order is already granted.
Interim protection.
Interim protection.
That's what, list on Friday in the fresh matters list. Next.
Interim order to continue.
Interim protection subsisting will continue till the next date of hearing.
157.
The petitioners are before this court calling in question so and so. A perusal at the contents of the complaint would clearly indicate that a seemingly civil dispute is projected to become, is given a color of crime and the criminal law is set into motion. Permitting further proceedings against these petitioners would run foul of plethora of judgments of the apex court on the issue. Therefore, there shall be an interim order of stay of so and so till the next date of it. 1 HCGP 2 emergent notice.
158.
Apartment.
Please. It's squarely covered by my lord's order.
Kodtholid. The learned counsel Nishant AV submits that the issue in the list stands answered by judgment rendered by this court in so and so. In that light, there shall be an interim order of stay of further proceedings with these petitioners till the next date of hearing. 1 HCGP 2 emergent notice. Next.
59.
I am for the petitioners in this case.
Sir, we'll direct CBI to take notice first.
Please.
Yes. Counsel
ಆಮೇಲೆ
P. Prasad.
one more submission.
Yes, sir.
May I request your lordship to kindly turn to page 147 for a second. Typed copy of the order on 5/11/2024. The FIR is filed on 29th of June 2024. I don't know why this habit has been continuing merely. They put the FIR in a sealed cover. They will file a memo, don't disclose it to anybody. They will not give the copy of the FIR to us at all. It is unfortunate. In most of the courts, these things are happening.
Particularly in CBI, I guess.
Particularly in CBI. Why? But sealed cover, the Supreme Court has time and again
Let me
said
see.
because now I was constrained to file this petition, my lord, solely on the basis of the pro forma FIR, without even having the advantage of a complaint.
We'll hear Prasanna Kumar. Counsel heard the learned senior counsel C.V. Nagesh appearing for the petitioner. Counsel Shri P. Prasanna Kumar, representing the Central Bureau of Investigation, is directed to accept notice for the respondent. Petitioner to serve, the advocate on record to serve requisite set of papers upon the counsel. List the matter on 29th in the fresh matters list. Yes.
160.
Hearing for the petitioner.
307, sir.
Lords, 302. I'm not seeking quashing of the order, my lords.
What the?
Lords, appointment of SPP.
Oh,
Appointment.
ಇದ್ರಲ್ಲಿ ಬರಿಬೇಕು ಅಂತ
Please.
ಮಧ್ಯಾಹ್ನ ಬರಿ. Yes. Idrallen, what's the allegation? Remuneration is paid by complainant or what?
Remuneration is paid by the father of the deceased victim, my lords.
ಆಮೇಲೆ
And the father, my lords, says that he is well known to the person who is being appointed. He is well known and close friend of the deceased victim.
ಇದ್ರಲ್ಲಿ ಮಧ್ಯಾಹ್ನ I will write. Yes.
161.
A1, A2, A3. In the meantime, what's next? ಇದಲ್ಲ 498. ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. The petitioners are A1, A2 and A3, finding no ingredients of the offences alleged against them, there shall be an interim order of stay of further proceedings so on to the next date of hearing. Next.
62.
Drugs and Cosmetics Act.
Yes.
1 HCGP. Ibru HCGP.
Yes.
This is a matter on 11th December in the meantime. Next.
Great.
163.
How much money you have taken, sir?
I have not taken any.
Who has taken, sir?
Sir, the other accused 1 and 2 have taken.
Give back, sir.
I am not.
Don't doubt.
No, I am not even part of the entire thing. Kindly see the allegation made in the complaint.
Yes, sir.
Now, kindly see the allegation.
ಎಷ್ಟು transaction ಏನು? How
No,
many?
I have not taken a rupee from.
What's the transaction?
I have no idea. My transaction is only with the
Then we'll
society.
get the idea from the complainant. 1 HCGP, 2
Sir,
emergent note.
my transaction is.
If you have
only
no
with the
idea,
society
we'll
where
get the idea.
I was, now kindly see the emails. I was only to give them a loan to the
Sir,
society.
you are the mediator for the loan.
No, I'm not the mediator for the
Then
loan.
what?
I am the mediator for in respect of the society and the bank.
1 HCGP, 2
No.
emergent notice.
My lord, kindly see the email communications.
Barley, let the complainant come.
My lord, if a date could be fixed, my lord.
Returnable by 17 December. Yes.
My lord, until then,
No, no.
let the petitioner not be arrested at least. my lord.
Why, sir? Bail ತಗೊಂಡಿಲ್ವಾ?
Bail illa, my lord.
ತಗೊಳ್ಳಿ.
Let the petitioner not be
No, no.
arrested till then. Grateful.
Yes, ಹಿಂಗೆ ತುಂಬಾ ಜನಕ್ಕೆ ಆಗಿರುತ್ತೆ. Yes.
64.
My lordship, challenge the 125 proceedings. my
Huh?
lordship. 125 proceedings, 145 proceedings, my lordship.
145, there. Yes, in the meantime. ನಾನು 125 ಎಲ್ಲಿ ಬಂತಿಲ್ಲ.
Sorry,
Yes, next.
it may be fixed.
165.
Respondent number 2 is also government, my lordship.
ಗೊತ್ತು emergent notice, HCGP accepts notice for both the respondents. In the meantime, ಅಷ್ಟೇ. Yes,
Date
next.
may be fixed, my covered by judgment. my lordship.
Covered?
Yes, my lordship.
ಕೊಡಿ. Yes, madam. Close, disposed.
165.
Take it on Friday, investigation papers. HCGP is directed to secure the investigation papers and place it before the court. List on Friday in fresh matters.
Question 166.
Petitioners.
Hoysala.
Crime 65 of 24 was registered against petitioners who are accused number 1, 2, and 3 respectively. The accused number 4, named Banu Prakash, he has appeared before this honorable court earlier in serial number 92.
Yes, the matter. Tomorrow in the fresh matters list. Yes, first time ಬರ್ತಾರೆ.
ಹೌದು.
List tomorrow in the fresh matters. Next.
Orders 167.
The council seeks a week's time to comply with the office objections. Yes,
168.
a week's time is granted. ಕೆಳಗಡೆ SJK. Week's time. Seeks grants. Yes. Maintainability. Second petition ಹಾಕಿದಾರಾ? Oh, 14-2, yes. ಏನ್ ಚಾಲೆಂಜ್ Release anticipatory bill, appeal. Yes. The office objection stands sustained. List of 2 weeks. The office objection is with regard to, the counsel for the petitioner seeks the following prayer. The prayer is for grant of an anticipatory bail for it having been turned down by the concerned court. Against the said order, a petition under 482 would not lie, but an appeal under section 14(2) of the Atrocities Act has to be preferred. In that light, the petition stands disposed, reserving liberty to the petitioner to avail of the remedy of filing an appeal ordered accordingly. Next.
69.
Lords, I appear for the petitioners. In this, my lords, the matter was listed on 11th of this month, my lords, under the head orders along with council submission. It was to be listed today under the head fresh matters, my lords. When I open the daily orders, the emergent note, it shows that the emergent note is.
ಅದೇ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಿ ಬರ್ಬೇಕಾಗಿತ್ತು.
ಹೌದು.
ಆಯ್ತು ನೋಡಿ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್.
170.
Yes,
Lordship, this is also same lordship, sought for interim order, lordship. Lordship, on that time, lordship, council
submission ಬಂದಿತ್ತ?
Council submission has word and list on the press matter ಅಂತ ಹೇಳ್ತೀನಿ. Notice order ಆಗಿದೆ ಅದಕ್ಕೆ.
Same day after tomorrow, fresh matters. Yes. Invigilator extra ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
171.
Madam, ಅದರ
For petition.
ಬರ್ಲಿ, no notice was issued.
That's 439, my lords, by mistake only it has been listed before.
ಇಲ್ಲಿ ಹೆಂಗ್ ಬಂತು ಮೇಡಮ್?
My lords, by mistake only, my lords.
ಎಸ್. ನಾನ್ ಮುಂಚೆನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ನ ಇಲ್ಲಲ್ಲ? The matter appears to have been posted before this court out of inadvertence, lest the matter before the bench having appropriate roster, urgency ಇದೆಯಾ?
1
Appropriate
week
roster,
notice.
yes, next.
Hearing on IA 172.
306 is offense. Last time you were not directed to file the entire charge sheet minutes. I have filed it on Saturday.
ಎಲ್ಲಿದೆ?
I have filed the notes on Saturday.
First day after tomorrow in the fresh matters list. The registry is directed to put up the charge sheet material that is placed, said to have been placed by the petition. Next.
Great.
Voting settlement 173.
My lord, 490 offense, my lord. Mediation settle ಆಗಿದೆ. Page number 69 and 70, my lord.
ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
Mediation ಅಲ್ಲಿ, sir. My family, decree of divorce also granted, my lord.
Separation, reunion.
No, my lord, separation, divorce, my lord. 69 and 70, my lord.
Page?
69 and 70, ink page.
ಬರೀ ಆ paragraph ಮಾತ್ರ.
I need to pay 2 lakhs DD, my lord. I am handovering the 2 lakhs.
Last ಅಲ್ಲಿ. Counsel for the petitioner hands over a demand draft of rupees 2 lakhs, which is acknowledged by the respondent wife who has appeared in person. In that light, disposed first.
Obligations.
Order sheet.
All other conditions fulfilled?
All the conditions fulfilled, my lord.
Next.
174.
Hearing for the petitioner, your lordship. Your lordship may kindly pass over the matter.
Why, sir? Settlement. Oh, pass.
Yes, yes, sir.
175.
Respond number 3, madam. Settle the notice of settle.
Offense?
490.
498, yeah, madam.
I mean, permitted to kindly file compounding application on joint. And also wakalat, madam.
Counsel sons, ನೀವು
R2, madam.
Lordship be kindly permit to file wakalat, NOC wakalat.
ಏನು
ಅವರು ಗೌತಮ್ ಮೇನ ಈ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತಾಯ್ತು. Counsel so and so enters appearance in place of Gautam AR. Registry to delete the name of Gautam AR and print the name of
Ravi JS.
so and so. First ಅದ್ ಮಾಡ್ಬಿಡಿ. ಆಮೇಲೆ mediation ಆಗಿದೆಯಾ?
ಆ mediation.
Page?
ಆ mediation ಕಾಪಿ ಇನ್ನೂ ರಿಲೀಸ್ ಆಗಿಲ್ಲ ಸರ್.
Anyway, joint memo ಇದೆಯಲ್ಲ.
ಜಾಯಿಂಟ್ ಮೆಮೋ ಇದೆ.
ಅದ್ರಲ್ಲಿ ಹೇಳಿದಿರಲ್ಲ?
ಹೇಳಿ.
ಕಂಪೌಂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. ಆಮೇಲೆ ಅದನ್ನ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. Yes.
Parties present. Please. Sign us.
Order sheet signature.
ಆಗುತ್ತಾ ಮೇಡಮ್?
Passed over matters.
That I'll take it 2:30. OE Corporation.
Bill number 60. Little.
ಕೊಡಿ. Split chart sheet, ಯಾರು appear ಆಗಿದೆ? ಇವಾ? The petitioner, accused number 2, is knocking at the doors of this court, calling in question the continuance of proceedings in CC 1932 of 2014 registered for offense punishable under section 399 and 402 of the IPC. The petitioner is a petitioner accused number 2, along with others, gets embroiled in a crime number 334 of 2012 for offenses punishable under section 399 and 402 of the IPC. The police, after investigation, file a charge sheet. The petitioner at the relevant point in time was not available for trial. Therefore, the concerned court draws up a split charge sheet against the petitioner and tries the others in Sessions Case 206 of 2014. The concerned court, in terms of its order dated 11th December 2014, acquits all the other accused except the petitioner on the score that the petitioner was not available for trial and a split charge had been drawn against him. The reason rendered for the acquittal of others by the concerned court is the prosecution failing to prove the guilt beyond all reasonable doubt. The reason so rendered can be gathered from paragraph 15 to 15, 16, page 76 to 79 extract. In the light of the learned HCGP, though would vehemently refute the submission to contend that the petitioner who has escaped trial should not be shown any indulgence, and the petitioner should come out clean in a full-blown trial as others have come out, would though merit acceptance, the issue is the petitioner would eventually get acquitted of the offences, as the other accused have got acquitted on account of the prosecution failing to prove the guilt beyond all reasonable doubt qua evidence. Evidence that was not available qua other accused cannot spring against this accused if trial is permitted to be continued. The trial, if permitted to continue, would only be waste of precious judicial time. Therefore, to save precious judicial time, I deem it appropriate to entertain the petition and obliterate the proceedings against the petitioner. The view of mine, yes. Next. Innೊಂದು split ಇತ್ತಲ್ಲ?
42 selected matters.
142. Yes, Prasanth.
Yes.
ಅವರು ಮೇಡಮ್ ಇದಾರಾ?
ಇದ್ದಾರೆ.
Yes.
Respondent number 1.
Yes, madam.
This is the case where, my lords, there are 5 petitions, my lords.
Hmm.
Initially, my lord, the first respondent filed one complaint, my lord, against the accused number 2, the petition number 2 alone, my lords, before the jurisdictional police. Lord, the jurisdictional police, my lords, after conducting inquiry, my lord, issued an endorsement saying that the dispute, my lords, is civil in nature. Then, my lord, the first respondent, my lord, filed a complaint before the commissioner of police, my lord, vide Annexure G, my lords, on 8/5/2023. Annexure G, alleging that, my lords, during the year 2017-18, my lord, the second accused, my lord, created some documents so as to see that a premises, my lord, has been taken, my lord, on rental, my lord, by the first respondent when he was a director of the first respondent company. And in addition to that, my lord, the accused number 1 in the first petition, my lords, is shown to be a service provider, and a bill has been raised to pay the service charges. But as a matter of fact, there are other directors who are actively participated in the affairs of the company. They were not arrayed as not parties, not in the complaint Annexure G. Only a complaint is against the accused number 2, petition number 2, for which, my lord, the commissioner of police, my lords, referred the matter to the jurisdictional police, my lord, RMCR police. Lord, before the commission, my lord, the petitioner, second petitioner, my lord, filed a detailed objections, my lord, reply, offering explanation as to how, my lord, the bills were raised and who are the persons, my lord, consented for raising such bills, and who was the account manager who raised the bill, my lords. Then, my lord, RMCR police, my lords, have also issued an endorsement stating that, my lord, it is the dispute civil in nature. Then, my lord, the first petition respondent filed independent private complaints against, my lords, all the directors of 4 companies, as well as, my lords, the first petitioner, who is the service provider to the first respondent. Lord, the other directors, my lord, were no grievance against the petitioners. since 2017 onwards. Only when not the person who is entered as a director in the year 2021, not up to waiting for 2 years, not lodge the present complaint before the learned magistrate, alleging not some documents said to be created by the petitioners. There is no allegations against other directors of the petitioner companies. And kindly see, earlier, one Mr. Rohit Garg was the executive officer of the company, and later his wife also joined as a director in the year 2016. Then the second accused who was a visiting director used to participate in the affairs of the company. The second petition is not the active director of the first respondent company, but complaint is only against him. That too filed after 5.5 years from the date of alleged incident. Commercial suits have been filed by the petitioners against the first respondent, in which also the other directors were appeared in the first instance and filed written statement. Then they had no grievance against the petitioner. Only when the complainant who entered into the directorship on 27/9/2021 claimed that he has noticed some malpractice in creation of documents, and therefore the complaint is filed. Kindly see the complaint.
Page 36.
Please, page 36. That is page 36 so the suit plaint filed by filed by the petitioners. Yes,
Page 36 is Fox-based technologies.
Yeah,
I
page 31.
What is the complaint, sir?
referring
The PCR, what?
PCR, correct. It's PCR.
there are 5 petitions, sir.
I am holding 27695.
9.5.
Page 29 complaint commences. Then 2930.
29, yes, 29. Relevant page,
Come to paragraph 7, sir.
Please, paragraph 7, it is available, page number 31, 31. The complainant came to know that the 2 purchase orders were created by the accused dated 1/4/2017 and 1/7/2017, raised 2 purchase orders upon the complainant on 1/3/2018
and 31/3.
respectively for a sum of 4 lakh and 14 lakhs. It is very clear that the purchase orders is only an offer prior to the purchase of goods by the prospective buyer from the prospective
Yes,
seller.
madam. All right.
Yeah,
Yes.
question of purchase order will not arise in the 4 matters, Your Honor. They are seeking for the rent. They have
Who
raised,
is seeking rent?
they are seeking a rent. They're considering that we have taken a lease of their property, and all 4 companies, they say for the same
It's all-
schedule.
You are before the commercial OS.
Whatever
620.
he has filed for the recovery.
Ah.
I'm not representing in commercial space.
That's all.
I am only onto the PCR and
Fox base is also a.
Yes.
Fox base here. I
Is
would
a
like to
defendant there?
elaborate, Your Lordship. First thing, the petitioner 1 was a previous director and who was a managing director of the company.
Now, what
And-
is that you allege? 2 purchase orders are created on 1/4/2017 and 1/7/2017. You got to know of it on 1/3/2018. Correct?
I came to know only when they filed the suit.
Correct.
Prior to that, I was not aware.
1/3/2018 you came to know.
Yeah.
Is that correct?
2018, when they actually process were happening, they were not knowing what's happening.
No.
Yeah,
It's
correct.
your complaint is that it is those 2 purchase orders you come to know on 1/3/2018 and 31/3/2018.
It is not just two, it was around 8 purchase orders.
All
in a
right,
different-
all in the year
different case.
2018 you come to know.
And they are claiming the rent for the same premises by different companies of their own, where all the companies where petitioner number 1 was the director. So he has actually fabricated all the document after resigning from the company, prior to the resigning of the company.
When did you resign?
My lord, 2019, my lords, TDS being deducted, my lords, from the 2017 itself, my lords.
When did you resign?
Please,
sir?
my lord, resigned, my lord,
2010,
my lord, 2019, my lords.
2019 he
19.
resigned.
Hmm.
Prior to that, TDS have been deducted by him only. He is the approver, he is the payer. Actually, the normal tendency in the company, Your Honor, one will be an approver.
After
one
resignation, what he has claimed again rent?
No.
He has not claimed any rent and he resigned from the company. He said full and final settlement and exit the company.
All right.
Okay. We were not knowing after the COVID, all of a sudden comes up with the suit saying that you are expected to pay this much money. Where we were little surprised for the same Vasant Nagar property from 4 different companies, he is claiming a rent of 40,000.
You file your objections, madam.
That will
You
be.
file synopsis, Aki.
Please.
The petitioner to file a short synopsis of the issues in each of the petitions, as they are 5 in number
4 weeks time.
and appear to be intertwined. The counsel for the respondent is permitted 3 weeks time to file statement, 2 weeks time to file statement of objections. List the matter on 18th.
Till then, my lords.
Not till then.
My lord,
No.
kindly see annexure J, my lords.
List
All
on,
the, my lords,
list on
properties
18th.
are standing in the name of all the, my lord, 4 companies, my lords.
Yes.
They are the owners, my lords. Till then.
List
entry,
on
my lord.
18th.
Otherwise-
One single paper saying that I have taken on lease. That I want. That's all. If that is provided,
List on-
nothing like
List
it.
on 18th. Yes.
Please.
ಎಷ್ಟಿದೆ ಇದು? ಯಾರು ಇಲ್ವಾ ಈಗ? ಇದು ಫೈಲ್ ಕಳಿಸಿ. Yes, we come back at 2:30. ಮುಗಿದೋಯ್ತು.
Hello. Hello.
Yes. But this is a matter where a serious situation has arisen.
ಇವ್ರದ್ದು ಬೈ ಫೈಲ್ ಬಂದಿದೆಯಾ 306?
Yes, ಬಂದಿದೆ. Yes.
Yes. The victim here has committed suicide in view of the.
Which petition is that?
Criminal petition
8640.
23.
86?
40.
40, 8640.
ಅದ್ ಕೊಡಿವಿ.
But this was a petition where.
As far as I remember,
Yes.
I permitted investigation to be
Yes.
continued and charge sheet not to be filed without the leave of the
Yes,
court.
yes. But after that, what has happened? Rightfully so, my lord, because there were some public ramifications and public money involved, your lordships had directed. After
Yes.
that, yes, after that, what has happened? The IO was, a new IO came in September 23. The present.
After my order?
Yes,
No.
my lord.
Before the order.
A new IO had come, new IO had come. But after your lordship's order, I think when was that order? 29?
24/9.
24/9 was your lordship's order. my lord.
After that 13/11, we filed an affidavit.
Then what happened? Repeatedly, she started harassing, the IO was a lady, DYSP. Repeatedly, she started harassing this young lady, Lord advocate. In view of this,
She was an accused in that.
she was an accused.
Accused number?
Eight.
Okay.
But apparently, the main dispute is on a very narrow compass, but that I'll come later. Now, not what happened when she was going there regularly, there was insinuations, allegations made against her character, against her family, against her reputation, saying that you come from such a family, you are such a person, you are of a degraded character. Immediately, and she used to torture her. Immediately, what she did on 6/11, on the advice of her counsel, because she was his junior, Mr. Jeevan Kumar's junior. She was also an advocate. She has filed wakalats also in his office. They say that she was not an advocate at all. That is what.
No,
some
we
of
didn't
it
say they
they
are an
said.
advocate, but we
She-
said
she
that
has
there's something.
filed
I'll get back to
Wakala.
Hello.
Yes. In the meantime, what happened? An affidavit came to be filed, dated 6/11, filed on 13/11, before
What affidavit?
this honorable court, my lord.
Narrating
An
all the
affidavit
allegations.
narrating all the allegations. That
Affidavit.
affidavit, my lord, I'll just read that affidavit
Tell
dated
it,
13/11. In this same.
Part of the record here?
Yes,
It is filed on 13/11.
13/11.
After the date which my lords fixed.
And this affidavit reveals the reason why she had to.
Even ನೀವು ಹಾಕಿರೋದಾ?
Jeevane, the deceased filed the affidavit. She was a petitioner in that petition, criminal petition 8640.
8640 ಅಲ್ವಾ? ಓ ಇದೇನು? ಇದು ಅಪ್ಲಿಕೇಶನ್.
ಒಂದು affidavit ಇದೆ. Dated 13/11. Court seal is 13. Lord, shall I hand over?
ಕಾಪಿ ಕೊಡಿ.
Yes, the sealed copy.
ನಮ್ಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
ಇಲ್ಲ ನೋಡಿ
Copy ಇದೆಯಾ?
ಅವ್ರು ಕೊಟ್ಟಿದ್ದು
ಇದ್ರೆ ಕೊಡ.
ಕಾಪಿ ಸರ್ ಮಾಡೇ ಫೈಲ್ ಮಾಡಿ. ಸರ್ ಮಾಡೇ ಫೈಲ್ ಮಾಡಿ.
ಇರ್ಬೇಕು.
ಆಫೀಸಲ್ಲಿ ಇಲ್ಲ, ವೆರಿಫೈಡ್ ಇಟ್.
ಆಯ್ತು, ಕೊಡಿ ಇವಾಗ ಇದೆಯಾ ಇನ್ನೊಂದು copy?
ಏನಿದು? affidavit.
This is
ಈಗ
the affidavit filed by the deceased.
Jeeva, yes, is the advocate who's committed
Yes,
suicide.
who committed suicide. She is the one. But here, kindly see, Lord, paragraph 3, from 3 it starts. She seems to narrate gives a clear picture of this harassment and torture up to that date. Shall I read, Lord?
Yes, yes.
From para 2. On 26/9/2000, the Sound Court directed the investigating officer to continue the investigation, submit a progress report by 30/10/24. I am fully committed to cooperating with this process and ensuring that investigation is conducted fairly and transparently. I state that I have been involved in the investigation process for the past 1.6 years, through which I have provided my statements and documents to the previous investigating officer, Shri A.D. Nagaraj and Muhammad Rafi. I have been verbally summoned without formal notice and have appeared on the following dates, 15th and 24th October. My consistent adherence to these summons intimation demonstrates my commitment to cooperating with the authorities throughout the investigation and set following.
Sister is also an accused?
Sister is not an accused.
She is. She's also an accused.
Is that?
All right, yes.
Yes.
He was not an accused on that day.
On that day,
She
it
was not
appears.
All right,
Nice.
yes.
Then Lord, on 9/10/24, accused number 7, that is Yashaswini, by the instructions of the IO, informed me to appear before the IO as per the High Court order dated 26/9/2024. Following this, I appeared before the IO on 15/10/24. During this session, the IO posed personal and inappropriate questions, such as inquiring if an individual name is my father, which was harassing and irrelevant. Although I had already provided all necessary documents and statements to the previous IO, the current IO continued to ask questions regarding my family background and integrity, which I believe were intended to insult and malign my character. As per the accused number 7 mentioned that to collect the documents from the previous IO to collect the documents regarding so-and-so, I visited the previous IO and so-and-so. I was asked by the IO about me and my sister's living arrangements in a manner that was inappropriate and harsh on 15th of October. I gave the documents, but told me to collect the documents was given to previous IO. I stated that on 24th October, I presented before the
This
IO.
is affidavit is dated 6/11/2024.
Yes, but actually filed on 13/11.
What is the date of death?
Date of death is 22nd 22nd March.
22nd November.
22nd. Yes. I state that on. Yes.
Yes, sir.
Ninth paramount. I state that on 24th October.
Yes, I have seen.
Yes, presented IO. I know how to get. So, Lord, she narrates all the issues of these harassment. 13.1, Lord. I'll just take your Lordship's attention. I state that throughout my appearance, IO has posed irrelevant and personal questions seemingly designed to assassinate my character and tarnish my family's reputation. Such questions are improper and I have caused. Now, Lord, this was one stage, pre-affidavit stage. After this affidavit was filed in 1311, that is when there is a sudden escalation in the harassment and torture.
Where do you get that?
That not in the death.
The death note.
Death note, which
Yes,
is
death
of 11 pages death note.
Death note is, yeah? I have.
Very serious allegations where she has been stripped.
Who is stripped?
Stripped. Totally
been
stripped without the brawls. That is what the sister says.
The IO.
The IO
has done that.
IO has done this. Stripped.
That's in the death note?
That's in the death.
And the other petitioner in the other petition has also been stripped. In that regard also, I'll file an affidavit.
And the very inhuman incidents that have occurred.
Really, death note is there?
And it appears, my lord, she has signed the death note every page, given the page number. That's what 11 pages death note.
Yes, Jagdish.
Yes.
You have removed her undergarments also. What is the investigating officer trying to achieve?
Right.
Are you carrying cyanide and what is all this?
All I can say, my lord. All I can say, my lord, we have made an allegation against them before this court in the last date of hearing.
They are not cooperating.
They are not cooperating. One. Second, even though we have not asked them, they have come to the CID office and taken a passes to enter into CID office and remain in CID office without meeting. IO has gone back. And thereafter, my lord, entire videograph after pursuant to your lordship direction, we have recorded the entire investigation, interrogation with them. All these things are there. But I must say, my lord, the allegation which they're making, that now there is an allegation, my lord, but we have to meet that allegation.
There is an allegation.
There is an allegation which we have to meet.
The allegation is very serious.
Very serious. We'll have to.
How can you strip a lady?
It is, I say, my lord,
Your allegation, you're investigating into corruption or corruption charges against someone or money swindling or misappropriation, whatever it is. What has the carrying of cyanide to do with?
There is no way we have removed our clothes or normal frisking because.
What normal frisking?
It's in case if they're.
What is normal frisking? What do you mean
if they're carrying, in case if they're carrying anything else to.
What?
Maybe weapons, maybe instrument.
Weapons where? Into
normally we frisk everybody.
What office?
No,
sir.
That's all.
Frisking is okay. See, what is
all these things,
else.
all these things have been told, my lord, is not been done. All these things have been told is not been done. May I make one submission, my lord? Your lordship.
So why would see this is
Fair enough, my lord.
This is prior to the death. Why
Yes,
can't
ma'am.
someone simply say
Fair
that?
enough, my lord. Your lordship may take this petition for 8640. My lord. For a moment, your lordship may take this petition.
Hmm.
Why all these things been made now?
Who is
I'll-
the IO?
One Kanaka Lakshmi,
DYSP?
device. You take this, your lordship may take this petition. Your lordship may see your lordship may see the IA affidavit filed by the petitioner at page number 55.
IA period.
Yes, IA for stay.
ಯಾವುದು ಈ dated 24/8/23?
Date is not there, my lord. It must be the.
IA for stay ಅಂತ ಇರೋದು ಅದು?
Yes, yes.
ಹಾ.
Your lordship may take the affidavit.
Page?
55, my lord, is in my this thing. IA for stay along with affidavit, my lord.
55.
Yes.
ಯಾವ್ದು 53ಗೆ ಎಂಡ್ ಆಗಿದೆ? ಯಾವ ಅಫಿಡವಿಟ್ ಹೇಳ್ತಾ ಇದ್ರೆ?
IA affidavit, my lord.
petition end ಆಗತ್ತ.
ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ಅಲ್ಲ. IA.
Application for stay.
Application for
ಅದ್ರಲ್ಲಿ
stay.
53 ಲಾಸ್ಟ್ ಪೇಜ್.
I have my page, my lord, 55.
ಯಾವ್ದು ಜೀವನ್? Which is that?
Yes.
Yeah. This is dated 24/8/23.
24/8/20.
Lordship may see who she is. I so and so, aged about so and so, proprietor of so and so.
Anika Enterprise.
Yes.
All right.
And she says, my lord, in para 2, she accepts transfer of funds, she accepts everything. The entire petition, my lord, your lordship may now come to page 9, my lord. Para 7 of the petition. There's an affidavit. Your lordship may now come to page 9, para 7 of the petition. Main petition. Main petition, my lord, para 7. She speaks about Dreams Enterprises accounts and financial transactions. And para 9, my lord, she speaks or submit to the petitioner is nothing to do with allegations leveled against therein. Further, the petitioner being a woman social entrepreneur and having started a firm.
What are you suggesting?
My suggestion, my lord, that she claims that she's a social enterpriser.
Not an advocate ಅಂತ ನೀವು ಹೇಳಿದ?
Yes.
All right.
I don't understand how. I'm not suggesting anything, my lord. I must say, my lord, that on Saturday, now since the president is here, my lord, let me make this statement. Saturday, I was walking down from this high court. Incident happened in this premises. One of the person whom we are investigating, associates of them, stops me. And
one of the accused?
Yes, stops me and tells me because I moved an application and stay got vacated and the death has occurred.
All this is diversion.
No, it's not a diversion. It is not diversion.
No, see, all you have done, he has done his job.
Yes,
Investigation
but
had to happen.
it has to happen.
What led to this is always an enigma. We'll
Yes,
see, we'll resolve the dispute. But
And now
that's
your
okay.
lordship may see rule 47 of Bar Council rules, my lord. How can she continue to be a lawyer?
There is one
No,
issue,
that's,
but one issue which stands out. She is already an accused in this FIR under PC Act, Prevention of Corruption Act, because there was demand for money also.
PC Act.
ಏನಾಗಿದೆ ಜೀಪ್ ನಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗುವಾಗ ಕೋ ಅಕ್ಯೂಸ್ಡ್ ಯಶಸ್ವಿನಿ ಇಸ್ ಹಿಯರ್. ಜೀಪ್ ನಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗುವಾಗ all this threatening harassment is for the purpose to milch more money. What she has done, ಜೀಪ್ ನಲ್ಲಿ ಕರ್ಕೊಂಡು ಅಂದ್ರೆ 25 ಲಕ್ಷ she has said ಕೊಟ್ರೆ ನಾನು ಬಿಡ್ತೀನಿ ಅಂತ ಕಿವಿನಲ್ಲಿ this IOS tells ಯಶಸ್ವಿನಿ in the ear. And then let me just complete. If this is the 1 second. Otherwise,
I'll come back.
No, if this is the complaint has been filed in this tenor on the demand for 25 lakhs. Now there is a connection between why she was harassing them and she was asking for a price to acquit them or to put them in the B report. But if this is the situation, I do not know how prosecution can now argue like it is defending. Now prosecution has substituted itself as a
Prosecution
defense.
is arguing, they have to defend the action. Now,
Yes.
you're against the prosecution saying that it is because of that.
Yes, but now
Because the
they are-
investigation.
Yes, now they are prosecuting her for these illegal acts on the basis of complaint.
No, that is, see,
Yes.
the Bowie Corporation case, less said the better about it.
Yes.
So
Lord,
it has to be
uh,
investigated. That is
yes, and let-
huge sums of money belonging to scheduled caste and scheduled
Yes,
tribes is swindled away.
Yes.
So that is why investigation was
On this,
permitted.
on this.
10
we-
crores rupees
the
have been transferred to
association-
our account.
Lord,
See, and even to this, that is the allegation made on the last occasion,
yes.
that 10 crores is transferred even to this Anika Enterprises whose proprietor
All right,
is the
all-
one
all
who
right,
is no more
all right,
now.
All right, Lord,
And how do you explain
That-
10
that-
crores
that-
deposit?
no. On that, let there be prosecution. Let let these persons who have
So
committed. this
ultimately
offense, let
truth
them-
should come out.
Yes,
Yes.
Lord, on that, the Advocates Association is not intervening in that process. Let your lordships may issue directions to efficiently conduct that investigation.
Your
and
lordship can
complete it.
monitor, my lord. Your
But-
lordship can monitor the
But Lord,
investigation.
but one issue is, this issue, so far as the contents of the death note is concerned, and the chain reaction of demanding money, all these things have to be investigated by an independent agency, Lord. Because the state, for reasons better known, I don't think higher officers will allow an investigation against a coordinate higher officer. I don't think that they will ever permit a fair investigation. And already, Lord, after the lodging of FIR, nothing has been done. They have not moved an inch in the case.
Yeah, which FIR?
This suicide FIR. Urmel.
306.
306 and PC Act. And I requested that PC Act allegation that is there in the complaint, that PC Act allegation must be fulfilled. I mean, there has to be a registration. It cannot be merely abatement to suicide, because such an allegation is there. Perhaps the reason why, I'm sorry, reason why she was making all this harassment and issuing threats and threatening to file false cases.
Now the association has implemented.
We have impleted ourselves, my lord.
No,
We have impleted ourselves seeking justice, because if it is not referred to the CBI, an independent agency, I don't think they will do anything, because she is a higher officer. And this is not the first case where she has done this. There has been previous cases,
Where?
allegation of false cases, filing
Where?
false cases,
Kodiyada.
Lord, with which on a technical point, she said there is no sanction. On that technical point, it was sent back for sanction. This is the judgment, Lord, where same parameteria, same pattern of allegations come out against her, where she creates evidence. Yes, Lord. Your lordship, but your lordship has said, go back, seek the sanction and prosecute. That's all, on a technicality. And of
There,
course,
which
that is
petition?
the law, Lord.
Oh, this is petition number 2, is it?
Petition number 2.
Kanaka Lakshmi.
Correct, Lakshmi. And that is the law, Lord. They have to take sanction and proceed.
No, that is true.
Yes.
That is at the time of taking cognizance. of it.
Cognizance at the time of. In the meantime, they have to allow the law to move.
Liberties result sanction ಕೊಡ್ಲಿಲ್ವಾ ಇದರಲ್ಲಿ?
ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ.
ಇದರಲ್ಲಿ ಅಲ್ಲ ಆಮೇಲೆ ನನ್ನ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ?
ಆದ್ಮೇಲೆ
Because I have reserved liberty to take sanction and
yes,
proceed.
yes. This order was in 2022, Lord.
Yes.
And of course, state government generally will not proceed with sanctions on higher officers. That is the fate of all cases. And SPP has to be on our side and say prosecutor.
No, that advocates
That word has not
on
come.
our side.
That is why CBI is necessary. SPP's argument is the justification for CBI.
No.
Because even he is already protecting her. He is under
No,
the
in fact-
instructions of higher
Now
police.
this Anika Enterprises is owned by whom?
Owned by Jiva, deceased,
You say she's an advocate.
60%.
How can she own this?
Lord, what has happened is she is practicing under Mr. Jiva.
Wait. 2021 after enrollment she stopped all the.
After enrollment in 2021, she stopped the business. She has no further business affiliation.
Then she should have described herself to be an advocate in the affidavit. Why
Yes,
why
yes.
not
But
that?
Lord, she has filed wakalats along with her senior.
Funds
She
have
was
transferred
working in the
after
office of her senior.
Jeevan Kumar.
Yes, and Sangeeta is her sister who is a lawyer. She is here. And she narrated, Lord, I just want Sangeeta to narrate a few words, because she narrated over phone. Sangeeta had gone to Mangalore. She narrated over phone the previous night, all issues. She knows particularly correctly as to what was the state, why was she had gone to such a state of mind, and what drove her to this.
Wait, we'll see.
Yes.
My lords, yes.
I will get back to
Yes.
that.
My lords, on 13th of this month, my lords, your lordships passed an order at page 24.
Investigation continue ಮಾಡಿ.
ಆಗ್ಬೋದು, but your lordships also granted liberty to record the interrogation and all
Correct.
this. My lords,
Because the
she was-
allegation of harassment was made
Correct.
by Jeevan
So, my lords,
Kumar.
now
I
the
said, he
learned,
said he is not harassing.
My
So
lords,
I
they
said
have
record
recorded,
it.
now it is recorded and all. My lords, after appearing before us on 21st, my lords, she was taken to
for a spot measure. My lord, she wanted to show the office in which Anika Enterprises was housed and where the transactions took place. Now it is part of the record which my friend can confirm that my lord, they take her to a cow shed. They take her to the cow shed.
Oh, shit.
Yes. That is a fake address where, my lords, it has been videographed that some buffaloes and some people are there in confrontation. She agrees that no establishment of Anika Enterprises existed there. They come back to the office. My lord, she leaves the CID office. And the next day morning, my lord, this unfortunate incident has taken place.
So this is 21st agida.
21st ಆಗಿದ್ದು, and we told her that she has to come back with the explanation for 7 crores which Anika Enterprises has received, and also Harnita Enterprises in which the complainant and the victim.
Oh, who is the complainant? Nimmali?
Namralli her sister. She Harnita Enterprises is A9 in which Jiva and Sangeeta 60-40 partners. The Harnita Enterprises has received 3 crores 16 lakhs. Well, this is not explained. So we requested her to come back with all the details. She goes back from CID's office when we drop her at the gate along with the pass and all. Next day morning, this incident happens. My lord, your lordship may kindly see the complaint.
But what is the allegation of stripping her? Why?
My lord, it was only frisking. There is no question of stripping at all. My lords, I am not trying to shy away from any inquiries being conducted against me. That's apart. Now, please see the complaint. My lords, kindly take page.
Our petition kodi.
Respond number 2 in my
Bandidya?
case. Bandide. But page 14. Now, since my lords, death note is before your lordships, my lords, I am not privy to that. But still, my lords, please see the
No,
complaint.
I read it from the death note itself.
No, that's right. Why I am trying to point out, I'll explain. Well, this is registered around 10:45 AM on 22nd of November 2024.
Yes.
The allegation of 25 lakhs that petitioner allegedly made to the victim or a deceased. Your lordship, if it is part of death note, then my lords, I may not have further submissions. My lord, there is nothing in this. This is only a tailor-made allegation. Now trying to, my lords, I have all sympathies for her. But the point is, I cannot be hounded like this by emotional pleas and incorrect facts. Please see the death note. If there is any whisper about this 25 lakhs being part of it, if she can write 13 pages, why not this allegation against me?
1 minute. You have seen the death note?
No, my lords, I am very sure about it. It is an orchestrated complaint.
It's not there, my lord. I can say I've seen that it's not there.
Well,
No, my lord.
PC
Therefore-
Act, fine.
No, my
Why
lord,
not-
therefore, my lord, I have done my job. My lord, there is no physical ill treatment, even according to the death note. And now, learned senior would introduce some lady who says in Kiviyalli ಏನೋ ಹೇಳಿದ್ರು.
No, that's wait.
No, but this
That
kind
is a
of
fact.
emotional. my
That is
lord,
a
sir.
fact. It's not
No,
emotional.
sir, 1 second.
It's a fact.
1 second, sir. Let me complete.
You have a typed copy of this?
If you don't have. In fact, I must say, my lord, this is the second death in this case.
Second death.
Second death. First was a accident death in Hubli,
But
2022.
I don't know if it is going in a Vapium scams case.
I have the papers of that death as well.
Lord, please see the complaint now. The allegation of demand is made to the victim. Now my learned friend is trying to say that it was whispered in somebody's ears. Please see the complaint.
That's demand we'll see. Yes.
No, my lord. Therefore, my lord, the legal issue is in the face of section 170 of the Karnataka Police Act. My lord, could there be a registration of a FIR against me? And if they have to invoke 7 against me, my lords, then 17A permission was required.
7 17 ಬೇಕು. ಆಯ್ತು.
For 306, my lords, it covers.
ಅದಕ್ಕೆ 17 ಬೇಕಾಗುತ್ತೆ.
ಅಲ್ಲ, ಅಂದ್ರೆ so far as 170 of the KP.
No. That is only at the time of taking of cognizance.
No. Even for 170.
Oh,
my lords.
no, sir.
Please see 170, my lords.
ಅವಾಗೇನ್ permission ಬೇಕು?
Even institution also they say.
Until
This is
submission of
something,
report.
my lords, which is unheard of, this kind of complaint against me.
Complaint.
No, my lord, therefore,
Then
my lords,
there
the
is a
submission
pattern.
is What was the need to orchestra 25 lakhs?
Whatever it is, ಅಲ್ಲಿ 25 lakhs ಬಗ್ಗೆ ಅದ್ ನೋಡೋಣ
ಇಲ್ಲ,
ಆಮೇಲೆ.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು
But
ಏನಂದ್ರೆ,
there is a 13-page death note written at 1:28 AM on 22/11/2020.
I'm not going to comment, my lords, it has been recovered or whatever it is from the scene of offense. Let them do it. But the point is, what was the intention of introducing this 25 lakhs money? Are they wanted to hound me by saying that, no, you are a corrupt person, therefore, my lord, please see the complaint for a moment. I'm sorry, I'm repeating this. Please see page 14.
Seven invoke ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಬೇಡ.
seven ಬರ್ಲಿಕ್ಕೆ.
ಅದು the kind of narration what my learned friend is now contending is entirely different from
In the
content.
complaint, there is an allegation of 25 lakhs.
Correct, but
Not
to
in
whom?
death note.
To whom is the question. Now he says that somebody was whispered in the ear while going to the jeep. Please see the complaint.
Complaint I have seen, yes. Complaint ಅಲ್ಲಿ there is an
ನನ್ನ
allegation of
ತಂಗಿ
25
ಹೇಗೆ
lakhs.
ಬದುಕುತ್ತೀಯಾ ಎಂದು ಮಾನಸಿಕವಾಗಿ ಧೈರ್ಯ ಕುಗ್ಗಿಸಿ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ನೀಡದಿದ್ದರೂ ಸಹ ಅವಳು ತೆಗೆದುಕೊಳ್ಳದೆ ನನಗೆ ಇದು ಬೇಡ, ನನಗೆ 25 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡು ಎಂದು ಸಾಯ. Who told her? Did the victim tell it to the complainant? Madam, one second.
What is this?
It is nobody's case that victim told the sister, therefore she has informed this
Very-
kind of.
Very scene of crime, my lord. Very sad to see. Life being lost, the state treats it so casually, which she should have been living and she should have faced the trial. A life being lost today has no worth for the state. What has happened,
Kind
Lord?
of emotional pleas, my lords, should not
No, it
come
is
in
not
the way of
emotional.
consideration.
And they are
Learned
seeking-
senior. My lords, I
seeking
understand.
investigation at independent agency,
That's it,
so
Lord.
he's saying that.
Lords,
That's it.
even we
And
also,
only
my
this
lords,
crime.
never expected
We are not,
this
Lord.
girl to go away.
There may be larger repercussions on the Bowie scam, Lord. Let the Bowie scam go, your lordships, it will, you leave it to your lordship's discretion, Lord. Let the Bowie scam, in order to speed up that scam, since 1.5 years.
They are
they've
doing
investigated. Yes, well, very well. Lord. We do not want to, because in 2021, incidents happened, 2023, the complaint is filed. We do not want to go into why that complaint was filed belatedly after another government, but that's all for them. We don't want, association does not want to enter into these areas. We want this case to be investigated by CBI. And otherwise, we will get no justice. Ultimately, they will treat me as a accused
Just pass on the money flow, just.
instead of
Very
treating her as an accused.
The money which is now, what is the amount of money which has gone to accused number 8?
So that he had earlier indicated 7 crore 16 lakhs to
Yes,
Anika
for A,
Enterprises,
and in which
3
the-
crore 79 lakhs to
Harnita.
Harnita Creations.
and in which complainant is 40% stakeholder and 60%.
Loan from Bowie Corporation.
Huh?
Not even one single rupee has come from Bowie Corporations.
Where did it come from
All
then?
business transactions, let them produce that I have received one single rupee from the Bowie Corporation.
These are all
One
the,
single rupee from Bowie Corporation. I'll withdraw the petition immediately. Those are all business transactions which I have done. There are all banking transactions. Nothing has been hidden. GST is paid. GST officers have inspected the spot, then given the registrations. All are banking transactions. There's nothing apart from banking transactions which have been done. I have, in last occasion, also I had submitted some.
that's what she was requested to come back with the documents on the next day
Documents
to
I
explain
submitted
this.
For this honorable court. itself,
Probably
I have
not,
SPP. All the documents, my lords.
you wanted her to come back with the explanation for this.
Do you have any
submitted it.
objection about the association's application?
No, I have a serious objection, my lord, because according to them, they say that she's doing a business. When she is doing a business, how do you understand how Advocates Association comes in picture?
No, that's all right. Have you
Is,
placed
the
on,
prosecutor has forgotten the offense.
no.
No,
have
then
you-
every offense
have you
association
placed on
comes.
record the.
The wakalats, we'll
Wakalat-
place the under enrollment, under enrollment.
Enrollment, wakalat and
Wakalat.
other things.
Please,
The enrollment, I'm not disputing. I know that she enrolled in 2021. The very fact that she herself filed an affidavit before this court saying that I'm an
but we-
entrepreneur in
we-
2023.
It is unfortunate prosecution is taking this stand. We are here for the welfare of the advocate community.
No, that's all right. I'm not on that. I only want the
Yeah,
facts to
please,
properly come out for a reason.
Please,
Yes.
please.
Now,
And even-
what objections you have for this? He is asking transfer to the CBI.
I say, my lord, your lordship monitor the investigation. I say, my lord, we lordship seek for a daily, weekly investigation.
Lord, let that be done under CBI. That is our plea, because
No,
independent agency pursuing this
It
investigation
means that the
will give
association
it
doesn't
the
believe
correct.
the.
And there is no threat of any political issue here. Because
Nobody is on that.
nobody's.
here.
It's an officer's conduct. Let the CBI objectively go into the material and churn out the investigation. So far as PC Act is concerned, my lord, the
Act ಆದ್ರೆ you'll need 17A permission.
yes, but co-accused Yashaswini is here, where she was told by the IO itself in the jeep, if you give me money, I will leave you. This is the conduct of the IO.
That is not
And that,
even in
Lord,
complaint.
we can, that is a subject matter of a separate PC Act case.
That's a part
We
of
will,
this
we will,
FIR.
we will
No,
pursue.
same FIR.
Same FIR.
Same FIR, all right. It
Same
could be
FIR.
because it emerges out of the same investigation. Therefore, there is ample material under the PC Act. Let the investigation continue, my lord. On PC Act,
Go
let
ahead,
the
some
filing of
case.
the
The
charge sheet.
complainant will have to comply with 17A.
Lordship may see this
Yes.
document.
ಏನದು?
Madam.
ಕೊಡಿ ಅದು.
I'm not, so far as videos are concerned, after your lordship's directed video hearing, video inquiry,
ಹಾ.
what she has done, intermittently, she puts off the video and then harasses her, says, you extract this, I want to extract this confession statement from you. Then she puts on the video. So in between, while extracting that confession, there is so much of mental harassment and torture. Saying, you say this, you implicate such a person, you give your statement in such a manner. There is some issue regarding the objective pursuit of investigation by this IO, Lord. Because in the previous case also, an allegation, serious allegation came up in the lottery case that she had planted evidence, took false statements. Same thing, she puts off the video and then she says, she extracts the confession, absolute torture. She says she was made to sit on her knees and she was beaten. Jiva.
This is
This
something
is, if these,
That is in the death note.
yes, if
that is the
these
death-
issues, if these issues
of anxiety,
have gone into,
out of
No,
anguish,
those are-
she may have,
No,
Except the 25 lakhs, whatever he is saying is in the death note.
but out of anxiety, she may have written it, but not that is part of investigation. Whether what happened on that intervening night, whether she had in a state of mind to write or somebody else, I don't know. So therefore,
else.
But
In
she,
fact, my lord, there
no,
one
the
more
thing is,
incident happened.
investigation was concluded for the day on 21st night,
yes, ma'am. Yes.
21st evening rather. The death happens at what, 1:30 AM and
No, my lord.
5 o'clock.
5 o'clock.
5 AM on 22nd. The death note is written at 1:28 AM.
Yes.
So there is link in the chain of events.
No, no, I'm
There is
not
one
on
more
that.
issue, my
I'm
lord.
not on that.
The lordship may recall, the coordinate bench has stayed the investigation approval obtained under section 17A. That order came to be vacated.
Yes, that,
That order
it
came to be, came to be vacated. Petition came to be dismissed on 12th.
What order came to be vacated?
The
17A approval.
Yes, madam.
Against whom was that?
Against two of the main people.
Oh,
One
that's
is
all
PK
right.
Nagarajappa with the managing director.
You
In
can-
fact, my lord, this petitioner, these documents, my lord, your lordship may say since 2016, the 3 addresses, BK Nagarajappa's house address, deceased address,
Now the main accused is BK Nagarajappa, is it?
And all of
BK
them,
Nagarajappa, Leelavati,
same address, my lord, they were staying.
same address.
The petitioners in my learned friend's petition and BK Nagarajappa.
Cowshed.
No, these
Same.
are address.
Address is the
Nagarajappa's
same, and
address.
company's address is also same. Your lordship,
BK
they
address.
have rent agreement.
Lord,
And
They
that the
may-
same person, my lord, comes and objects me for on this Saturday.
Which person? BK
BK
Nagarajappa.
Nagarajappa.
No, Lord, nobody can approach the prosecutor.
Approach alla.
That's why we have,
Document tells it.
that's why we got the Advocate Protection Act enacted. Our PP can use the Advocate
No,
Protection
no, no.
Act.
ನೀವು ಮಾಡ್ಬೋದು. Oh,
Any client threatening, he can immediately report. The state will immediately haul him up and bring him.
No, no, no.
I
can understand.
He's putting out the facts.
Yes, but that is offensive. We cannot accept that. And no advocate can be threatened in the discharge of his duties. Even now, the PP is doing his best. But PP
No, no,
is,
sorry.
Learned PP is, has to take up our case as prosecutor. We want that role from the PP. It has not come still. That is evidence of the fact that inquiry will not go on neutrally with the state. Number one, higher officers, they have enormous power under them. And it is impossible for us to get at the truth with this
local
state
authority
police.
with his supervision.
Third, Lord, is kindly see the first affidavit filed, Lord, before your lordships. She comes up with some semblance of torture and harassment. But after the affidavit is filed, it escalates multifold. And this is where we are very sorry, because for approaching the court, this lady, the investigating officer, has victimized her.
Lord,
For approaching the court.
If
And
sixth-
saying,
sixth is
one
the-
minute, let me
sixth is
finish.
the affidavit.
Saying that
Why were they holding
30th
back till 13th orders passed?
in that chain of link of events, my lord, which your
this is
lordship
something-
pointed out.
Because of that affidavit only, of the torture that was argued.
Yes.
That
I
affidavit
said,
I
let
sub-
the investigation be videographed.
No,
Yes.
That is done.
No,
Now,
no,
in the
that,
in the
why I
complaint.
passed that order of videography
No,
is
in the-
because of
Let's-
the affidavit that was filed,
Lords,
that
the
the
teeth
investigation
of-
officer is torturing the.
The teeth of the
IO,
lordship.
this IO has gone to the extent of saying, my learned friend passed the affidavit across the bench, my lord. Your lordship said, file it so that I can read it and come. Perhaps your lordship said that. Then it was filed in the thing. She has even stated that your affidavit is not read by the learned judge. So therefore, it will not be read. It's all noted, I think, in the.
Lords, I don't think is.
And
Friend is going way
she has
beyond
been
the.
harassed.
Death note.
Death note.
Not there,
Well,
but
ಇದೆ.
I am not on that. The
13
point
page
is,
ಇದೆ.
my lords,
ಆಮೇಲೆ ಆ ಡೆತ್ ನೋಟ್ ಏನ್ ಮಾಡಿದ್ರು ಇನಿಷಿಯಲಿ ಡೆತ್ ನೋಟ್ ನ ಸೀನ್ ಆಫ್ ಕ್ರೈಮ್ ನಾವು ಹೋದ್ವಿ ವಿ ವೆಂಟ್ ಅರೌಂಡ್ ಆಫ್ಟರ್ನೂನ್ ಬಟ್ 10 o'clock some 2 or 3 lawyers were there. Scene of crime ಇಂದ ಅವ್ರ ಪಾಪ ಫೋನ್ ಮಾಡಿದ್ರು. Initially what they did, the IO put the speaker on. Other person from the other side was saying, this is how investigation goes on. I mean, ultimately they have been correct in not lodging the death note. They said, has anybody read the death note? One of the hearers was listening. They said, some lawyers have read it. Then immediately they said, then keep the death note. ಇಲ್ಲ ಅಂದ್ರೆ ಡೆತ್ ನೋಟೇ ವ್ಯಾನಿಶ್ ಆಗೋಗೋದೋ ಏನೋ.
ಹೇಳಲಿಕ್ಕೆಲ್ಲ ಚಂದ ಕಾಣುತ್ತೆ ಕೋರ್ಟಲ್ಲಿ.
Anything is possible
Because
with the police force.
Anything can be said about anybody and get away. The point is, the complaint itself, not on 25 lakhs.
No, it has to be investigated.
That is true.
Yes.
I am only
There is
requesting.
no doubt that there is, whether there is goading, instigation or not. But link in the chain of events definitely necessitates an
My
investigation.
lords, I am not on it.
There's
My
no doubt.
liberty may be protected. And secondly, my lords, what I am trying to point out is, in the complaint, they say that investigation should be conducted through VC. It is not that it should be recorded. My lord, look at the wordings used in the complaint. ವಿಡಿಯೋ ಮೂಲಕ ಅವ್ರಿಗೆ ಇಂಟ್ರಾಗೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು, ಆದ್ರೆ ಅವ್ರು ಬೈ ಫೋರ್ಸ್ಫುಲಿ
ಕರೆಕ್ಟ್
ಕರ್ಸ್ಕೊಂಡಿದ್ದಾರೆ.
ಆಗಿ ಇದೆಲ್ಲ ಮಾಡಿದಿರ ಟಾರ್ಚರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರೆ she would have been living today.
No.
She has made prayers to the court on the conduct of this IO. It is for there is a forewarning, Lord.
She is the fourth IO. We have cooperated with all the 3 IOs. We would have cooperated, we have cooperated with this IO. If she had that intention, my lord, she would have committed suicide at the first IO itself.
There is a
So torture allegation is only against this IO.
this IO.
Not against any other, even their subordinates. In the first page, my lords, if I remember in the death note, he doesn't want to make an allegation against anyone, but she makes an allegation against the present IO because of
That
the
I've
torture.
seen, that is there. Minute details are
And
narrated in the death.
in the second case, my lords, the co-accused, I'll file an affidavit,
What co-accused?
who was along with her as to how even she was stripped on that day. Even she was stripped on that day. Para number 2, my lords. Not only the deceased,
No, that I see in the death note also.
even this petitioner was also
Jagdish,
stripped on that.
correct. Even this, in the death note also, if you see this, the same thing is there. ನನ್ನ ಬಟ್ಟೆಗಳನ್ನು ಒಳ ಉಡುಪುಗಳನ್ನು ವಿವಸ್ತ್ರಗೊಳಿಸಿ
Most inhuman, Lord.
ಅಲ್ಲ ಮುಟ್ಟಿ ಪರೀಕ್ಷಿಸಿ ಸೈನೈಡ್ ತಂದಿದ್ದೀರಾ ಅಂತ ಕೇಳ್ಕೊಂಡು ಯಾವ್ದಾರ ರೆಕಾರ್ಡಿಂಗ್ ಡಿವೈಸ್ ತಂದಿದ್ದೀರಾ? Any problem with the IO?
There is no problem, my lord. I must say, my lord, there is no problem.
Now we will have to file a petition for change of IO, because if this is a state, other
No, that-
petitioners also.
That's a
will not-
different issue, my lord.
So that's
All
all
these
right.
things
Now,
we will,
now I'm examining the
yes,
death of
yes.
the advocate will see. Yes,
Lords, so far as,
investigation ಆಗ್ಲೇಬೇಕು.
correct, my liberty may be secured, and so far as,
What liberty?
my lords, I'll cooperate with the investigation. Now, she comes and says that, my lords, 25 lakhs and all those things is unheard of. 17A permission, my lord, legally your lordship may examine
ಅದು
this.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
ಅಲ್ಲ, investigation ಆಗ್ಲಿ ಪ್ರಶ್ನೆ ಅಲ್ಲ.
PC Act
initial bar.
ಅದು
ಬೇಕಾಗುತ್ತೆ.
there is a separate mechanism for
There is initial bar. So therefore, my lords, my submission is that your lordships, my lords, may supervise this as submitted by learned SPP. My lords, I can be taken out of the investigation. I don't latch on to any case. Lordship, may, let them pass an order, superior, constitute a SIT, my lord, let them investigate threadbare. Let the
SIT.
truth come out.
SIT is a
No, if-
replacement
if
of.
My friend.
It
is
is
trying
like,
to-
Lord, it is like, I telling another lawyer is very good lawyer. He does not do any other.
Lords, it is
work.
not, it is not.
It is a
whom I am
one
going to
police
suggest the
officer will tell
officer.
the
It
another
is-
police
I
officer.
leave it
is
to your
good.
lordships on that issue. I am only, my lords, as officer of the court, I am placing before my propositions before your lordships.
Purely, my lord, in the police
And so
force,
far as this is
there is
concerned,
lot of inner currents of connectivity.
As I
One officer will be connected to another
Of course,
officer.
connectivity should be there in. a
Should be there,
force.
of course. Your lordships.
That's not.
Yes,
That's not,
but
that's
that
not
will-
alien
yes,
concept.
that
to
will
force.
prejudice the investigation, Lord.
As I
It has
say,
to
my
be
lord,
by an independent.
Yeah, no.
is the
CBI.
first death of this case.
Allah,
No,
the
that's
main
anyway,
case
that's
merits, Lord, we are
happened.
not concerned.
But
Main case merits.
she
if I-
makes-
Totally Bowie Corporation, the scam, alleged scam, ಎಷ್ಟಾಗಿದೆ?
Other, there are 6 complaints, total 196 crores anta we hear.
196 crores.
109,
What
6
the
different
CRPL
complaints.
maker state.
This issue is about 3.75 crores.
No, it's about more than 10 crores.
Yes,
Yes.
two companies have
Perhaps.
received. One company.
But
has
on the
received-
whole, it is 200, close to 200 crores.
Close to 200 crores.
Initially,
And
there was a financial allegation against some of the IVOs. I must say, my lord. Therefore, the IVOs have been changed. Integrity of the IVOs was
In question.
in question. Therefore, IVOs was
ಈಗ
changed.
CID ಹೆಂಗ್ ಬರ್ತಾರೆ ಅಂತ ನಮಗೂ ಗೊತ್ತು, ಅವ್ರಿಗೂ ಗೊತ್ತು. CID ಗೆ ಹೆಂಗ್ ಅಯೋನ್ ಆಗ್ತಾರೆ ಅಂತ. But this is widely known how an officer comes into CID.
It's all right. But there is an allegation which is absolutely grave in the
Lords,
death
I am
note.
not on that point. My lords, what I am requesting is, your lordships are, my lords, by making a submission, your lordships
So
are
this
monitoring.
lady, if she wanted to investigate, she should have investigated. Where is the question of stripping or
Now, all these things, my lord, is there are other officers.
stripping or examining every private part of the body to see whether they are carrying any device,
Lord,
recording
it is
device
not
and other
Things,
things.
my
What
lord,
is
there are
all
other
this?
officers were present. It is not that it was done only when this thing. Every time there is other women and other male staff were present, they can be examined and to see whether all these things has been done or
It's
not.
only a
done.
frisky.
I must say, my lord, there
Not
are
have been driven.
people behind.
She would
who-
not have been driven to this extent, but for that activity that day, which has
Lords,
driven her to, her
if-
both parents died in COVID.
My lords, if the incident
is
has
alone
happened on
with her
14th,
sister, living
stripping
with
has
her
happened on
sister.
14th.
She is
But
living
according
alone.
to the death note, my lords, I have not seen it. It is on 14th. Then, my lords, she has come
Death
next.
note is not on 14th.
No, it's must be on
Frisking.
frisking about.
Huh.
Frisking ಅದು ಯಾವತ್ತು ಮಾಡಿದಾರೆ ಅಂತ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. I don't know which, if it mentions. a date
1411.
and
It says in the affidavit, it says 1411.
1411.
Client and ಕೇಳಿದ್ರೆ
1511.
And all these things, my lord, your lordship, may say only
Subsequently, she has
subsequent to,
appeared.
Coordinate bench order.
Subsequently, she
No,
had
no, no.
appeared for.
That is at paragraph 3. There are about 20 paragraphs here.
My lords,
The narration goes on.
No, what I'm trying to point out is so-called stripping has taken place on 15th. She has appeared on subsequent dates. 21st also she has come to us. We have taken her for a spot measure. Then she leaves
all
the
this
office.
is-
Sir, one
all
second.
this is
Sir,
after
one
we
second.
file the affidavit.
1 second, sir.
Before last.
It's all right, yes. But Venkatesh, it needs an
But
investigation.
7A, my lords, they can't.
It needs an investigation.
Correct. 7A, they can't, on face of it, my lords.
I will see.
17A bars it.
Maybe the Prevention of Corruption Act ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
Just to give a good
ಹೇಳಿದ್ದಾರೆ.
good case for a prosecution.
No, no. Then legal snag comes in under 17A.
Yes. Sanction.
Approval.
My lords, we are at your
At least
lordship's hand.
preliminary investigation, Lord,
Lords.
before cognizance.
17A.
Inquiry, investigation, everything is prohibited. My lords,
Lord, 306, that is 108.
before concluding, my lords.
New
I am-
BNS.
We are at your lordship.
ಅದನ್ನ investigation.
ಅದು ಗೊತ್ತು.
ಅದು
We are at your
So
lordship.
far as this is concerned, Lord, let the state government take a stand and come back before your lordships
That we will do.
on this PC Act.
ಅಲ್ಲ PC Act ಬಿಡಿ. Now 306 investigation act.
Yes, ma'am.
It has to happen. Because if one reads the death note, it is
It has to be investigated, ma'am.
horrible.
I'm Lord, let the CBI report to your lordships. So and to ensure fairness.
We'll see. What do you say about
Lords, in fact,
transferring salary?
today there is a judgment of Honorable Apex Court. It is not over. I'm sorry. Second. With reference to R.K. Kapoor Medical College, not the Honorable Supreme Court has said that CBI is not a remedy for everything. We will monitor, or the Calcutta High Court will monitor. The hand-picked officer is chosen by the court. Then, my lord, they say, go and investigate. My lord, that could be the parameters. It is not yet to come out in the, today it was passed. So, my lords, it is only a suggestion. Let my learned friend not say that one advocate is praising another advocate. There's nothing like this.
In cases where officers are are at the level of inspectors, my lord, there would be enough seniority to take care of such instances. But now this is the DYSP, and he is a high officer. She is a high officer. It is only an independent agency like CBI which can go into objective material, collect this material, place it before your lordship, and then step by step go into prosecution. And not to ensure fairness for either side, let it be monitored by your lordships. But if CBI does not go into this plot, like they were about to bury the death note at the initial stage itself, they may bury several pieces of evidence, which is most dangerous for this investigation.
But something
And
can
it is
stop the
necessary.
record.
It is necessary that in such
Something-
cases,
my friend should
this is
not
an
make a
offense
statement
against,
like
this is an offense against public. Using powers of police to degrade the victim and then push her to this extent. I think this is a case which calls for CBI investigation only, my lord. This is rarest of rare in India. We have seen custody deaths, but driving the mental state of a accused to this extent in investigation, that death note itself is self-explanatory, my lord, and gives prima facie evidence on these issues. So if CBI can investigate this, then it could be perfectly handled by them.
Well, I'll pass orders tomorrow. You have any objection? To what you have objection? In case transfer, the application transfer to CBI, you have objection?
I will have to consult the state, my lord. I can't be making the statement.
All right, you ಕೇಳಿ ನಾಳೆ ಹಾಕ್ತೀನಿ. We'll pass orders tomorrow. By then you secure instructions. ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. Batch of these petitions are preferred by accused in crime number 56 of 2023 registered for offenses punishable under section 406, 420 read with 149 of the IPC. The allegations pertain to certain alleged siphoning off of funds from the Bowie Corporation. The alleged total amount in
About
196 crores.
3.7 total 196.
The allegation is with regard to siphoning off of 196 crores belonging to the Bowie Corporation.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
ಮತ್ತೆ 196 crores ಅಂದ್ರೆ
I say 100+ crores.
of the Bowie Corporation.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವ್ರ ಯಾರೋ ಒಬ್ರು ನನ್ನ ಅಕೌಂಟ್ ಇದಾಗಿದೆ ನನ್ಗೆ ಮೋಸ ಮಾಡಿದ್ರೆ ಒಬ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ನ. Not the
ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು.
The investigation is on. During the course of these proceedings, this court passed several orders. On a particular affidavit filed by the accused number 8, accused number 8-1 Kumari Jiva, an advocate, this court directed the investigation to be videographed, as the affidavit alleged torture by the investigating officer upon the said accused. This order comes to be passed on 13/11/2024.
24/9.
Huh?
24/9.
Permission to investigate is on 24/9.
Initially on
Yeah, video-
13/11/2024 and on 24/11, 24/11
ಅಲ್ಲ
13/11/2024. The investigation, it is thereafter the investigating officer is alleged to have tortured the accused number 9 on several dates of investigation, i.e.
number 8.
Huh?
Accused number 8.
Accused number 8. On several dates of investigation, i.e. on 14th November, 15th November and 21st November, it is alleged that the investigating officer has meted out such torture upon the accused number 8. Accused number 8, that the accused number 8 penning down a death note running into 13 pages in the wee hours of the 22nd November 2024 commits suicide. Therefore, the offense against the investigating officer is now registered, alleging it is abetment to suicide in a crime registered on
22nd.
In a crime registered on 22/11/2024 for the offense punishable under section 108 of the BNS, which is section 306 of the earlier regime, the IPC. On the death of an advocate, the Advocates Association has preferred an application seeking transfer of the investigation insofar as it concerns the offense of abetment to suicide is concerned to the hands of an independent agency. The independent agency, according to the learned senior counsel Vivek Subbareddy, is the Central Bureau of Investigation. As according to him, an investigation, if has to be fair and generate public confidence, the investigation has to be handed over to the CBI, as one officer will always protect the other in the police force. The learned counsel Venkatesh, the officer against whom the crime is registered on 22/11/2024, even before the ink on the crime could dry, is before this court in criminal petition 12695 of 2024, calling in question the registration of the crime for offense punishable under section 108 of the IPC, inter-alia. The learned counsel submits that the officer would cooperate with the investigation, but certain protective orders of the liberty of the petitioner being taken away should be passed. Since the issue that is issue now is whether the investigation should be handed over to the hands of the Central Bureau of Investigation and the investigation, the additional SPP to secure instructions or file objections or make his submissions as the case would be. List the matter, Nale?
Day after tomorrow.
List the day after tomorrow at 10:30 a.m. Please.
Just with the other criminal petition also, I filed an affidavit. that
ಏನು
with-
affidavit?
With regard to.
ಈ
harassment
ಕೊಟ್ಟಿದ್ದು
ಹಾ.
affidavit of the sister.
No, not.
Huh?
Other accused, other petitioner.
ಇನ್ಯಾವ petitioner ಇದ್ದಾರೆ?
ಇನ್ನೊಂದು 9102.
ಅವ್ರಿಗೂ ಟಾರ್ಚರ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರಿಗೂ ಟಾರ್ಚರ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನೇ ಅವರು, he has also given it 7 pages affidavit.
ಅದು ಈ ಕೊಟ್ಟಿದ್ದ ಇನ್ನೊಂದು
9102. ಇನ್ನೊಬ್ರು petitioner. (9102) of 2024. That could also be taken on record.
1 minute. ಇದು who is Yashaswini?
Yashaswini is the petitioner in
He is here.
9102.
ಅಲ್ಲ, affidavit is by Yashaswini.
Yes.
Yes.
She is the petitioner in 910.
ಆಮೇಲೆ
Where
ಬರ್ಕೊಳ್ಳಿ.
she was also stripped.
The other accused number?
7.
Accused number 7 has filed an affidavit is filing an affidavit before this court, again narrating the torture meted out by the investigating officer while conduct of investigation. Therefore, the learned additional SPP, the same is taken on record, the learned additional SPP to secure instructions and counter it if needed by his submissions or filing of objections. ಇದಕ್ಕೂ ಅದೇ ಹಾಕಿ. Let's day after tomorrow, 10:30.
Please.
Yes.
All the
7A is.
All the matters.
Please.
We'll see.
Obliged, my lord.
If necessary, we will segregate. Yes. Tag this petition 12695 of 2024 along with these cases. List them all at 10:30 a.m.
Please, my lord. Obliged. Please.
Records ಇಲ್ಲೇ ನನ್ನ ಹತ್ರ ಇರಲಿ. Admission, yeah.
The petition.
Interim order ಇದೆ.
Interim order ಇದೆ.
ಹಾ.
Lord, what has happened is the complaint lodged by Tahsildar hearing for the same offences in another two cases, Your Lordship, the 2 years is completed. They're not given the originals and all. The respondent police,
Originals.
they have not cooperated with the police.
You are the complainant, is it?
Yes. No. Here I'm the accused here. See, what has happened is the similar case wherein two crime numbers in 415 and 416 for the lodged by the same Tahsildar police allegation for the same offences.
All right.
So wherein the respondent police filed in a B report wherein
All
because
right.
after 2 years completed, he has not provided any originals and anything. So he's
For
given
what?
No.
Originals for what?
no, for investigating into the matter.
You are the complainant or the accused, sir.
No, I'm for the accused.
If you are for the accused, there is an interim order operating.
Operating.
All right. ಈಗ B report close ಮಾಡ್ತಾ ಇಲ್ವಾ?
B report ಹಾಕಿದ್ದಾರೆ ಬೇರೆ ಕೇಸಲ್ಲಿ, but in my
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಇರೋದ್ರಿಂದ B report ಹಾಕ್ತಾ ಇಲ್ವಾ?
please,
ಆಯ್ತು, we'll close it.
I'm producing the memo with the two
No problem.
cases wherein
The petition is moved. This court, the coordinate bench of this court on 28/11/2023 had passed the following order. Interim order as prayed for was granted as insofar as it related to the petitioner. The counsel for the petitioner has moved the matter on the score that the interim order is coming in the way of the investigating officer filing their final report before the concerned court. It is a specific case that in two of the connected crimes, in crime number
415 and 416.
415 and 416 of 2022,
Please.
2022, the police, after investigation, have filed a B report before the concerned court
File.
and would seek leave of this court to dispose the petition with a direction to the concerned investigating officer to complete the investigation, file his final report as is filed in crime number 416 and 415
Please.
of 2022. My final report, B report ಹಾಕ್ಬೇಕು ಅಂತಿಲ್ಲ.
As mentioned in the crime number ಅಂತ ಹೇಳಿದ್ರೆ, then if their B report has been filed, we'll to file B report.
ಅಲ್ಲ, so and so, that is submission. So, we're
producing the
seek
memo.
leave of this court ಅಂತ ಹೇಳಿ. In the light of the said submission, I deem it appropriate to dispose the petition with a direction to the concerned investigating officer to file his final report in crime number 432 of 2022 hyphen the subject crime in accordance with law.
I'm
Ordered
producing,
accordingly.
I'm producing the two memos with
That's all
documents.
right. No problem. Yes, in accordance with. It is made clear that this court has not assessed the issue on its merit, nor has assessed the B report filed in crime number 415 or 416 of 2022. Yes. Ordered accordingly. Extension of time for what? Settle ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ sir.
Offense ಏನು?
Offense 498 my lord. ಇದು annexure
Page
68 of the joint petition my lord. Before the mediation center.
ಡ್ರಿಲ್ ಗೊತ್ತಲ್ಲ, 498 ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಗೊತ್ತು.
Husband and wife is present paper. And the decree is drawn as per the annexure E my lord 70.
Yes, yes, sir, yes. ಇಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ, ಪೇಜ್ 69 ಅಷ್ಟು ಮಾತ್ರ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ. Yes, all conditions fulfilled?
Fulfilled.
Yes. Next.
My lord, maybe. Other petitioner number 1 is present, other petitioner's father and attempted that present.
Don't worry. Yes. Husband and wife ಆಗಿದೆ.
Present is there, present.
The transaction between two companies, Your Honor.
ಏನ್ ಅರ್ಜೆನ್ಸಿ 230 ಫೈಲ್ ಅಲ್ಲಿ
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
Withdraw
29
ಮಾಡ್ತಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ 29/11
ಆಯ್ತು.
ಲೋಯರ್ ಕೋರ್ಟ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್
ಅಲ್ಲ 29/11 ಇದೆ ಸ್ವಾಮಿ.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಗೆ ಸ್ವಾಮಿ ಫೈನಲ್ ರಿಪೋರ್ಟ್.
ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡ್ಲಿ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅಲ್ಲ FIR ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಆಯ್ತು, ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅಲ್ಲ ಇನ್ನು ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಕೈಂಡ್ಲಿ.
ಜಗದೀಶ್ ಚೆಕ್ ಸೆಕ್ಯೂರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಾಪಿ ಕೊಡಿ.
ಕೈಂಡ್ಲಿ.
List the matter day after tomorrow in the fresh matters list. Next. ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. ಕೊಡಿ, ಮೂವ್ ಮಾಡ್ತಾರೆ. $498. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೇನು? 498. Except husband, accused number 1, all others, 2621 ಗೊತ್ತಲ್ಲ? Yes. 1 HCGP, 2 emergent notes. Next. Deepa. ಕೊಡಿ. In terms of memo, mood for withdrawal, mood for withdrawal. Yes. 7. Lokesh.
Sorry, my lord, I couldn't see the list. My lord, this matter between the petitioners are the in-laws, my lord. Matrimonial dispute. Son eloped and got married, my lord. And then he finds out that she is married and the earlier marriage is not dissolved. He files a petition for annulment of the marriage before Bangarpet. Husband. Filed the petition, my lord. After getting to know about that, like the 30th of October, the court orders for notice. 498A, atrocity, attempt to murder, everything, my lord. It's Muhammad Ali is directly applicable, my lord.
Muhammad Ali.
The well-drafted complaint.
Oh. Yes.
May take my lords to the complaint, my lord.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಬೆಳಗ್ಗೆ.
Heard the learned counsel appearing for the petitioner. The petitioners are accused 2 to 5. Mother-in-law, father-in-law, and brother
Sister-in-law.
and sister-in-law of, brother-in-law and sister-in-law of the second respondent, wife of one Abhishek HS, who is not before the court. It transpires that the accused number 1 and the complainant get married. After marriage, the husband gets to know that the complainant is already married and is still living with the first husband.
No, my lord. He's alive. There is no dissolution of marriage.
And gets to know that she's already married and there is no dissolution of marriage with the first husband. Therefore, first husband, trouble begins to brew between the two. The result of such brewing of problem between the two is the registration of the crime in crime number 355 of 2024.
He also filed a complaint.
I have also filed a complaint
2024
earlier.
for offenses punishable under so and so. It is also a counterblast to what the husband has filed against the wife for cheating. Cheating
Antela, she is threatening of committing suicide, physical abuse,
All right.
mental abuse, all
Anyway,
those things.
by the husband. Therefore, in the crossfire between the accused number 1 and the complainant and their problems, the petitioners are caught. If further investigation is permitted into the case at hand against these petitioners, it would on the face of it become an abuse of the process of the law, albeit prima facie. Therefore, there shall be an interim order of stay of all investigation against these petitioners till the disposal of the petition. 1 HCGP, 2 emergent notice.
One short order may be uploaded. my lord. The police are asking.
ಅದು ಆಗುತ್ತೆ, ಜೀವ ಆಗುತ್ತೆ. Do it. ಅದು ಇದು ಇರೋದೇ ಶಾರ್ಟ್, ಇದ್ರಲ್ಲಿ ಏನ್ ಶಾರ್ಟ್ ಆರ್ಡರ್?
Stayed ಅಂತ ಬಂದ್ಬಿಟ್ರೆ we can show it.
Yes.
Public.
The crime state, my lord, within 15 days, my lord, charge sheet is filed, my lord, in the earlier round.
Offense ಏನು sir?
324, 325, my lord, IPC. Earlier BNS ಅಲ್ಲಿ 115 ಅಂತ ಹಾಕಿದ್ದಾರೆ, 115-1. Case counter case, my lord.
Encounter.
Case and counter case.
Yes and counter.
After 32 days delay of the incident, my lord, this FIR is lodged, my lord.
When did you register the crime?
Page number,
ನಿಮ್ಮ incident date.
see, my lord, 46.
Incident date.
Incident date is 22/7/2024, my lord. This FIR
ನಿಮ್ಮ
is,
complaint.
mine is also on same date, my lord.
Crime
22
number. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
Crime number.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಇಲ್ಲಿ?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, annexure C.
ಇವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್?
At the time of filing itself.
2:30 ಮೂವ್ ಮಾಡೋದಾದ್ರೆ ಇಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಲ್ಲ ಏನು?
Please.
ನಿಮ್ ಕಾಪಿ ಕೊಡಿ. ಈಗ ಕ್ರೈಮ್ ನಂಬರ್ ಹೇಳಿ. ಕ್ರೈಮ್ ನಂಬರ್ ಹೇಳಿ. ಒಂದು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ತರದು. ಅವತ್ತೇ ಮಾಡಿದ್ರಾ?
Please, my lord. Annexure C is the case what we had registered, my lord.
(292) is the crime effect.
Heard the learned counsel appearing for the petitioner. The petitioners are before this court calling in question proceedings in CC 7323 of 2024. An incident happens on 22/7/2024, and on the said incident, the petitioner number 4 registers a crime against the complainant in crime number 292 of 2024. Coming to know of the crime so registered, after 32 days of the registration of the crime, comes the crime registered by the complainant as a counterblast. In the light of unexplained delay of 32 days in registering the crime by the registering the impugned crime, there shall be an interim order of stay of further proceedings qua these petitioners till the next date of hearing. 1 HCGP 2 emergent notice. Additional SPP 2 emergent notice. Next.
Mine is also, my lord.
Same,
Same in the subject is different. Connected case already stayed, my lord. Counter case is
Number?
134. Yeah, criminal petition number 446 of 24.
page 134.
134, my lord. Criminal petition 446 of 24. my lord.
Coordinate bench.
Please, my lord.
Tag the petition. Same. Sadanand?
Beg to appear for the petitioner in this matter.
Yes, sir.
Charge sheet under section 420 and 504 and 506, my lord. The brief allegation against me is that, my lord, the complainant has registered survey
ಇದು
number.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
Colleague has
ಕೊಡಿ.
given.
ಇಲ್ಲಿ ಕೊಡ್ಬೇಕು sir. When you move at 2:30, you should give it here.
The brief allegation is that, my lord, on 5/4/2019, survey number 78, the complainant has executed a sale deed in my favor. On survey number 77, a registered agreement of sale is executed in my favor. On 6/11/2021, my lord, she lodges a complaint against me that the remainder sale consideration is not paid. That's the only allegation against me.
You are
However, my lord, at annexure C, she herself comes forward and executes the sale deed in my favor. On 25/5/2022.
Additional SPP 2 emergent notice.
And the entire sale consideration is passed on.
Second respondent is the complainant, who appears to have registered the complaint on the score that the complete sale consideration of a sale deed that takes place between the petitioners and the complainant is not paid. Second petitioner Kodalla. What's his name?
Name is Manjunath. That is wrong, my lord. He is not any gym trainer or something. He's the
Jim Manja andre ಏನು?
Illa, Swami. His role is only not there. The agreement is and the execution of sale deed is only between petitioner number 1.
So also, a seemingly civil dispute is sought to be dressed with the color of crime and the petitioner color of crime. Therefore, there shall be an interim order of stay of further proceeding to the next.
Sale deed to execute ಆಗ್ಬಿಟ್ಟಿದೆ sir.
Yes, sir. Paral. Next.
Great.
1 additional SPP 2 emergent notice. Purushottam.
For the petitioner, my lord.
Not the allegations against the complainant.
ನೇಮ್ ಎಲ್ಲೋ ನೋಡಿದ್ದೀನಲ್ಲ, ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಇತ್ತಾ?
ಇಲ್ಲ. Offenses under 415, 416, 417 and
ಯುನೈಟೆಡ್ ಕಿಂಗ್ಡಮ್.
no, my lord.
ಎಸ್ ಸರ್. ಹಾ, ಎಸ್ ಹೇಳಿ.
Offenses under 415, 416, 470 and 420 of the IPC, my lord.
Why did you move it 2:30?
My lord, the case has been posted for framing of charges before the trial court on Wednesday. And this arises.
Copy ಕೊಡಿ, tomorrow ನಾಳೆ ಆಗುತ್ತಲ್ಲ ಮೇಡಮ್? Tomorrow fresh matters. Give a copy to the additional. ಈಗಲೇ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
ಇಲ್ಲೇ ಮಾಡಿ.
ಇನ್ನೂ ಇದೆಯಾ?
The offense is registered on section 420.
Second criminal petition.
No, this is the first petition which has been filed. Madam.
Maintainability ಅದೇ ಇರೋದಿಲ್ಲಿ.
Against petitioner 2 and 3 and.
Huh?
Against petitioner 2 and 3 and others.
Against P2 and P3.
P2 and P3.
ಅವ್ರು ಇನ್ನೊಂದು ಹಾಕಿದ್ದಾರೆ.
I will withdraw against P2 and P3, my lords, but subject to this petition number 1, is the first petition which has been filed.
P2 and P3 filed another petition.
I will not press against P2 and P3.
Criminal petition 7044 of 23. Petitioners 2 and 3 are already before this court in criminal petition 7044 of 2023. The learned counsel for the petitioner submits he would withdraw the petition subject petition insofar as it concerns petitioner 2 and 3. One name.
One, my lords, the complaint is filed.
Copy ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಡ್ತೀನಿ sir.
Tomorrow.
ಅಲ್ಲ ಕೊಡ್ತೀನಿ sir.
Fresh matters tomorrow. Yes. Next. ಕಡ್ಕೋಳ್. ಇಲ್ಲೇ ಇದ್ರಲ್ಲ. ಇದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ. This can be allowed. Serial number 3.
Petition for transfer, my lords, was sought for before the Sessions Court.
Petition dismissed.
Petition has been dismissed. Now, my lords, the matter is posted for judgment before the magistrate court tomorrow.
What petition is dismissed? Transfer petition.
Transfer petition has been dismissed. Not against the statement, private party. Offense under 138.
Next matter.
Yes. Don't. We'll stay further proceedings there. ಎಲ್ಲಿ ಇದೆಯಾ?
Mysore, my lords.
Before which court?
My lords, the 10th additional JMFC Mysore.
ಎಲ್ಲಿ prayer ಹೇಳಿದ್ದೀರಾ?
Please, my lords.
Emergent notice to the respondent. There shall be an interim order of stay of further proceedings before the court so and so.
10th additional JMFC Mysore.
So prayer ಇದೆ.
I'm very good.
Yes, next.
Lordships covered by the for the petition. NBW setting is.
NBW.
Lords, this is a case wherein, my lords, after taking cognizance, my lord, the learned
ಗೊತ್ತಾಯ್ತು, covered mat. ಎಲ್ಲಿ judgment ಕೊಡಿ.
197.
annexure F and annexure G, my lords.
ಇಲ್ಲೇ 218. Page 218.
Yes, my lords.
197 and 284.
Hello.
Great.
Same. Suyog.
198 is clear, my lords, when it was challenged, my lords, charge sheet was.
Fire. Husband.
Husband ಇದ್ದಾರೆ. In-laws are also there, father-in-law and brother of the husband. Lords, in interim prayer, my lords.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
I have. Lords, they work it, my lords, abroad, UAE, my lords. The residency permit of, my lords, the father-in-law and the brother will expire, my lords, in the January 2025. I also sought.
Husband will not grant 2 and 3 for now.
And also, my lords, they may be permitted to travel abroad. I have sought in the prayer, my lords. Annexure K, K1 and K2, my lords.
Stay ಮಾಡಿರ್ತೀವಲ್ಲ, consequence. The 2621, only 2 and 3, no husband. The learned counsel for the petitioner submits that on the registration of the, on the filing of the charge sheet against accused 2 and 3, they are not permitted to enter the shores of the nation. They are presently residing in the United Arab Emirates. Therefore, in the light of the interim order granted, there would be no impediment for the petitioners 2 and 3 to travel. Yes.
Travel abroad. They are now here, my lords.
Sorry, travel beyond the shores of this nation ಅಂತ. Yes.
Great.
ಅದೇಂಗಾಗುತ್ತೆ? Crime pending ಇದೆ.
They will come back.
Yes, ಅದೆಲ್ಲ ಏನ್ ಬೇಡ. Yes, next.
My lords, their residency permit will be expiring, my lords, on at least for that, to that extent, my lords. Permission, my lords, till
Where
then.
is, you have produced the residence permit?
Please, my lords, at annexure K1 and K2, my lords. At page number
That's-
126.
List the matter on 4th December in the fresh matters list.
I request
Yes.
on third,
Third, all right.
interim order till then.
That will be there, that entry model.
Great.
ಬೇರೆ ಜೀವೈ ಬಿಯಾಂಡ್ ದಿ ಶೋರ್ಸ್ ಅದೆಲ್ಲ ಏನ್ ಬೇಡ. 2621 entry model 2 and 3 ಅಷ್ಟೇ. List on for 3rd December.
Great.
My lord, appear for the petitioner, the second.
ಎಲ್ಲ ಎರಡೆರಡು petition ಹಾಕಿದ್ದೀರಾ.
My lord, the first petition of memo for withdrawal was filed, my lord.
In terms of the memo, first petition. Second petition, Monday in the fresh matters list.
Monday.
20, ಯಾವತ್ತು? 2nd December. Yes, next. ಗೊತ್ತಾಗುತ್ತಲ್ಲ ಜೀವ? Yes.
For petitioner in this case, my lord.
ಹಾ,
My lord, I may kindly be permitted to withdraw one petition, my lord.
ಯಾವುದು? 4757?
Please, my lord.
In terms of the memo, 4757, 177.1.
Another petition is of the year 2019, my lord.
ಮತ್ತೆ ಎರಡನೇದು ಯಾಕೆ ಹಾಕಿದ್ರಿ ಈಗ?
My lord, what happened in this case, my lord? After the stay was obtained, advocate for petitioner passed away, my lord. His death was not communicated to the petitioner. The stay still subsists in 2019 matter.
ಇದೆಯಾ ಮೇಡಮ್ ಫೈಲ್ ಅದು? ಕೊಡಿ. ಅದು ಬರ್ಲಿ.
Please, ma'am.
ಇಲ್ಲಿ ಬರಲ್ಲ.
Please, ma'am.
ಎಸ್.
There is interim order in 2019 matter.
ಇದೆಯಾ?
Great, my lord.
177.1 interim order subsisting shall continue to the next date of hearing. That's all. 178. ಅಲ್ಲ, ಎರಡಿದೆ ಇಲ್ಲಿ. ಎರಡು ಪೆಟಿಷನ್ ಹಾಕಿದೆ. ಒಂದು ಮೈಂಟೈನಬಿಲಿಟಿ. 4-5 ಇದೆ, ಕರೆಕ್ಟ್. ಯಾಕೆ ಬಂತು ಮೇಡಮ್?
This matter, my lord, your lordships heard sometime.
ಓ, ಅದೇನಾಯ್ತು?
The issue is, my lord, whether sanction under
ಅಲ್ಲ,
section
why
19.
this 178 has come?
My lord, they are all same crime, my lord, they are club, but so far as my case is
ಅಲ್ಲ,
concerned.
178 is second petition is filed. No, 178 ಅಲ್ಲಿ ಪುರುಷೋತ್ತಮ್ ಅವರೇ. Who's Purushottam counsel?
Purushottam.
He has filed, Vinay Kirti has filed another case of the same petitioner, same crime.
Vinay Kirti is online, Vinay Kirti.
Yes, Vinay Kirti. ಅದ್ ನೋಡ್ಬಿಟ್ಟು ಇದನ್ನ ಮಾತ್ರ ಇದು ಮಾಡಿ.
My lordship, 178 ಅಲ್ಲಿ ಫಸ್ಟ್ ಒನ್, my lordship, 8140 of 24. ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಇನ್ನೂ ಆಗಿಲ್ಲ, my lordship.
ಅದೇ ಎರಡನೇ ಪೆಟಿಷನ್ ಹಾಕಿರೋದು, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಆಗ್ಲೇ ನೋಟಿಸ್ ಆಗಿದೆ, ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ. ಎಸ್, ಅದು in the light of the same crime being challenged in criminal petition 1086 of 2022, the petition so filed challenging the very same crime in criminal petition 8140 of 2024 would not arise. The petition is therefore disposed. Petition therefore stands disposed. ಇದನ್ನ ಇನ್ನೊಂದಿನ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕೋಣ. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ 9th ಆಯ್ತು, 9th December. ಇಲ್ಲ, ಇದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ದು. All right, 9th, ಸರಿ. Yes, no problem.
Interim order, your lordship.
Interim order subsisting shall continue till the next date of hearing.
Please.
In this case, my lord, 179.1. I have filed withdraw memo, my lord, on 9/7/2000.
179 point, ಇದರಲ್ಲಿ interim order ಇದೆಯಾ 179? Monday ಆಗ್ಬೋದಾ?
Please, my lord.
179.1 withdrawn, 179 Monday fresh matters list.
180.1, I am filing withdrawal memo, your lordship.
180 interim order ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
Monday ವರ್ಗ ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು.
Yes, Monday fresh matters. Same order.
To appear for the petitioner.
ಯಾವ್ದು ಎರಡನೇದು?
Second one.
181.1 withdrawn.
Yes.
Learned counsel for the petition, memo ಹಾಕ್ತಾ ಇದ್ದೀರಾ? ಇಲ್ಲಲ್ಲ?
Memo ಹಾಕಿದ್ದೀನಿ sir. Already
Files
filed
the
it on
memo
the-
seeking to withdraw the petition. ಮಂಡೇವರೆಗೆ ವೇಟ್ ಮಾಡ್ಬೋದಾ?
304B.
So what? Second, list the matter on Monday in the fresh matters list. Anyways, husband,
Husband and mother, my lord. The victim.
anyways, difficult case, Monday.
Alla,
Yes.
50 days she was in the matrimonial home.
See my judgment and on 304B.
All right, Monday.
Yes, Monday.
182.1 withdraw the petition.
Yes, 182, same Monday, next. 182.1 withdrawn. 182.1 withdrawal.
Please.
Sorry. 183. ಅದನ್ನು ಮಾಡಿ ಅಷ್ಟೇ. In terms of memo ಇದೆಯಾ? 182.2 is also the same. 182 and 182.2.
Challenge the only charge sheet with FIR only 182.15 challenge the charge sheet for FIR.
ಇನ್ನೆರಡರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
A different crime number.
Different, all right, yes. 183.
183.1, they are filed a memo for withdrawal.
In terms of the memo, 183 Monday. 184.
184 only second petition filed before filing a charge sheet, my lord.
ಯಾವ್ದದು second petition?
The second petition 6,482.
Sorry, 184.1 withdrawn in the light of memo ಹಾಕಿದ್ರೆ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಸುಮ್ಮನೆ ಒಂದು ಮೆಮೊ ಕೊಡ್ತೀವಿ.
Learned counsel for the petitioner files a memo seeking to withdraw 184.1 in the light of the charge sheet being challenged in 184. Disposed as withdrawn. Next.
For respondent in 185.1.
185, same.
ಇಲ್ಲ ಅದರಲ್ಲಿ RP ಅನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ I don't have copy. I have only 185.1.
ಇದು ಬೇರೆ ಸೇಮ್ petitioners ಅಂತ ಹಾಕಿದ್ದೀರಾ ಮೇಡಮ್? ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಅಂತ ಹಾಕಿರೋದ? Rest the matter on Monday in the fresh matters list. Next.
Where?
ಇದು ಅದೇನಾ second petition? Which is the second one?
1, wherein earlier we have filed a petition, 186.1.
ಅದು withdraw ಮಾಡ್ತೀರಾ?
Withdraw ಮಾಡ್ತೀವಿ because another petition 186 which has been filed by some other advocate of
Yes.
the charge.
186.1, in the light of the companion petition challenging the charge sheet filed, the present petition which had called in question the FIR is sought to be withdrawn by the petitioner. In the light, withdrawn by the learned counsel appearing for the petitioner. The petition is thus disposed as withdrawn.
But in serial number 60, I'm sorry, mother. In the morning it was called and said at 2:30. I'm told that it has been allowed.
Split.
The split. ನಾವು 1:15 ಆರ್ಡರ್ ಮಾಡಿ ಅಲೋ ಮಾಡಿ.
ನೀವು ಇರ್ಲಿಲ್ಲ, ಅಲೋ ಮಾಡಿದ್ದೀನಿ ನಾನು.
I'm thankful to my lord. I'm obliged.
Because ಮಧ್ಯಾಹ್ನ ಅದು ಒಂದು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತಲ್ವಾ?
ಹೌದು.
ಅಲೋ ಮಾಡಿ.
I'm obliged. Serial number 174.
170?
174. Morning it is passed compromise.
ಸೆಟಲ್ಮೆಂಟ್ ಒಂದೇನು offense ಏನು?
354 finals.
ಏನು 354 ಅಂದ್ರೆ?
Yes,
Offense.
they are friends with us. Prevail issue.
498 ಹೇಳ್ಬೇಕು, 354 ಹೇಳ್ಬೇಕು.
They are the friends.
ಎಲ್ಲಿ parties are present?
They are present.
Both the parties.
Both the parties. Joint affidavit.
ಆಯ್ತು ಕೊಡಿ.
Please.
Yes, ಆಯ್ತು ಅಷ್ಟೇ. Second, respondent counsel. So and so enters appearance. Where is the respondent? Complainant ಎಲ್ಲಿ? ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ
Just pass.
ಇಲ್ಲ ಇದೆಯಾ? 354 B C D ಎಲ್ಲ ಇದೆ.
Indication is that ಅವ್ರ ತಾಯಿ ಮನೆಗೆ ಹೋಗ್ತೀನಿ ಅಂದ್ರೆ ಹೋಗ್ಬೇಡ, ನಾನು ಪ್ರೀತಿ ಮಾಡ್ಕೊಂಡು ಇಟ್ಕೊಂಡು ಹೋದ್ರೆ
ಅಲ್ಲ ಏನ್ ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫಾ?
ಫ್ರೆಂಡ್ಸ್, they are lovers, they wanted to marry.
some trivial issues erupted because of the respective family members. In order to maintain the distance, this complaint was lodged.
354 BCD. She is present. Complainant is present, is it?
Yes.
Is present. Yes, Jagdish, one more. Affidavit ಅಲ್ಲಿ ಇದೆ ತಗೊಳ್ಳಿ. 161 statement. 160 ಏನಾಗಿ ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಓ ಅದು ಬರೀತೀನಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಬಟ್ ಅದು ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕಾಗತ್ತಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ನ ಕೇಳ್ಬೇಕು ಹೂ ಇಸ್ ಅಪಾಯಿಂಟೆಡ್ ಅದು ವಿಲ್ ಗ್ರಾಂಟ್ an interim order and give a date. 160 the petitioner is before this court calling in question the order of appointment of a special public prosecutor. According to the learned counsel appearing for the petitioner, that the petitioner, the special public prosecutor so appointed is well known to the complainant and the remuneration, his remuneration is also being paid by the complainant. This runs completely counter to the law laid down by this court and the coordinate benches of this court in plethora of cases. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. The petitioner shall serve on the counsel who represents on the said counsel and file an acknowledgement to that effect. ಯಾವ respondent ಅವರು? Shall serve on respondent number 4 and file an acknowledgement to that effect. List on 5th December in the fresh matters list. Yes. Yes, sir.
Well, before I make my submissions on the merits of the matter, Lord, I would like to
This is
draw.
that approver thing.
Approved. I would like to invite my Lord's kind attention to the statement of objections in which certain serious allegations are made against the petitioner. May I request your Lordship to kindly turn to paragraph.
Allegations against the petitioner.
Yes, my Lord. Kindly turn to paragraph 19. Now I shall demonstrate the encomiums that are given to the Central Bureau of Investigation by the trial court in a couple of seconds. Who has been protracting the proceedings? Why the proceedings are being protracted? Kindly turn to paragraph 19 for a second. That is the last paragraph, my Lord. It is submitted that the conduct of the petitioner in approaching this honorable court at a belated stage, after a delay of almost 15 days since the passing of the impugned order, is only a thwarted attempt to delay the trial. The purpose of criminal trial is to unearth the truth, and it is a journey or a voyage towards discovery of the truth, which is the ultimate object. The petitioners have made all the attempts at their disposal to delay the culmination of the trial in spite of this honorable court's direction to conclude the trial expeditiously, preferably within a period of 3 months. May I request your Lordship, may I just pass on to your Lordship the proceeding sheet of the case in which your Lordship would find the encomiums that are given to the prosecution by the learned trial judge, who has been protracting the proceedings, for what reason, for what purpose the proceedings are being protracted. Your Lordship would see. May I request your Lordship to kindly turn to the proceeding sheet dated 21/10/2020. Your Lordship, kindly turn to 15/11/2024. Well, let me submit your Lordship what transpired on 14/11/2024. Lord Justice. Would your lordship kindly go to the proceeding sheet of the case dated 15/11/2024. On that
Yes.
day,
Is
Yeah.
given pardon.
a person by name Shivananda Srishaila Biradar, who came to be treated as an approver in the case, was present before the court.
ಬಸವರಾಜ್ ಮುಟ್ಟಗಿ ಅಂತಿದೆ.
ಅದು ಅವನ್ ಬೇರೆ. ಇಲ್ಲಿ 15/11, kindly go to
ಯಾವ್ದ್ರಲ್ಲಿ
page 309,
ಮೇನ್ ಪಿಟಿಷನ್
proceeding sheet.
ಈ ಕೊಟ್ಟಿದ್ದು
ಹೌದು, ಈ ಕೊಟ್ರು.
15/11 case called out, accused number 1 Baswaraj Muttagi is given pardon, SPP is present, office is hereby directed so and so.
Next, next bottom, puna 15/11.
Approver by name Shivananda Sri Shaila Biradar.
Kindly go to the next page, madam. Kindly go to the next.
Yes,
Case
ma'am.
called again. Approver by name Shivananda Sri Shaila Biradar is present before the court and he is examined as PW9 and fully cross-examined for further trial by 16/11/2024. My lord, on 15, in the later part of 15/11/2024, this A9 who was given the pardon, benefit of pardon, and who came to be examined as a witness on behalf of the prosecution, he having not chosen to toe the line suggested to him by the prosecution, came to be treated hostile by the prosecution, and he was cross-examined by the prosecution and thereafter by the defense. But he came to be examined by the prosecution with regard to the charge that is framed against the accused for an offence which is made penal under the provisions of the Arms Act. But then the trial was adjourned to 16/11/2024, on which date, my lord, also the prosecution was required to keep 2 other witnesses who would corroborate the statement of the approver. My lord, on 16/11/2024, 2 witnesses were present before the court and they were made to stand outside the court. When the case was called, the prosecution was asked whether the witnesses who are summoned for the day are present or not. The prosecution would say that we have no idea or we have no information about their presence before the court. My lord, their names were called. They appeared before the court saying that we are so and so. Now kindly read this 16/11/2024.
Yes.
My lord gets it, my lord? CWs 56 and 57 are present before the court and they are discharged. Why they are discharged? My lord, on 15/11/2024, the public prosecutor will examine that approver. He would even cross-examine him. The defense also would cross-examine him. Suddenly, my lord, maybe for, I don't dispute the fact, he would fall sick. The public prosecutor would fall sick on 15/11/2024 at a point of time when CWs 56 and 57 were present before the court. I am not disputing, my lord, for a moment, the fact of he having fallen sick. But what the defense would submit to the court is, at least you should have kept us informed that he is likely to fall sick when 56 and 57 are before the court, for one reason or the other. That was our grievance. Now kindly read the encomiums which the court would give.
Yes, I've seen.
It is rather unfortunate to note that in spite of providing sufficient opportunities, the prosecution are unable to furnish appropriate details of the witness they are intending to examine. Repeatedly, the checkered history of the case indicates that the case was posted for fixing the date of trial, and thereafter some witness lists were being filed by the prosecution without ascertaining the list which they had filed earlier. Earlier, they would file one list, but subsequently the entire list gets changed. In the next list, my lord, instead of eyewitnesses, recovery witnesses, punch witnesses, handwriting expert would come into picture now. Doesn't matter. Now kindly read the next paragraph. In other words, there should be some sort of continuity in conducting trial, which unfortunately is found lacking. Though this court had fixed the date of trial continuously, much progress is not being seen, which is causing a lot of inconvenience to the court since the court is unable to take up other cases. Accordingly, the head of Bureau of CBI, not the defense, the head of Bureau of CBI is hereby directed to look into the matter and strictly instruct the concerned to conduct the trial in accordance with law and as contemplated under the law. These encomiums. So did I protract the proceedings? Now, my lord, kindly no, it will not stop there.
No worries, he will retract the statement.
Now kindly go to the next paragraph. Without there being any further alternative, the court has reluctantly once again posted the case for fixing the date for trial, since on the last stretch of dates, majority of the witnesses were not examined by the prosecution. What is his allegation against me in paragraph 9? That I am protracting the proceedings. Now kindly go to the 22/11/2024 proceeding sheet. The learned SPP 22/11.
Yes, sir.
The learned SPP has filed a memo along with list of witnesses to be summoned. In the said memo, it is noticed that the prosecution is intending to summon CW 153, Dr. Kumuda Rani, who is an handwriting expert, in order to prove the letter allegedly received by the deceased Yogesh Gowder prior to his murder, which would be deposed by Basavaraj Muttalagi. Handwriting expert would come up instead of the rest of the material witnesses. It is relevant to note that the Honorable High Court of Karnataka, by its kind order, has deferred the recording of evidence of approver Basavaraj Muttalagi. As such, after recording the evidence of CW 153, the court will have to defer the cross-examination, since the evidence of Basavaraj Muttalagi is yet to be recorded. That apart, CW 13 and CW 14 are stated to depose about the motive in the above case. It is pertinent to note that some of the witnesses who were examined already by the prosecution speaks about the motive. Eldernu edit sentence so adjourned. Not even their examination chief is complete. For instance, PWT has already deposed about the motive and intention, and even his cross-examination is deferred. On that day, a submission was made that some of the witnesses were to speak about the motive. The court today has posed a question to the learned SPP that how many witnesses cited in the charge sheet would speak about the motive and intention. The learned SPP submits that there are some other witnesses apart from the one who are mentioned above to depose about the motive and intention to commit the murder. Under such circumstances, it is observed that once again the case will be deferred for cross-examination, since the corroboration would be required. Unless a particular type of witness is the eyewitness, witnesses who speak about the motive and intention, expert witnesses are flocked together and examined, effective cross-examination will not be conducted by the defense, wherein the learned counsels for accused have also made a submission that for the purpose of corroboration, they have to be examined together. As such, the list of witnesses proposed to be examined is not conclusive, and in spite of granting a week's time to the prosecution, they have not come up with proper list. It is not the duty of the court to remind the prosecution to file a proper list of witnesses to conduct effective trial. Accordingly, again, my lord, the head of Bureau of ACB CBI, Bengaluru, is hereby requested to provide necessary assistance to the learned SPP in order to prepare the list of witnesses for conducting effective and expeditious trial.
ಇವರೇ ಅಪೇರ್ ಆಗ್ತಾರಲ್ಲಿ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅಪೇರ್.
SPP ಬೇರೆ ಇವರೆಲ್ಲ ಇಲ್ಲಿದು ಇವರು ಇಲ್ಲಿಯವರು ಈ ಅಬ್ಜೆಕ್ಷನ್ presumably he was not kept informed about the encomiums that are given
Is not
or the
informed.
compliments that were given by the trial court. But he now, in the statement of objection, he would put the blame on us, saying that we have been protracting the proceedings. That would be the first point. Well, the second submission, let Lordship may kindly see, let me take your Lordship again to paragraph 19. It is incorrect, wholly incorrect. He should not have made this. That is why, my lord, I want to counter his submissions. It is submitted, my lord, the order itself was not signed. I shall show to your Lordship on 30th now. Well, it is submitted that the conduct of the petitions in approaching this honorable court at a belated stage, after a delay of almost 15 days since the passing of the impugned order, is only of the thought the attempt to delay the trial. Well, the order came to be passed on 30th October, no doubt. Well, may I just request your Lordship?
Uploaded on 11th.
Well, that signature was put on 11th. I shall take your Lordship. No, one must be careful and cautious in making certain atrocious allegations. What for it was made? Is it to prejudice the mind of the court? But kindly go to internal page 45. The order was passed on 30th of October 2024.
Digitally signed on 8/11/24.
My lord, dictated to the stenographer, grade 1 in open court from 12 noon to 1 p.m. Your lordship may recall to your lordship's memory, last time I made this submission, which has not been seen in any of the orders which came to be passed and pronounced in open court on this 30th day of October 2024. Then, my lord, what the learned judge would say is, digitally signed by so and so, date is 8/11/2024. My lord gets it, my lord? So 8/11/2024 it was signed?
11th, I think it was uploaded. Last time you told me.
My lord, yes. Then, my lord, I would file this on 12/11.
Next day.
Next day, I make a motion before this honorable court on 13/11/2024 to take up the matter in the afternoon session of the day, because on 14th, my lord, the approver was summoned for the purpose of giving evidence in the case. Am I protracting the proceedings? Or I did not tell the trial court to pass wrong orders? I'm sure your lordship would certainly agree with me that I have a right. If in my wisdom, my lord, if I were to see that the order that is passed by the trial court is incorrect, inaccurate, illegal, unacceptable, I am not entitled to question it. I am certainly entitled to question it. Ultimately, it is for your lordship to decide whether what I have questioned is right or wrong, whether I am justifiable or not. Is it with ulterior motives that I have filed this petition and questioned the order which came to be passed by the trial court? But I am a little bit pained because this should not have been the statement of objections which came to be filed by the prosecution as stated in paragraph 19 of the statement of objections. Well, now let us go to the merits of the matter now. But this application is under section 306. Well, probably I may have to humbly request your lordship to grant me some time, because
ಎಷ್ಟೊತ್ತು ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಇಲ್ಲ ಇದರಲ್ಲಿ probably your lordship may have to.
ನಾನು ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ, ನೀವು ಎಷ್ಟೊತ್ತು ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ.
Then it is all right. I'm sorry.
I guess
kindly permit me to take your lordship in detail.
So you can take any.
Probably it may warrant a law being laid down by your lordship in this case under section 306 of the CRP.
One second.
That's why, my lord, I would like to do it.
Hand delivery ready ಮಾಡ್ಬಿಡಿ.
My lord, he is the first accused in the case. Earlier, the trial was there. Nearly about 66 witnesses came to be examined before the sessions court.
By the state.
By the state.
Yes.
He kept quiet for years and years. He kept quiet. For years and years, he kept quiet. The matter was even statement of the accused under section 313 came to be recorded.
At that stage, it was transferred to the CBI.
At that stage, it was transferred and then investigation. Even thereafter, he participated in the proceedings of the case for 3 years, even after the filing of the charge sheet by the CBI. Doesn't matter. Well, I am not concerned with the incident.
The accused number 1.
Accused number 1 participated in the crime for 3 years.
Because he had himself filed 482 before me.
Yes.
To quash the
Well,
proceedings.
witnesses were examined. Subsequent thereto, after the trial came to be transferred to the special court, witnesses came to be examined. Well, on 13th of March 2023, on 13th of March 2023, this first accused, now to whom, my lord, the pardon has been given, and to treat him as a witness on behalf of the prosecution, would make an application under section 306 of this CRPC.
That is rejected.
13(3). Well, I would like to draw my lord's kind attention
Page.
to the application which he has filed and the order which came to be passed by the trial court on that application.
Page.
The application your lordship would get at page 146. Kindly go to page 146. A 1-paragraph application, because your lordship the other day posed a question to me. Your lordship may recall to your lordship's memory. Leave alone.
SQ 164.
SQ 164.
Pardon can be granted.
Can he grant it on the basis of such kind of bald applications? Is the question that warrants consideration at your lordship's hands. Well, kindly permit me to take your lordship to the contents of this application, which is in one paragraph at page 146.
Yes.
That in the top noted case, accused number 1, Basavaraj S. Muttagi, seeking permission for approval to tender evidence as accused number 1 is ready to give tender. As accused number 1 is ready to give tender of pardon. I don't know to whom he wants to give tender of pardon. Doesn't matter, my lord. That is the application which he has filed, probably to the prosecution or somebody. In support of the prosecution. And in this regard, said accused number 1 is also ready to give section 164 of CRPC statement as a confession. Hence, Honorable Court be pleased to kindly accept a tender of pardon. He is giving to the court probably. Accept a tender of pardon of accused number 1, Basavaraj S. Muttagi. And in the support of this application, accused number 1, Basavaraj Muttagi is filing affidavit as the same is made voluntarily without any threat or influence.
Sadly worded. Sadly worded.
Sadly worded. And no basis for the court to have.
So what
given it.
happens to this application?
Well, no. This application came to be opposed by the prosecution.
Oh,
Yes, my lord. Kindly go to.
where is the objection?
Yes, my lord, 148. What they say is, no. Issue a direction for recording a statement under 164. But 164 does not come into play no sooner the inquiry or trial commences. It is only during investigation. The court has no jurisdiction at all, either to direct or itself record the statement under section 164. Because till such time, my lord, he is treated as a witness for the prosecution, he is an accused. Kindly go to page 148 now. Kindly permit me, my lord, I shall skip, my lord, paragraph 1 and 2. I shall take your lordship to next paragraph.
He has not quoted how he is going to support the prosecution. So
Yes, my lord, that is the basic essential ingredient to invoke the jurisdiction of the court under section 306. What is his role? What is the role of the other man? What is it that he is going to depose? My lord, what the trial judge, I shall take your lordship, did was, no, I am going to give you pardon, but I shall wait whether you are going to support the case of the prosecution or not. Therefore, I will direct the magistrate to record a statement under 164. I will secure it. I will find out. I will read it. Then I will give you pardon. That is, my lord, if I may say so with utmost respect, my lord, that is not the duty of the presiding judge. Kindly go to paragraph 3 now for a second.
yes.
It is humbly submitted. This is a statement of objection. It is humbly submitted that on perusing the application, CBI could not able to ascertain on disclosure of which facts, fortunately, favorably to me, the petitioner is going to support the prosecution case. Well, it is only for the similar application. It is for this purpose, the learned trial judge, the order impugned, my lord, would direct the magistrate to record.
So what order is passed on this?
No, I shall. My lord, I shall read this. I shall just 4 or 5 sentences,
Yes,
my lord.
yes.
It is further submitted that the affidavit attached with the application also is devoid of merits. It is pertinent to mention that the purpose of section 307 of CRPC is to obtain the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense during investigation or inquiry or trial, and the same could not be proved by the available evidence by the prosecution. Kindly pause for a minute. Well, if the evidence that is which the investigator had collected during the course of the investigation of the crime is certainly insufficient.
According to them, it was sufficient.
My lord,
No, that's what.
8 eyewitnesses in the case. 6, earlier they have been treated hostile. Subsequent to the CBI taking over the investigation, they have examined 2 eyewitnesses. Their statements are there. Their statements under 164 is also there, unless and until they say that from the evidence which we have been able to collect subsequent to the notification issued by the state government is certainly insufficient to make out a case against the accused, then only, my lord, the court can do it. That is what they would say here. And the same could not be proved by the available evidence by the prosecution. Well, kindly read the next paragraph. This would be very, very important. In this regard, it is respectfully submitted that this honorable court may be pleased to direct the petitioner to record his confession statement under 164 subclause 1 CRPC, and after perusing the recorded confession statement of the petitioner, prosecution will be in a position to take the appropriate decision. Right. Well, they would make a request to the court to direct the accused to make a statement under section 164, which the court can't do it. Even the magistrate also can't record a statement under 164. I shall take your lordship to the provisions little later after taking your lordship to what is the order which can be passed by the trial court. May I request your lordship to kindly turn to, it commences at page 124. Well, the relevant paragraph, the order commences from paragraph 17 at page 142. But this order came to be passed by the trial court on this application on 29th of April 2023. This order has attained finality. Commences at page 124. Kindly go to page 142, paragraph 17. My lord gets it. I have gone through the sections 306 and 307 and 308 of CRPC. There is no bar either under section 306 or 307 CRPC to tender pardon to an accomplice. And the court can tender pardon any stage of the investigation or inquiry into or the trial of the offense. But there is no quarrel with regard to the jurisdiction of the court during inquiry or during trial. Absolutely no quarrel. The court certainly has a jurisdiction under section 306. Seeking, accused number 1 has filed the application under section 306 of CRPC, seeking tender of pardon from this court. In the application filed by the accused number 1, he stated that he is ready to give tender of pardon in support of the prosecution. And in this regard, he is ready to give statement under section 164 of CRPC, not in support of the prosecution or in support of the defense, my lord. What transpired and what is the role played by him, what is the role played by the other. As a confession and prayed for granting pardon. In the affidavit, he has stated that the contents of the application are voluntarily made and no person has influenced and threatened him to file this application. There are no specific grounds urged under which he seeks pardon. The accused has not stated his role in the case. He has not explained the role of the other accused. He has not stated why he is seeking pardon and how his evidence helps the court to bring home the guilt of the accused. The dominant object is that the offenders of the heinous and grave offenses do not go unpunished.
Para 19, the entire crux.
He
rejects it for the reason that he has no confidence on the.
I'm sorry, my lord, kindly pardon me.
Yes.
Kindly pardon. The legislature in its wisdom, how beautifully the learned judge has written the order. No, my lord, he does not even refer to this order at all, which is bound to. That is what the Supreme Court has said.
No, seeking pardon will not conclude in one stroke. In the sense, today it is rejected. It is not a bar to seek pardon again. It's a different thing. But this should have been referred to.
Referred to, that is number 1. Number 2, when he seeks for the second time the pardon, it must be the change in circumstance. No, an application then I will take your lordship with the order. But
on the same circumstance, you can't keep seeking.
But kindly imagine the situation. All the 18 would, there are 17 or 18 accused. One after the other will keep making the applications.
Yes.
No, but kindly go to. The legislature in its wisdom considered it necessary to introduce this section and confine its operation to cases mentioned in section 306 of the court. The object of section 306, therefore, is to allow the pardon in cases where heinous offenses are alleged to have been committed by several persons, so that with the aid of the evidence of the person granted pardon, the offense may be brought home to the rest. The basis of the tender of pardon is not the extent of the culpability of the person to whom pardon is granted, but the principle is to prevent the escape of the offenders from punishment in heinous offenses for lack of evidence. The prosecution has filed objections and contended that the CBI could not be able to ascertain and disclosure of which facts the petitioner is going to support the case of the prosecution, and the affidavit attached with the application is also devoid of merits. Further, it is contended that this court may be pleased to direct the petitioner to record his confession under section 164(1) of the CRPC, and after perusing the record of confession statement of the petitioner, the prosecution will be in a position to take the appropriate decision. This court cannot direct the accused to give a confession statement under section 164(1) of the CRPC, which is self-incriminating. In this case, the learned judge passes an order directing the accused to go and make a statement and directs the magistrate to record his 164 statement. Kindly read the next sentence, my lord. However, grant of pardon to one prime accused in the case is satisfied that this is the accused who is going to make full and true disclosure of the whole of the circumstances within his knowledge relating to the offense and to every other person concerned, whether as principal or abettor in the commission thereof. Now, my lord, I will take your lordship to paragraph 19, as my lord has pointed out. When the accused is not ready to disclose either his role or the role of the other accused, that is in the application. That is in the application.
Application, correct.
That is in the application. How this court can expect from the present accused that he would make full and true disclosure of the whole of the circumstances within his knowledge relating to the offense? This court is not aware as to how much information is known to the present accused regarding the commission of the alleged offense, and whether he had participated in the larger conspiracy to commit murder of Yogesh Gowda, and if so, who is the key conspirator to commit the offense of murder of Yogesh Gowda. I do not think that the tender of pardon will be in the interest of successful prosecution of the other offenders whose conviction is not easy without the approver's testimony. Kindly underline this, Miller. It will be indubitably agree to tendering of pardon. Therefore, I am not satisfied that a tender may be granted to the accused number one, Basavaraj, on the ground that he would make full and true disclosure on the whole of circumstances within his knowledge relating to the offense. He has shirked his responsibility to disclose his role and the role of the other accused in the commission of offenses while filing this application before the court, and therefore this court has no confidence with him that he would make a full and true disclosure of the whole of the circumstances relating to the offense. Therefore, I answer point number one in the negative. Application came to be rejected.
It has become final.
It became final. It was not questioned. Subsequently, my lord, what would transpire is on 19th of October 2024, a second application came to be filed.
Where do I get that?
Yes, my lord. Probably after the change of guard in the court, a second application came to be filed.
Oh, change of guard in the court.
Change of guard
in the court.
Of the presiding officer of the court.
ಅಲ್ಲಿ change ಆಗಿದಾರ ಈಗ?
Change ಆಯ್ತು ಆಮೇಲೆ. ಇದಾದ ಮೇಲೆ ಆ ಅಪ್ಲಿಕೇಶನ್ ಬರುತ್ತೆ.
ಯಾಕೆ ಇವರೇ ಅಲ್ವಾ ಇರೋದೀಗ?
ಇಲ್ಲ. ಇಲ್ಲ. My lord, this is signed by
special judge is changed, is it?
No, my lord, special judge B. Jayant Kumar. Earlier order. Your lordship may kindly go to page 140.
Earlier order is somebody else.
Yes. That is why I submitted, my lord. New presiding officer. My lord, I have nothing. See, incidentally, I thought of bringing it to your lordship's notice.
No, I thought this present man is.
Illa.
Yes.
My lord, kindly go to page 92 now for a second. On 19th of October 2024, the second application is filed. Kindly go to page 94.
Yes, I am there.
92, I'm sorry, 92.
92, 93.
Very next page, my lord, after the order. Kindly go to 92 now. My lord, para 2, the applicant is facing threat for his life from various corners, including the accused number 15 and 16 in this case. The threat faced by this accused is constant. In this case, from the commission of crime till now, the threat perception persists. ಅದಕ್ಕೂ 306 ಸಂಬಂಧ ಇಲ್ಲ. ಥ್ರೆಟ್ ಇದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿ, FIR ಆಗಲಿ, ಅರೆಸ್ಟ್ ಮಾಡಲಿ, And the prosecution on the basis of this statement would even go to the extent of making an application before the court seeking for cancellation of bail. That application came to be rejected. Well, now kindly go to paragraph 3 now. The accused submits that after introspection of the entire event, the accused decided that he should reveal the true facts before this honorable court to save the ends of justice. On the earlier occasion, this accused has filed an application seeking pardon. However, the same was not appreciated by the honorable court as confession statement under section 164(1) CRPC was not available before this honorable court for consideration. Yellide? But the trial, in the earlier order, your lordship did not find this. In the earlier order, what the court would say is, no, sorry, I can't direct the accused to go and make a statement under section 164. The stage has gone. Inquiry has commenced. Trial has commenced. Witnesses are being examined. Charges are framed. In the exercise of the powers clothed upon the court under 164 CRPC, the court cannot direct. And even the magistrate becomes functus officio in recording the statement under 164. Accused submits. Well, kindly go to the next paragraph. Accused submits that he has to disclose the truth before this honorable court for the sake of justice.
No,
And
this accused has been seeking pardon for the third time now.
Second time.
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾವ್ದು annexure C2 ಅಂತಿದೆಯಲ್ಲ ಅದೇನು ಅದು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಇದು ಡೀಟೇಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಇದೇನು
ಹೌದು ಇಲ್ಲ ಇದು ಅಬ್ಜೆಕ್ಷನ್
ಅಲ್ಲಲ್ಲ
Your lordship is referring to
page 100 to 103
100 to 103.
it's a detailed application seeking pardon.
ಅದು ಐವೋಗೆ he writes a letter to the IO.
To the IO, yes.
ಅಷ್ಟೇ. Well, the accused submits that he has to disclose the truth before this honorable court for the sake of justice. And if this honorable court pleased with the disclosure of the fact, it may take appropriate decision to pardon or otherwise. The accused is ready and willing to depose before the magistrate, disclosing his role and the role of the other accused in the commission of the crime. The accused may be provided proper security from the central agency. Well, even in this application also. Well, now kindly go to paragraph 5.
Yes.
The accused number 1 prays that this honorable court may be pleased to allow the accused to disclose the true facts under section 164 CRPC to attain justice. Well, this application, which is as bald as it should have been, it doesn't say anything. What is the role? Well, earlier, what the court would pass an order is, you should say what is the role you have played? What is the role the other accused have played? To what extent your evidence is going to support either the defense or the
Your
accused?
suggestion is the application should contain everything. There cannot be a recording of 164 statement for the purpose of consideration of pardon.
But here,
no, that's this.
yes, that is the legal. But here, two things are there. 164 can't be recorded at all. I shall show to your lordship presently. 164 can't be recorded. That is number 1.
So the first application was bald. The second application is equally bald. The first order rejecting it is there. The second order accepting it is on the ground that 164 statement gives everything. So according to 164 statement is a nullity.
Yes, it is a
If it is
nullity in the eye of
it
law.
should go only on the application.
But the learned trial judge will pass the order solely on the basis of statement that recorded under 164.
That's what I see on page.
I shall take your lordship now.
Page 61 of the order on.
Yes, but the accused has said in his 164 statement, the accused has said in his 162. No.
No, you should only tell me the illegality with recording of 164 statement prior to the grant of pardon. That's all. That's all that's necessary.
May I request your lordship to kindly have a cursory look at 164 for a second now?
Yes.
But that,
if that's,
Please,
sorry to interrupt, but
No, my lord,
if that is the submission.
No, your lordship
then-
is trying to save the
No, if
impressions.
what I have understood is the
Time of the
submission
court.
of yours, then it.
No, ಇದಕ್ಕೆ ಇನ್ನೊಂದು ನಾನು ತೋರಿಸ್ತೀನಿ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಒಂದ್ಸರಿ.
ಹಾ.
ಇದಕ್ಕೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
ಯಾವುದು CBI?
Yes, my lord. But the second application, on the same day, even application 1910,
Handwritten objections.
ಹೌದೌದು ಅಲ್ಲೇ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಎಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿದೆ. Kindly go to page 94. Well, ultimately,
99 ಗೆ ಬನ್ನಿ. In
94.
view of the discussion, it is
No, no,
humbly
94.
prayed, this honorable court may be pleased to deny the petitioner to record a confessional
ಹೌದು.
statement under 164(1). What deny, sir? Prasanna Kumar sir.
next ಇನ್ನು ಹೇಳೋದು
ಅಲ್ಲ
ಇನ್ನೊಂದು
ಡಿನೈ ಅಲ್ಲ, ಡೈರೆಕ್ಟ್ ಅದು.
ಅದು ಡೈರೆಕ್ಟ್ ಅಂತ ಇರ್ಬೇಕು.
ಟೈಪೋಗ್ರಫಿ ಕೈಯಲ್ಲಿ ಡಿನೈ ಅಂತ ಬರೆದುಬಿಟ್ಟಿದ್ದಾರೆ, ಡೈರೆಕ್ಟ್ ಅದು.
ಅಲ್ಲದ ಇದರಲ್ಲಿ kindly go to page paragraph 98 now. That is the typed copy, Milad.
Yes, yes,
Handwritten is 94.
yes.
Typed copy is 98.
I have humbly submitted.
Yes. It is humbly submitted that on persisting application, CBI could not be able to ascertain of which facts the petitioner is going to support the prosecution version. At least for the
So
first time, they are signing
Now
with
the
me.
entire issue revolves around 164 statement,
ಬರ್ತೀನಿ.
whether that is permissible or not.
ಬರ್ತೀನಿ. ಒಂದು ನಿಮಿಷ.
Yes.
Well, then what is the basis for the trial court to have exercised its jurisdiction under section 306? It is for mere asking? Is it for mere asking that the court can exercise its jurisdiction under section 306 is the question, next question. It can't be. That's what the Supreme Court has said. But it is humbly submitted that on persisting application, CBI could not be able to ascertain of which facts the ಇನ್ನೂ ಒಂದು ತೋರಿಸ್ತೀನಿ ತಮಾಷೆ. 164 ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ, it is more a matter of my lord, a regular practice that court ನಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಎಲ್ಲರನ್ನು ಆಚೆ ಕಳಿಸಿ ಮಾಡಿ ಕೂರಿಸ್ತಾರೆ. ಈ ಲಾಯರ್ನ ಕೂರಿಸ್ಕೊಂಡು 164 ಮಾಡಿದ್ದಾರೆ ಅಂತ ಜಡ್ಜ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಲಾಯರ್ ಕೂತ್ಕೊಂಡು ಅವ್ರ ಪಕ್ಕದಲ್ಲಿ ಮಾಡಿರೋದು. I shall show to your lordship now.
ಅಲ್ಲ ಎಲ್ಲ ಆಗೋಗಿತ್ತಲ್ಲ, ಇದು 164 at a later stage ಅಲ್ಲಿ ಹೀಗೆ ಆಗದು.
ಅಲ್ಲಲ್ಲ 164 ನೇ ಲಾಯರ್ ಪಕ್ಕದಲ್ಲಿ ಕೂರಿಸ್ಕೊಂಡು ವಿಟ್ನೆಸ್ ಮಾಡಿರೋದು.
ಮುಂಚೆ ತಗೊಂಡ್ರೆ 164 ಯಾರು ಇರಲ್ಲ. ಇದು ಟ್ರಯಲ್ ನಡಿಬೇಕಾದ್ರೆ 164 ತಗೊಂಡ್ರೆ ಲಾಯರ್ ಇದ್ದಾರೆ ಸರ್ ಪಕ್ಕದಲ್ಲಿ.
In fact, ಎಲ್ಲರನ್ನು ಆಚೆ ಕಳಿಸ್ತಾರೆ. Other than the court officers or officials, my lord, whose assistance is needed for the court for the purpose of typing or taking the dictation and all that. ಲಾಯರ್ ಇದ್ದಾರೆ, ತೋರಿಸ್ತೀನಿ. ಅವ್ರ ಲಾಯರು, ಯಾರ ಲಾಯರು? ಅಪ್ಲಿಕೆಂಟ್ ಲಾಯರು, ಅಕ್ಯೂಸ್ ಲಾಯರು. Kindly now go to paragraph 3 at page 98 for a second.
Yes, sir.
It is humbly submitted that on persisting application, CBI could not be able to ascertain of which facts the petitioner is going to support the prosecution version. It is further submitted that the affidavit attached with the application is also devoid of merits. ಅವರೇ ಹೇಳ್ತಾರೆ, fortunately for me, instead of me saying it, they support my cause. It is pertinent to mention that the purpose of section 307 CRPC is to obtain the end of any person supposed to have been directly or indirectly concerned in privy to an offense during the investigation or inquiry or trial, and the same could not be proved by the available evidence by the prosecution. In this regard, in respect, it is respect of submitted.
ಅಲ್ಲ ಅದು ಸಿಂಟ್ಯಾಕ್ಸ್ ಎರರ್ ತುಂಬಾ
ಅಲ್ಲ, typist ಸರಿ ಇಲ್ಲ.
is very bad.
ಅಲ್ಲ ಒಂದೇ. In this regard, it is respectful ಅಂತಿರ್ಬೋದು. We shall read proper. My lord, I am not saying anything.
That's all.
That this honorable court may be pleased to direct. ಇದು ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ಪ್ರೀವಿಯಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ, ಅದರ ಕಾರ್ಬನ್ ಕಾಪಿ. It is pleased to direct the petitioner to record his confession statement under 164 on the CRPC, and after perusing the recorded confession statement of petitioner, prosecution will be in the petition action. When the court can't look into it at all, ಇದು ಅವರು they are making the court to commit mistakes. ನಾನು ಅದನ್ನು ಕ್ವಶನ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾರೆ ಇವರು ಇದರಲ್ಲಿ. Time and again you are before this court. You are making the court to commit blunders. ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿಸ್ಬಿಡಿ, ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ ಅವ್ರ ಪ್ರೇಯರ್, ದಟ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್. ನೋ ಮೈ ಲಾರ್ಡ್, ಮೇ ಐ ರಿಕ್ವೆಸ್ಟ್ ಯು ಲಾರ್ಡ್ಶಿಪ್, kindly go to C2, my lord. C2.
Yes, sir.
Date ಇಲ್ಲ, month ಇಲ್ಲ, time ಇಲ್ಲ, ಅವನ application.
C2, sir.
No, C2.
Page
100. Your lordship has referred to it little earlier.
tender.
Not before, made by the,
Yes,
before
sir.
the investigation. Same thing. It is of no consequence.
Yes, sir.
May I now request your lordship to kindly go to the order which came to be passed by the learned trial judge at page 47.
Yes.
on 13th of October, 2024. Commences at page 47.
Yes.
But I shall skip facts of the case. The law and judge would write. Kindly go to page 57 now. At the bottom, last two sentences at the bottom of page 57.
In very extractions. Reasons commence at 63. Shorn of unnecessary.
ಅಲ್ಲ ರೀಸನ್ಸ್ ಮುಂಚೆ ಇಲ್ಲಿ ಬರೀತಾರೆ ಏನ್ ಬರೀತಾರೆ ಇದೊಂದೇ ಸೆಂಟೆನ್ಸ್ ಬರೆಯೋದು earlier order ವಿಚಾರ ಅದಕ್ಕೋಸ್ಕರ ಐ ಆಮ್ ಜಸ್ಟ್ ಐ ಥಾಟ್ ಆಫ್ ಇನ್ವೈಟಿಂಗ್
Page 57, sir.
Yes, well, page 57, last two sentences. It is also been submitted that on an earlier occasion, because your lordship posed a question, has he referred to it or not, filed an application seeking pardon. However, the same was not considered by this court as his confession statement under section 164 CRPC was not available before this court. No?
No, one moment, sir. His 164 statement was recorded by the state and by the CBI earlier.
No?
No, no, not for the purpose of 306.
No?
For,
Accused, Miller, how could they record his?
oh, accused.
He is the accused.
Yes.
They could not have. He would not have obliged. For more than one reason, he is now obliging.
Now, the question is, 164 statement, as I have known, is recorded prior to the commencement of the trial.
Right.
Once the trial commences, recording of 164 is not available.
Not
That is
available.
what, subject to correction.
No, I shall take your lordship to the provisions of law.
If 164 cannot be recorded after the commencement of the trial or at this stage of trial, whether it can be done for the purpose of 306 is what is.
Adu, the statute should close powers upon him.
Yes, 306.
No, no, whether it is 306 or 161 or whatever it may be, my lord, the magistrate has no jurisdiction to record. The learned sessions judge
Could not
is
have
asking him to
directed
commit a mistake. He is asking him to commit a blunder by issuing a direction to the magistrate, which he could not have done under the statute. Well, I shall take your lordship to the provisions of law.
Now, for illustration, if this is permitted, now every court, court of session during the trial may direct magistrate to record 164 statement and get it before.
ಕ್ವಶನ್ ಮಾಡಿದಾಗ ಈ ತಾಪತ್ರೆ ಆಗುತ್ತೆ ಕ್ವಶನ್ ಮಾಡದೇ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರುತ್ತೆ if it is questioned before your lordship,
Yes, sir.
then the problem arises. Otherwise, no. But what the law says is first tender pardon and then record statement. Ili putting the cart before the horse.
No, after tendering pardon, definitely it is cross
ಅಷ್ಟೇ
examination.
ಅದೇ ಅಷ್ಟೇ ಇರೋದು ಇನ್ನೇನು ಇಲ್ವೇ ಇಲ್ಲ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ನಲ್ಲಿ
After tendering pardon, he will give examination.
ಅಷ್ಟೇ.
Recording of
ಅದು ಬಿಟ್ಟು
statement.
ಬೇರೆ ಏನು ಮಾಡಕ್ಕಾಗೋದೇ ಇಲ್ಲ. But for the purpose of finding out whether he is going to support the case of the prosecution, he can't be directed to go on the.
One clarification. Once he's tendered pardon.
Yes.
After tendering pardon. the court-
164 ಇಲ್ಲ.
What is that statement?
That is regular evidence.
It is not 164.
Oh.
So I just.
Well,
want to
what
know,
happens is this-
164 is not available after the trial commences in terms of this
Because he
statute.
becomes a witness for the prosecution.
Yes.
He becomes a witness for the prosecution. And after the trial commences, no one can record his 164. Well, kindly go to, well, where does he find this, the learned judge? However, the same was not considered by this court as his confession statement under section 161 CR was not available before this court. No, what the learned judge, I invited my lord's attention, he says is that I can't direct the accused to make a statement under section 164 because that becomes inculpatory. I can't ask him to make evidence against himself.
No, that is true.
That is how the learned judge does not dispose of the application or reject the application on the ground that your 164 statement is not there. No, he dismisses the application on the ground that your application is bald. It does not contain the details that are needed. I can't direct the recording of the statement of the accused under 164. You have not shown or said anything about the role which you have played and the role which the other accused have played, so that I could come to a conclusion. That is number one. Number two, my lord, he would also dismiss the application on this score that unless and until the prosecution contends, but for his evidence, as an approver, it is difficult for us to make out a case against the accused. That is the law. That is the correct legal position.
So after granting pardon, he is subjected to examination and cross-examination. In a normal way, evidence takes place.
He becomes
during-
a witness for
during
the
trial.
PW1, he becomes
He's a
PW1,
witness.
PW2, PW3.
The accused is transposed as a witness,
it.
he is examined and
Mela-
cross-examined. by
Melody,
the-
instead of a larger box, he comes into a smaller box.
Yes.
That's all. Larger box is more than one accused. Smaller box is a witness box. He steps in there. He stands alone, not with his other companions. He stands all alone.
So that's the difference, that's all.
That is it. No, but kindly see, this is incorrect. Accepting this, it is also submitted that he was ready to disclose the truth for the sake of justice. And if this court permits him to disclose the fact, he was ready and willing to divulge. On the filing of the impugned application, this court had requested the Lawyer at 17th Additional CMM Bangalore to get his statement recorded. Lawyer at 17th Additional CMM Bangalore, after following the statutory bound and after providing, the ತೋರಿಸ್ತಿದ್ next lawyer ಪಕ್ಕದಲ್ಲಿ ಕುರ್ಚಿ ಹಾಕೊಂಡು ಕೂತಿರೋದನ್ನ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ. But I am not building castles in here. I stand by that.
No, it's obvious. You need not even say. You will obviously be there because it is recorded at the stage of trial.
ಅಲ್ಲ ಇದಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್
ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಾಗ್ಲೂ ಅಲ್ಲಿ ಲಾಯರ್ ಇದ್ರು.
ಇದೇ ಲಾಯರ್. The lawyer who was representing this first accused during the trial of this case till the date of his application becomes the lawyer for him to make the application under section 306. And it is the very same lawyer who files the wakalatnama at a point of time when his statement under 164 came to be recorded by the magistrate. Signature ಹಾಕ್ಬಿಡ್ತಾರೆ ಅವರು. ಎನ್ರೋಲ್ಮೆಂಟ್ ನಂಬರು, ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಅವರು ಇರ್ತಾರೆ, ಕೂತ್ಕೊಂಡಿರ್ತಾರೆ. ತೋರಿಸ್ತೀನಿ, ಒಂದು 2 ನಿಮಿಷದಲ್ಲಿ ತೋರಿಸ್ಬಿಟ್ಟು. ಇದರಲ್ಲಿ get it. On the filing of the impugned application, the court had requested the Lawyer at 17th Additional CMM Bangalore to get his statement recorded. Lawyer at 17th Additional, after following the statutory, etc., he recorded it. Number one, he could not have recorded it at all. I mean, directed it at all. Number two, he has also not recorded as mandated under law his statement under 164. Number three, if everything is in order, he could not have placed reliance on the statement said to have been recorded under 164 for the purpose of granting pardon to the accused.
Now, whatever he has deposed under 164, if that was the part of the application under 306, there should not have been any problem.
No, even then 164 can't be done.
No, that's all right. ನಾನು ಕೇಳ್ತಿರೋದು.
Yes.
ಈಗ 164 ಅಲ್ಲಿ ಏನೇನು ಹೇಳಿದ್ದಾರೆ ಅದು 306 application ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ
that would have been the ground. That would have been the ground.
All right.
But now kindly go to what he says is at page 60 at the top. In response being filed, it has been specifically narrated in length by the learned SPP with respect to the fact that how the statement of accused number 1 Basaraj so was recorded under section 164(1) CRPC is relevant to be considered his application. In the said application, he has specifically submitted that the letter addressed by the etc., etc. Now let us go to the reasons, as my lord has said. Kindly go to, I shall skip the first 2 pages, 64 and 65. Kindly go to 66, para 12. Even a copy of the said statement was supplied to the IO, who had filed his additional response to this court, stating that the accused number 1 has disclosed true and real facts of the above case. Well, when the trial is in progress, the issue can't be only between the prosecution and the court. I am a party. Ultimately, I am the man who gets aggrieved. I am as much a party to the case during trial as the prosecution is. The trial court ought to have given me notice. Look here, so-and-so is before the court. What have you got to say? As could be deciphered from the statement and also from the response which was filed by the CBI, it could be noticed that the case of the prosecution is entirely based on circumstantial evidence. That is wholly incorrect. That is wholly incorrect. It rests on the statements of 8 eyewitnesses. It is also not in dispute that the case of the prosecution rests upon the statement of various witnesses, where it is alleged that the accused persons have joined together to hatch a Who has not disputed, Miller? It is also not in dispute. Means, did I agree at any point of time before the court that I had hatched a conspiracy? That is put for trial. I am charged of an offense under section 120B. It is also not in dispute means who? I am not a party to this order. I am not a party to the application. I am not a party to the statement of objections. Everything is done behind my back. And the learned judge would say, it is not in dispute to hatch a conspiracy for committing a murder of so-and-so on the fateful day. It is relevant to note at this juncture that the response which is filed by the CBI would indicate of various facets which are coming to picture during the course of investigation. For instance, I have called out the necessary materials which are forthcoming in the additional response, etc. Madam, I shall just invite my lord's attention to one word and then keep proceeding. The statement of accused number 1 discloses. Number 2,
ಅದೆಲ್ಲ ಕಲ್ಲಿಂಗ್ ಔಟ್ ಅಷ್ಟೇ
ಎಲ್ಲ 164 ಸ್ಟೇಟ್ಮೆಂಟ್
ಅಲ್ಲ. ಅಡಿಷನಲ್ ರೆಸ್ಪಾನ್ಸ್ ಆಫ್ ದ ಸಿಬಿಐ ಕಲ್ಔಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅದರ ಅದೇ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಸಿಬಿಐ ಇನ್ನೆಲ್ಲಿ ಬರುತ್ತೆ?
ಅಲ್ಲ
ಹೇಳೋದನ್ನ
ಅಡಿಷನಲ್ ಈ ಕಲ್ಔಟ್ ಮಾಡಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಆರ್ ಆಲ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್.
164 statements which are reproduced by the CBI in its additional statement of objections.
Because the court at page 72 goes to say that when the entire facts are once again carefully appreciated with the statement of accused number 1 recorded under 164 does indicate so and so.
My lord, ಇದರಲ್ಲಿ he was an accused, arrested, the notice of the crime came to be registered. ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದಿಲ್ಲ 164 ಇಲ್ಲ ಅವಾಗ. If at all there is any statement, the statement would be under section 27.
Correct.
That statement may not can't be adverted to or looked into for any other purpose other than for the purpose that is enumerated in section 27. ಅದರಲ್ಲಿ ಇದು ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಇವ್ರಿಗೆ?
No,
ಇವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದಾರಲ್ಲ,
entire order is based upon 164.
164 entire order.
Yes. ಅಲ್ಲ, because paragraph 14
Yes, madam.
para 14 ಅಲ್ಲಿ one paragraph,
ಹೌದು,
ಮಿಕ್ಕಿದೆಲ್ಲ that is extraction.
ಅಷ್ಟೇ.
Para 15 one paragraph, others is extraction. Para 16 again 16 and 17 all 164 statements.
164 statement. But now it would be useful for me to invite my lord's kind attention. First, he directs the recording of statement. Thereafter, he gives pardon. That is impermissible.
The procedure is grant pardon and record statement, but not under 164.
No, he has to record.
That is
in the form of
during the
evidence,
course
in
of
the
the
form
trial.
of evidence. No, may I just now, for 164, may I just invite my lord's kind attention to the proceeding sheet. I have the certified copy. ಏನಿದೆಲ್ಲನೂ CBI ಅಂದ್ರೆ ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು ಅಂತ. That is the notion. Anything and everything they can do and undo things. No. Most of the time, my lord, the lawyers who are practicing in the trial court have come across the IVO going and sitting in the chambers of the judge, the prosecutor going and sitting in the chambers of the judge, or the judge, the trial court judge, just sending a message to the prosecutor or to the IVO to come. Case called out 21/10/2024. Case called out before the open court on 21/10/2024 at 1 PM.
And his counsel are present before the open court.
ಅದಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಇನ್ನೂ ಸರಿ ತೋರಿಸ್ತೀನಿ. ಫಸ್ಟ್ ಇದನ್ನ ಓದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದನ್ನ ತೋರಿಸ್ತೀನಿ ಅದನ್ನ.
Nagendra Naik.
ಹೌದು.
Yes.
Accused number 1 by name Basavaraja Shivapambuthige and his counsel are Nagendra Naik, so on. I'm sorry, I read it. Counsel are present before the open court. The procedure before the recording of statement of the accused under section 164 CRPC is conducted since 1 PM and the procedure is separately recorded. Further, the statement of the accused number 1 under section 164(1) of the CRP is recorded since 1:07 PM to 3:25 PM in the presence of the counsel for the accused
Correct.
number 1.
There.
Is that the procedure which is required to follow? But now, my lord, may I request your lordship to kindly, your lordship has been repeatedly posing that question to me. What is the scope of section 164? Whether after the commencement of the inquiry or trial,
We'll see that.
whether either the trial court, which is the court of original jurisdiction, in this case a sessions court, or a magistrate, my lord, could direct or record the statement under section 164. Would you lordship? My lord gets it?
Yes.
Any metropolitan magistrate or judicial magistrate may, whether or not he has jurisdiction in the case, but in this case he has no jurisdiction, but whether or not he has jurisdiction or not, record any confession or statement made to him in the course of an investigation under this chapter. My lord, this is under chapter 12, if I am right, my lord.
Yes, investigation.
Under chapter 12. Chapter 12, my lord, commences from section 154.
Yes.
That is registration of the crime.
Crime.
Then 155 non-causable offense, 156 is the powers of investigation. Then my lord 169 and then 173, 172 and all that.
Yes.
During the course of investigation. or
Before
statement
the
made
commencement of
under this
inquiry
chapter,
or-
under this chapter, or under any other law, for the time being in force, or at any time afterwards before the commencement of the inquiry or trial. He lacks in jurisdiction. Law does not. When law could not and did not, the court could not have closed the jurisdiction upon the magistrate to record his statement. That is illegal. It is an illegal law. He could not have. If my lord were to eschew, while accepting my submissions, that the magistrate had no jurisdiction to have recorded the statement under 164, but when the learned trial judge has placed reliance only on the 164 statement, this order has got to go. This order will have no legs to stand at all.
Anybody?
Well, now kindly go to section 306 for a second.
ಅಲ್ಲೇನಿಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಅಲ್ಲಿದೆ.
164 ಪರ್ಮಿಷನ್.
ಅಲ್ಲ ಫಸ್ಟ್ ಪಾರ್ಡನ್ ಆಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅದು ಗೊತ್ತು.
ಇದರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ
ಅದು ಗೊತ್ತು.
ಆರ್ಡರ್ ಬೇಕಾದ್ರೆ ಓದ್ತೀನಿ ಅದನ್ನ. He says, go there, give your statement. I will verify whether what you have said or not.
That is why, see, the court has cautiously done it. It does not record the statement itself. Otherwise, it would have become trial during the course of trial. Before granting of pardon, that cannot be done. So record the statement, take that statement and continue the trial.
ಅದೇ ಆಯ್ತು, ಇವ್ರು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಬ ಹೋಗುತ್ತಂದ್ರಲ್ಲ, ಅವ್ರಿಗೆ ಏನು ಅಧಿಕಾರ ಇದೆ ಮಾಡೋದಕ್ಕೆ ಏನೋ ಪ್ರಶ್ನೆ ನೆಕ್ಸ್ಟ್ ಇಲ್ಲ. A plain reading of unless my lord were to interpret, my lord section 164, ultimately we have got to carry what my lord is going to pronounce in this case on our shoulders. Unless and until my lord interprets, no, despite the fact that the famous of law in their wisdom have said that it is only during investigation, at any rate, not subsequent to the commencement of inquiry trial, my lord, that becomes the law of the.
Now, grant with a view of obtaining evidence of any person supposed to have been directly.
Karnataka criminal rules of practice. Have a look at this.
Karnataka criminal rules of practice.
Yes, my lord, Karnataka criminal rules of practice. Chapter 5. Chapter 5, Rule 5. ಏನಿದೆ ಇದರಲ್ಲಿ?
ಅಲ್ಲ ಇಲ್ಲಿ ಸಿಗಲ್ಲ, ಕೊಡಿ ಅಲಿಸ್ಕೊಳ್ಳಿ.
Appearance is also
ಬುಕ್ ಇಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ವಾ?
ನಿಮ್ಮ ಹತ್ರ ಸಂದೇಶ್ ಚೌಟ ಸರ್ ಹತ್ರ ಇದೆಯಾ?
ಇಲ್ಲ ಏನಿಲ್ಲ.
ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್. ಚಾಪ್ಟರ್ Yes, sir.
Rule 5, my lord. Chapter 5. When an accused person is produced before a magistrate.
Recording confession statement.
The magistrate should explain to him that he is before the magistrate.
Recording confession statement.
ಹೌದು. ಅವನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಇವ್ರು. Is produced before a magistrate for recording a confession statement. He can't be directed, you go and do it ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ಅಲ್ಲ, even otherwise, my lord, this is of no consequence.
Yes.
But now 306, have a look at section 306 for a second. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense to which this section applies, the chief judicial magistrate or metropolitan magistrate at any stage of the investigation or inquiry into or the trial of the offence, and the magistrate of the first class inquiring into or trying the offence at any stage of the inquiry or trial may tender pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as principal or abettor in the.
But the only worry is subsection 4 of section 306.
Yes. Every person accepting, every person accepting a tender of pardon made under subsection 1 shall be examined as a witness in the court.
Court of magistrate and then.
Taking cognizance of the offence.
And then in the trial.
Then, idರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ he is the magistrate because it is a court of original jurisdiction.
Yes, that for original
Therefore, my lord, that means he can do it. You shall be examined as a witness in the court of the magistrate taking cognizance of the offence
Every person,
and in the subsequent trial.
every person accepting a tender of pardon in the sense the order of pardon ಆದ್ಮೇಲೆ.
ಫಸ್ಟ್ ಪಾರ್ಡನ್ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅದನ್ನ ಬೇಕಾದ್ರೆ ಒಂದ್ಸರಿ ಒಂದು
ತೊಂದ್ರೆ
ಇಟ್ ಇಸ್ ದೇರ್.
ಅದು ಗೊತ್ತಾಗಿದೆ.
Yes.
164 ಆದ್ಮೇಲೆ pardon.
ಏನ್ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ
No, ಇಲ್ಲಿ the drill went like this. Application is filed. On that application, he is referred to the magistrate for recording of 164 statement. 164 statement is recorded and the same is placed before the court of session as a special court here. Special court records all that is there in the additional objections or the 164 statement, and based on that, the court finds that there is ample material to demonstrate that he is going to depose in favor of the prosecution, so I grant pardon. That's the drill that is followed.
Lord, I have any number of judgments on this point. If my lord is persuaded to accept my submission,
One-
the facts of the case.
One the other judgment.
Yes, ma'am. My lord's judgment itself is there. First pardon ಆಗ್ಬೇಕು.
Mine.
That ಮಲ್ಲಿಕಾರ್ಜುನ ಶಿಪ್ಪಿಂಗ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕೇಸ್ ನಲ್ಲಿ ಏನಿದೆ ಅವ್ರದ್ದು ಇದು ಈ ಜಡ್ಮೆಂಟ್ ಮೇಲೆ ಅವರು ದೇ ಆರ್ ಪ್ಲೇಸಿಂಗ್ ರಿಲಯನ್ಸ್, ನಾನು ಇದ್ರ ಮೇಲೆ ಐ ಆಮ್ ಆಲ್ಸೋ ಪ್ಲೇಸಿಂಗ್ ರಿಲಯನ್ಸ್. Can you go to page 8 of the judgment? First pardon ಆಗ್ಬೇಕು ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. Only for that limited purpose I am drawing my lord's attention. Internal page 9, my lord. Kindly go to page 8, internal page 8 of the order. First paragraph, last two sentences. I deem it appropriate to notice the said provision, section
Yes.
306 of the CRPC reads as under. My lord would quote section 306 and thereafter
Yes.
page 9, last two sentences. Section 306 mandates concerned court to accept an application filed seeking tender of pardon to any accomplice in the crime, subject to the condition that once pardoned, he should make a full and true disclosure of the whole of the circumstances within his knowledge to the court concerning the issue.
Illi CBI had no objection. The co-accused had challenged it.
First pardon ಆಗ್ಬೇಕು. That is what the statute would say. Then he becomes a witness. But till such time he is
But
given
anyway, 164 is impermissible.
impermission.
That's all. That let in your either. You want to say something?
ಆಮೇಲೆ ಇನ್ನೂ ಒಂದೇನು ಅಂತಂದ್ರೆ ಸೆಕೆಂಡ್ ಅಪ್ಲಿಕೇಶನ್ my lord, what the Supreme Court has
Change circumstance.
change ಬೇಕು.
That-
I don't think I should.
ಅದು ಕೊಟ್ಬಿಡಿ. As far as I have heard, that is the circumstance. It's like bail.
Just like bail. Just otherwise, my lord, what happens is he keeps making application after application till the trial is concluded.
It
Trial gets concluded, no sooner the judgment is
it is
pronounced.
akin to making an application bail and change.
This is in
circumstance.
1973. 1973. A learned, 3 judges bench, a larger bench judgment, my lord, a full bench judgment. Kindly go to paragraph 15. This is what the Supreme Court would say. Well, at the middle of this paragraph, the mere fact that a magistrate of the first class inquiring into the offence has declined to grant pardon, as in the case before us, does not take away the power of or jurisdiction of the district magistrate. My lord, he becomes the appellate authority in this case. During those days, my lord, under the old code, district magistrate was the appellate authority. District magistrate to entertain a further application for grant of pardon. Though the district magistrate has got power to consider a further application, nevertheless, it is needless to state that he will have due regard to the views expressed by the magistrate for refusing to grant
No,
the
there
pardon.
district court had refused pardon.
Yes.
The subordinate court accepts pardon without any change circumstance.
We
So
must,
the-
however, state that judicial propriety requires that if a higher authority had declined to tender pardon, a lower authority should not grant pardon except on fresh facts which were not and could not have before the higher authority when it declined to grant the pardon. Even if the pardon has been refused on one occasion, a further request may be made. This is what my lord wanted to know from me. A further request may be made before the magistrate or the district magistrate, but such further request can be entertained and considered only if fresh or additional facts are placed by the party concerned. ಆಮೇಲೆ ಇಲ್ಲಿ second application, my lord, their lordships to the Supreme Court while dealing with petitions which came to be entertained by the High Courts under section 482. But on the day when I made the first application invoking the jurisdiction of the High Court under section 482, I had more than one ground that was available to me on the very day itself. But I am before the High Court under section 482, only urging one ground. The rest of the grounds, my lord, I don't urge. My petition got dismissed. But again, I would make an application invoking the second ground that was available. If that ground was also available on the first day when I made the first petition, second petition is not maintainable. But they would dismiss
Second
it.
petition is maintainable only on changed circumstances.
In this case,
You cannot, you see, what the Supreme Court says in that is, you cannot urge grounds in piecemeal. You should come out whole hog. Yes.
my lord, in identical, this court,
I guess that is the word that is used.
my lord, this court, my lord, this one, my lord, is in 2023.
Yes, sir. This is a piecemeal judgment. is it?
Yes, ma'am. But this court while dealing with an application filed under section 311.
Para 11, same. Yes.
Well, this court in another petition, while dealing with an application filed under section 311 seeking recall of the witnesses who were examined and discharged. Well, a second application came to be filed on the same ground. But in paragraph 4, the learned judge of this honorable court would say, learned trial judge on consideration of the material on record has recorded a finding that the petitioner had filed an identical application on an earlier occasion and the same was rejected and so on and so. Without challenging the said order, the petitioner has filed this same application again. Learned trial judge has also recorded that one of the grounds urged in the application is that the previous advocate was not aware of the documents which were in possession of the petitioner. He has recorded that the petitioner had filed an identical application on an earlier point of time and the same was rejected and that the said order has attained finality. It is not in dispute that a similar application was filed earlier and the same stood rejected. The said order which attained finality was not challenged. Therefore, it came to be dismissed.
Yes, Sandesh, sir. Yeah,
But
ನೀವು
the other day,
Sir.
the learned special public prosecutor raised an objection with regard to the maintainability of our petition.
Why?
Locus.
Locus.
They were on
He
the
has
aspect
raised
of
the
locus.
objection.
Co-accused cannot challenge it, is what they were trying to point out.
Have I said so in the other petition?
No, no, my lords. They're relying on one of the Supreme Court rulings where, my lords, they pointed out locus so far as co-accused, but immediately the next line says court has suo motu powers.
Your lordship noted that
So
also.
revisional powers and inherent
motu.
powers court has. We are the ones who are bringing it to the notice of the court. My lords.
Well, no one has a right of revision under section 397. The court may, did not shall.
My lords, I'll keep it very brief.
And
Extensive,
inherent
it's been
power.
argued. My lords, first of all.
I only want that point.
First of all, my lords, this entire application which is filed under a wrong provision. In a committal, my lords, an application doesn't lie under 306, but under 307. My lords would notice 307. Once there's a committal done, 306.
It is only under 307.
Only under 307. For 307, my lords, only clause of 306 which applies is clause 1. That's all is the equivalence to it. So, my lords, the very first aspect is, my lords, this 306 application on its own could not have been maintainable unless read with 307. That should have been the first. In my respectful submission, my lords, there are 4 points for consideration, my lords. One is, can a successive application under 306 or 307 be filed without showing any change in circumstance? Very, my lords, like how bails are. Second, my lords, whether a co-accused has locus to challenge an order passed under 306. Second aspect, my lords. Third is, at the time of considering this application, can the court direct a 164 statement to be recorded very extensively. It's been pointed out, my lords. It comes under a different chapter altogether and at the stage of investigation. And last is, my lords, will there be a doctrine of res judicata, constructive res judicata, then, my lords, issue-based estoppel? Because once a finding has been given on an issue, my lords, can it be re-agitated through another application? These are the four aspects. Now, while considering these four aspects, the present interim order, my lords, lack of application of mind,
Interim
this
order?
order, 306 order,
306.
306 order, my lords. Four aspects are very glaring, my lords. Lack of application of mind when we say, my lords. Wrong provision mentioned, not considered. It's all right, my lords. That's one aspect of it. Second, referring the accused under 164.
Or 1 second.
Second is, my lords, referring under 164. Absolutely could not have been done. Third, my lords, no reasoning as to why the previous order required a revisit. An order which had attained finality, why did it require a revisit? Merely because there is a change in a presiding officer cannot be a reason, my lords. Fourth
No,
aspect
there
of it, no condition.
There is no revisitation. It's a fresh application.
No change in
Whether
circumstance.
that we'll consider.
Because unless, my lords, the court felt at that point of time, probably the court was right in not having accepted that application. But now, for these change reasons, I'm accepting it, something else, my lords. And fourth, my lords, no condition that has been imposed after you grant pardon. Most important is that, my lords, under 306, first you grant a pardon, then you have to impose a condition. The condition we find under 306(1) itself. You have to depose.
Yes.
That condition has to be there. Now, from the impugned order, my lord.
No, it's only allowed.
Allowed, no condition imposed. These are the four aspects on lack of application of mind. The judgments, my lords, today I've culled out, my lords, so it becomes easy.
Paragraph number ಬರ್ದಿದ್ದೀರಾ?
Paragraphs I've culled out, right? So kindly notice,
Makes
my
our
lords.
job easy ಅಂತ ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ.
My lords, the first aspect there in the first page regarding a second 306 application not being entertainable without there being change in
Senior referred to
circumstance.
Kailashnath Agarwal.
Yes, my lords. And next, on the next page, regarding the locus of co-accused challenging an order, the very same judgment, 1973, paragraph 8 and 23.
Yes.
Then, my lords,
I have no doubt over it. So don't
and
worry.
there again, the CPI versus Ashok Kumar Agarwal, which they were relying on, that speaks about, my lords, suo motu powers that the court has.
Yes.
Then, my lords, the third aspect in page 3, concept of res judicata, its applicability to criminal cases. These are the judgments that deal with it, my lords. It is applicable even in criminal cases, though it's a concept in civil law, my lords. It is applicable here. I've put in two judgments there, my lords. And at page 4, regarding the need to have a material change in facts or law prior to maintaining a second application, 2005 2 SCC, page 42. Though in the context of bail, my lords, at paragraph 19, this is what they say, my lords. Paragraph 19.
Yes.
Then, my lords, on page 5, doctrine of issue estoppel. If an issue has been decided, then, my lords, that's the one. And 6, doctrine of constructive res judicata. I have culled out one judgment, my lords, at page 5.
Yes.
Then page 6, my lords, the procedure contemplated for grant of pardon is to treat the accused as an approver and then record his evidence. My lords, you get that at page, and I've relied on 1994 supplementary to SCC 73. They very clearly say, my lords, it's only after grant of pardon that
No,
the status of
Provision
an
itself speaks.
and that's how they have culled that out, my lords. Status of an accused is changed into that of a witness, and the law enjoins upon the court to record the statement of the approval. Then, my lords, page 7, there is no procedure permitting of a statement under 164 of CRPC to be recorded prior to grant of pardon, either under section 306 or 307. My lords, one decision which we have put there, my lords. Then 9, my lords, the title of the petition is irrelevant. My lords, Asian resurfacing, when they say. So, my lords, these are the judgments that I've culled out the relevant portions of it, my lords. However we look at it, this entire order will have to go.
Ready, sir? Anything?
The first application, not the your lordship will find,
The reason, my lord, for rejection of the first application. No, sir, page 144, para 19.
Yes. Para 19.
Para 19, my lord, after about 4 lines from the top. This court is not aware as to how much information is known to the present accused regarding the commission of the alleged offense and whether he participated in the larger conspiracy to commit the murder of so and so. But it was not made known, not to the learned special judge, as to under what circumstances
Correct.
it was done. Now, my lord, kindly have a look at
Not made known where? In the application.
in the application, or not otherwise also.
All right.
Or otherwise.
Otherwise,
Now,
ಹೆಂಗೆ made known?
now, my lord, kindly have a look at the.
Phone ಮಾಡಿ ಹೇಳ್ಬೇಕಾರೆ.
Kindly have a look at not the page 98. The report, my lord, filed by the investigating officer to the second application.
90?
98, my lord, the typed copy which your lordship not was pleased to.
Yes, that's
see.
it. No, this is the second application for pardon.
Second application for pardon.
98 is your objection.
Not this is, not we have stated as IO report bar objection.
That's what.
But this IO report, kindly have a look at not page 99.
Yes.
Not the fourth line from the top. I am also enclosing a letter of the petitioner addressed in the instant case.
That is page 100.
This is not page 100.
This was available then also.
No, this was not available then. This was
What
not
is
available
the
then.
date of this letter?
But this was may not hand over may not to the IO.
No, what is the date of this letter? It is undated. It is undated.
Oh, this was not available earlier. No, this was
What is the date, sir?
date either illa. Not I can
It is
find out on
undated.
what date. Not it was this was hand over not to the IO.
True, sir, but what is the date of this?
Not
Only to
date.
say that this was available to the previous application also. Now, if
was
it is
not.
not, if it is not, then what is the date of this?
No, that I can not find out the date. Not and this was not available. This letter was not available because there's absolutely no reference not to this letter. Not even in my earlier report of the IO or not the objections not by the prosecution or in the order. There's absolutely no reference not to this
All right.
letter. But
Fine.
this letter, the accused number one not to disclose, not completely, not what the facts not within his knowledge. Or if for any reason, but this honorable court were to come to conclusion.
One simple question. If the accused had already penned this down and submitted to the investigating officer,
Please.
what was the impediment to pen everything in the application by the same person?
Not 306 doesn't say that everything
No,
must be stated.
Not
in the
everything,
application.
Allah. What are the he has to say, these are the things that I
Kindly
have
look
to,
at- no,
I
kindly have
am
look at.
wanting to depose in favor of the prosecutor.
Kindly have a look at not page 92 is application.
ಅಲ್ಲ ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಬಿಡಿ.
ಅದರಲ್ಲಿ not para 2. The applicant is facing threat for his life from various corner, including
ಆಯ್ತು.
accused number 15 and 16. In this case, then,
ಇದ್ರ
kindly
ಮೇಲೆ
have a look at
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
next page.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್,
Please, madam.
ಇದ್ರ ಮೇಲೆ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. 164 ಯಾಕೆ?
Not,
ಇದ್ರ ಮೇಲೆ ಮಾಡ್ಬೋದಿತ್ತು ಬೇಕು ಅಂದಿತ್ತು.
I mean, that's what not my submission to my lord is. Not the statement not made it paragraph number 3 and 4. Not in my humble submission are more than sufficient. Not for the learned may not the special just to consider this application.
Where was the necessity for 164 recording after the
Not of course,
commencement
not
of the
the
trial?
heading of section 164 says not it could not have been
Statute,
recorded
sir.
after. That's what not. I'm not. I have
Up to
read.
the trial.
I have read. Not. I have read 64. Not if not for any reason. Not the learned special judge Milord was not right in considering or may not directing recording of 164 statement and considering it. Not the material not at page 100 not is well within his knowledge.
You should have passed an order on this. The entire order refers to only 164 statement.
But entire order refers to the statement made by the prosecution.
What
But it is
statement?
they who is saying that my statement is based on the
No,
not
which
164
statement?
statement.
Sir,
Kindly have a look
come
at.
to the
not-
impugned order, sir.
not the- Exactly.
Come
Your
to the
Lordship, kindly have a
reasons.
look at.
Reasons would commence at page 63.
Not your Lordship, not page 67 not is the
All right. 67.
67.
ಈ
not-
statements ಯಾರ್ದಿದು?
Not for instance, I have culled out the necessary, not your Lordship will find.
Statements which are forthcoming in the additional
Additional
response which has
response which have been
been
filed by the CBI authority which are as follows.
It's all right. That
But
is your
now-
additional response.
This is my additional response.
Where did you get that additional
Not
response?
in the letter, not at page 100. But your Lordship may not kindly have a look at, the details may not found at page 100.
That is not a part of your objection also, but it is
This,
a
no,
letter.
this is
That's all
part,
right.
not, your lordship may kindly see,
All
on
right.
page 99, this is part of my statement, my lord.
That's.
I am
that's all.
also enclosing a letter of the petitioner addressed to the instant case.
Sorry, Prasanna, for a second, kindly pardon me. I'm
Like this, sir.
interrupting you. Kindly go to
My
page
elect-
109. This is the additional response. Page 109.
Yes, sir.
109 confession statement under 164.
Alala. Response of CBI and the application filed by the accused Baswaraj Muttagi.
Additional rest, 105.
109.
109 is statement 164.
105.
105 to 108.
Okay.
105 to 108.
105.
Yes, 105.
I'm sorry, 105.
It looks like 9.
Yes, I'm sorry.
Yes.
ಎಲ್ಲಿದೆ?
No, additional response they see ಅವರು ಮಾಡಿರೋದೇನು ಅಂದ್ರೆ the said statement recorded on 164 so and so has disclosed the following crucial facts. They also rely on 164.
Not but the fact remains.
1 minute sir. ಈಗ ಅಲ್ಟಿಮೇಟ್ಲಿ ನೀವು ಏನ್ ಕಲ್ಔಟ್ ಮಾಡಿದೀರಾ ಅದು 164.
ಅಷ್ಟೇ.
ಕೋರ್ಟ್ ಏನ್ ಕಲ್ಔಟ್ ಮಾಡಿದ್ದಾರೆ ಅದು 164. ಕೋರ್ಟ್ ಏನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಅದು 164. 164 is impermissible.
But otherwise, not even otherwise.
ಅಲ್ಲ, even she could have passed the order on that.
Not my submission to lordship is not the application, the amendments made. The application at page 92 not clearly indicates the reason may not for him not to file the application under section 306. Coupled with the application, not the prosecution.
ಅದು ಏನಾದ್ರು ಮಾಡ್ಲಿ 164 ಕಳಿಸೋದು ಯಾಕೆ ಬೇಕಾಗಿತ್ತು? 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅದನ್ನೇ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಆರ್ಡರ್ ಮಾಡಿ ಅದನ್ನೇ ಅಪ್ರೂವ್ ಟರ್ನಿಂಗ್ ಇಮ್ ಅಪ್ರೂವರ್ ಅಂಡರ್ 164. Where is the
Not even if not the.
Is it not going acting completely contrary to 164?
Not even if not the.
Because 164 is a confession statement of a witness. Generally the complainant or witness, whatever it is. Confession statement of a witness, it stops at the stage of commencement of the trial. Over. Amale evidence. 160, wow, putting the clock back to confession statement.
No, my submission is not the IO report or may not the statement may not made by the IO. The response of the IO to the second application, not also is not accompanied by the letter of not the accused number 1.
Right, but why 164?
Not there is not in my humble submission. There is
No, you
absolutely
cannot say there is no bar.
there is no
specific
difference.
bar.
I understand.
Yes.
There is no difference between the statement made by accused number 1 on page number 100 with not in comparison with the statement made under section 164.
ಎಲ್ಲ ಸರಿ ಇರ್ಬೋದು ಯಾಕೆ?
There is no difference.
Maybe, sir.
Not whatever was within his knowledge, not he has stated.
It is on the face of it aberration of the statute. How can you come total?
Now, what has to be seen at the stage of 306 is.
At the stage of 306, now 306 is completely based on 164 statement. That cannot.
No, my submission is not the application is not supported by the statement of accused. Not at page 100.
ಭಯ ಯಾಕೆ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಬರೆಯಕ್ಕೆ 164 ತಗೊಂಡ್ಬಿಟ್ರು ತಾವು ಮಾಡ್ಬೇಡ.
Not my submission is even if may not your lordship may not want to compare the statement under 164 and may not the statement of the very accused not page 100 is one and the same. There is absolutely may not no difference. But all that the London magistrate or special judge will have to do not is satisfy himself that he is going to state all the facts within his knowledge concerning himself and the other accused persons. Not that is the only scope so far as not 306 is concerned. But with the material available on record, not with the my not objection as well as not the statement of the accused. But in my humble submission, what was more than sufficient not to consider the application.
More than sufficient. Why is this?
Not for any reason. Not if one portion of the order not is bad, that doesn't mean not in my humble submission.
No.
The whole order must go. If one of the finding not given by the learned special judge is based on inadmissible material, not that should not be not a reason.
No. See, in a process, for example, in a process of selection, you can't wash out the entire selection. You can weed out the illegality. In an order passed by a court, there is no question of weeding out the illegality there. It stays or it goes. That's unless it is justified.
Not my submission is not this the statement of accused number 1 is very much on record. There is absolutely no difference from his statement at page 100 and my lord once
But
section
will it
164
not
statement.
be directly contrary to 164?
Not even if he eschew not that part of the statement not of accused number 1 under 164, it is same not as his statement at second not page 100.
But let's see, the court should have passed the order on that. Let's see. We'll consider.
This is not on, not may not also bring to your lordship.
ಯಾವ್ದಾದ್ರು ಜಡ್ಮೆಂಟ್ ಇದೆಯಾ 164 ಟ್ರಯಲ್ ಆದ್ಮೇಲೆ ಮಾಡ್ಬೋದು ಅಂತ?
Trial ಆದ್ಮೇಲೆ ಟ್ರಯಲ್ ವರ್ಗೂ ಅಂತಿದೆ. Not may not bring to your
That's
lordship.
what,
kind
my lord, I
notice.
submitted unless and until my lord rules like that, which becomes the law. The statute prevails.
But on not the maintainability of this petition at the instance of
Maintainability at the instance of the
the
co-accused.
co-accused, not I had brought to your lordship's kind notice. Not 2013 part 15 SCC page 322. Not
ಅಶೋಕ್ ಕುಮಾರ್ ಅಗರ್ವಾಲ್.
ಅದರ ಜೊತೆಗೆ not how that is how this is interpreted not by this honorable court, that also not I will bring to your lordship.
ಕೊಡಿ. ಯಾವ್ದು ಸೇಲ್ ಅಲ್ಲ?
ಅದಲ್ಲ ಇನ್ನೊಂದಿದೆ. This Ashok Kumar Agarwal not on the other day I read to your lordships, not para 40. ಕೊಟ್ಟಿದ್ದೀವಿ.
This is what I have considered in that.
Please, no,
Mallikarjun
this has been,
shipping.
no, your lordship not did not consider the maintainability.
Maintainability.
Maintainability. No,
I
this-
did not go into that.
This
aspect.
judgment not has been further.
Because
may not
there you
consider-
accepted that.
Please, no, this judgment has been further considered may not by this honorable court,
Kudi.
other coordinate bench.
Coordinate bench holds that it is not maintainable.
But it says you will have no right of audience. Not paragraph number 4. Is what may not the effects of the this honorable court would quote the judgment of Ashok Kumar Agarwal. Then not your lordship may kindly come to page 4 para 5. You are accepting the above such observation made by the apex court. The co-accused gets absolutely no right of audience before the court. The court can at most treat the petition filed by the petitioner without right of audience as so motor revision in order to examine the procedural irregularity or regularity, if any, committed by the court while granting. This is not the other
So
one.
some leeway is there for revisional jurisdiction. This
Revisional
is
jurisdiction.
inherent jurisdiction.
Inherent jurisdiction. You will have not absolutely no right of
Hmm.
audience, not on the judgment cited, but in Kailash Nath Agarwal's case,
Hmm.
not paragraph number 15.
Hmm.
Not your lordship not was pleased to not observe.
Hmm.
I'll not find
Yes,
fresh application. Only fresh or additional. Paragraph number 15, not
Yes,
last
sir.
4 lines.
But why have you dragged the proceedings so much? Look at the order sheet.
Like maybe 1 or 2 days, not I.
1 or 2 days allowed.
Yes, throughout.
Why is this?
Throughout, I will
ಈಗ-
show you.
No, when you were wanting to say that they are.
No,
when
my learned senior
dragging the
friend.
proceedings.
not-
That's all right.
No, one ನಿಮಿಷ ಇರಿ, one ನಿಮಿಷ.
My lord has not stayed the trial. My lord only has said that he should not be examined. The rest of the witness court ಬಂದ್ರು ಮಾಡ್ತಾ ಇಲ್ಲ ಅವ್ರನ್ನ ಆಚೆ ಕಳಿಸ್ಬಿಡೋದು ಹೊಟ್ಟೋಗು ಅಂತ ಅದನ್ನೇ ಬರ್ದಿರೋದು ಜಡ್ಜ್.
ಇವರು ಇದನ್ನ ಹೇಳ್ತಾರೆ. Not when I ask, not ask the.
ನಾನು ಹೇಳೋದಲ್ಲ
Upper
order
part.
sheet ಹೇಳ್ತಾ ಇದೆ.
He says, accused themselves may not bring these witnesses.
That's all right, but court records against you.
That may not, that may not of finding, means 1 or 2 hearing dates, but may not
Throughout.
throughout illa sir.
That is what the learned judge has written. Throughout it is happening like that.
It's
The head of the Bureau of
matter of record.
Take immediate note of it.
No, that was.
Hello, why, when there is a direction to conclude the trial, why are you dragging it?
No, I am not dragging it. Not the issue is, witnesses, not accused may not bring the witnesses to the court.
Why you don't have the capacity to bring the witness?
Like the capacity, I'm not this.
ಮತ್ತೆ accused ಕರ್ಕೊಂಬರ್ಬೇಕಾ witness ನ?
Provide security to the approver. Why should you not provide security to the witnesses and bring them?
ಅಂಡ್ ಇದು ಟ್ರಯಲ್ ಅಲ್ಲಿ ಹೆಂಗಾಗುತ್ತೆ ಅಂದ್ರೆ ಇವತ್ತು ಫಿಕ್ಸ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ, ವಿಟ್ನೆಸ್ ಬಂದಿರಲ್ಲ, ಕೋರ್ಟ್ ಗಲಾಟೆ ಮಾಡ್ತಿದ್ದೆ, ಯಾರೋ ಒಬ್ರನ್ನ ಕರ್ಕೊಂಡು ವಿಟ್ನೆಸ್
ಅಷ್ಟೇ.
ಅವತ್ತು. ಅದಕ್ಕೆ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್
ಅಲ್ಲ
150 ವಿಟ್ನೆಸ್ ನಂಬರ್ 153 ಇಸ್ ಎಕ್ಸಾಮಿನ್ಡ್ ಎಲ್ಲಾರ ಮುಂಚೆ.
ಹಳೆ ಕಾಲದಲ್ಲಿ ಇನ್ ಗುಡ್ ಹ್ಯೂಮರ್
ಇಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಹತ್ರ ದೆನ್ ವಿ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಎಲ್ ಅನ್ಬಿಟ್ಟು ಯಾವ್ದೋ ಒಂದು ವಿಟ್ನೆಸ್ ಬಂದಿದ್ದೀರಾ.
ಅಲ್ಲ ಹಳೆ
This is what
ಕಾಲದಲ್ಲಿ
happened.
ಹಳೆ ಕಾಲದಲ್ಲಿ ಸೆಷನ್ ಜಡ್ಜಸ್ ಇನ್ ಗುಡ್ ಹ್ಯೂಮರ್ ವಾಟ್ ದೇ ಯೂಸ್ ಟು ಡೂ ಅಡ್ಜರ್ ಮಾಡಿ ಬೇಜಾರಿಗೆ ಹೋಗ್ತಾ ಇತ್ತು. ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಇವತ್ತು ಯಾರಾದ್ರು ಬಂದಿದ್ದಾರೆ ಯಾರು ಬಂದ ನೀವೇ ಹತ್ಬಿಡ್ರಿ ಏನೋ ಮುಗಿಸ್ಬೋಣ.
Not one more may not about this petition. Not all the senior friends may not argue. The order is against me. I was not heard. I'm a party to the proceedings.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದನ್ನು ಮಾಡುವಾಗ by the trial, by the London special judge, while considering the application not of section 306. Now, in this petition, they have not arrayed, my lord, the person in whose favor the order is passed.
ಅವನ್ ಯಾಕೆ ಮಾಡ್ಬೇಕು? ಅದ್ರ ವಿಟ್ನೆಸ್ ಪಾರ್ಟಿ
They
ಮಾಡ್ಬೇಕು
are on
ಅಂತ.
procedure.
But he is an accused.
No, there is an order in his favor, not rightly or wrongly. But I can say
That
different
is
number
what
of
is
judgments on the
question.
point.
Allala,
Rightly or
you-
wrongly,
you-
there is an order.
This is argument versus argument you can make, but yes,
Please.
yes, heard, deserved. Heard the, ಎಲ್ಲ
ಅಲ್ಲ, entry order may kindly be extended.
entry orders, in the light of the matter being heard and reserved, the entry order subsisting shall continue till the pronouncement of the judgment.
Please.
ಅದ್ರಲ್ಲಿ ಟ್ರಯಲ್ ಏನು ಸ್ಟೇ ಆಗಿಲ್ಲ.
ಇವ್ರದ್ದು ಮಾತ್ರ.
Not stay.
I have not stayed the trial.
My learned friend is, no, trial is being protracted. Who is protracting?
No, I guess I have not granted.
No, your lordship has
I have
already
not,
said, defer the recording of evidence of this approval ಅಷ್ಟೇ.
Defer the recording of evidence of accused number who is turned
Yeah.
approach. Trial will.
Trial is not stayed. Deeply right.
Yes,
Sorry, my lord, we have taken your lordship.
but that's all right, sir, yes.
Grateful.
ಅದಕ್ಕೆ ಇವತ್ತೆಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದು. You can take your time on.
But this is an interesting point of law.
ಅಲ್ಲ, all four matters is same,
Same order challenged by different accused.
same, all four reserved, all four reserved.
Please.
Got some interesting point of law. I wanted more time. That's
Yes, no problem, sir, no problem. Huh? Same, ಅದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡು. Yes. Next day.
Madam, 191.
This person has